Jennifer. Hello, good morning.
Good morning.
Good morning.
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 And David, you're here.
Yeah, this is my last day without kids on a Wednesday, so
Oh, really?
I'll have to hop in and out due to staff meetings that I have periodically during the day. And
Oh,
then
yeah, sure.
mercifully, I'll be done at 3 o'clock.
Sure.
And I get to watch everything on YouTube, everything that's later tonight.
Well, after we finished yesterday, I had the pleasure of attending a 3-hour school board meeting
There you go.
until my computer quit. The meeting didn't stop, but my
Yeah.
computer did.
My school is now full-time, which is great. It's good for the kids.
Well, that's the issue that's tearing this place apart, is whether to
Yeah.
go full-time or not.
Well, the hybrid where I get them 1 day per week is not, it's not good. It's a bad feeling sending these kids to the high school. I'm 8th grade history.
Yes,
and,
yes.
1 day a week cuts my content by 2/3 and
Yeah.
frustrating for them. These kids really want to learn, but they've been a year and a month on a 2-day rotation. They only come 2 days a week, 5 days off. That's sinking in. The retirement is feeling good for a lot of these young guns. So I'm going to go full bore, and I hope that, and I've warned them, you're going to get a big dose of a lot of material, and get your sleep and get ready because it's coming fast.
Yeah, I bet they'll be glad to hear that, or at least anxious for that kind of a change.
Yeah, I mean, we have, I have
Looks like
8
we
weeks.
have a quorum.
Okay.
Looks like we might have a quorum.
Yep.
And we are live streaming. So let's begin. Good morning, everyone. This is the meeting of the Joint Standing Committee on the Judiciary. And today we start our day with a series of public hearings. This afternoon, we'll do quite a significant number of work sessions on bills that we've already done hearings on. And this morning, with regard to the public hearings, it is our opportunity as a committee to hear from bill sponsors and members of the public who wish to weigh in on the legislation and ask them questions. And then this afternoon, when we do our work sessions, that's really our time to confer with each other and vote out the bills. And so with that, we'll begin to take up our first bill. Oh, and I also did want to note that we're meeting in the electronic format. We will bring members of the public who have signed up to testify on bills in from the attendee space to the panel of our meeting when it's their turn to present, and then move them back to the attendee status after they present. And we do have an active chat function, but we don't use the chat for anything substantive. It's not substantive. It's not part of the hearing. Please just use it for technological issues. And with that, we will begin our first bill hearing today, which is LD 902, an act to enact the Uniform Registration of Canadian Money Judgment Acts. And I'm just seeing a note. Give me a minute.
Introductions.
Yes. Excuse me. I was looking at the chat. And so we'll begin with the introduction of LD 902, and our colleague, Representative Steve Moriarty, is introducing this bill. And Steve, you can proceed when you're ready.
Thank you, Madam Chair. Good morning, Chair Carney and Chair Harnett and my fellow colleagues on Judiciary. As you know from our multiple meetings, I'm Steve Moriarty, representing House District 45, which is my hometown of Cumberland and part of the neighboring town of Gray. Some time ago, I think it was actually December, I was contacted by Maine attorney Paul Chaikin and was asked to introduce several bills on behalf of the Maine Uniform Law Commission, and agreed to do so. We have 2 of, I think, 4 total before us this morning, and they are very closely linked, which is why I believe we've decided to combine the hearings into one. I'm going to be followed by a series of speakers who are much more familiar with the substance of the bills and the function and operation of the Maine Uniform Law Commission than I am. And I would suggest that questions be reserved for those who will follow me. Two bills. One involves the uniform registration of Canadian money judgments. The other similarly involves the uniform registration of foreign country money judgments. Madam Chair, should I mention the next speaker, or would that be properly your function?
No, I can definitely introduce the next speaker, and thank you for reminding me and the committee that we're actually taking these two bills, 901 and 903 together.
Yes.
And so with that, I see that we have Ann Robinson from the Uniform Laws Committee present, and she's joined the panel. And Ms. Robinson, you may proceed with regard to LD 902 and 903 when you're ready.
Thank you, Senator Carney, Representative Harnett, members of the committee. My name is Ann Robinson. I'm pleased to be here today on behalf of the Uniform Law Commission. Senator Carney, I don't know if I missed anything. There's that 15-second or so lapse when one is promoted to a speaker. And so I don't know if this was stated or not, but it was my intent, with the indulgence of the chairs and the committee, to provide simply a brief overview of the ULC, particularly for the new members who are not familiar with the process of the ULC, and others who will be following me will be speaking to the substance of the legislation. But if that's not consistent with what you had planned today and your time commitments, I certainly understand, and will just defer to those who follow me.
I think that that's very appropriate. And for how long were you intending to present generally about the Uniform Laws Committee?
I'm hoping that this statement is about 3 minutes.
That is wonderful. Why don't you go ahead, and then we'll probably ask you some questions afterwards. Thank you.
Thank you. So again, Ann Robinson, I'm a resident of Portland. I'm a lawyer with Pierce Atwood, and I'm here today in my capacity as one of Maine's 3 appointed commissioners to the Uniform Law Commission, and appreciate the opportunity to speak with you. As I mentioned, I'm one of 3 members, and I'm privileged to serve both with Paul Chaikin, whom you heard reference to, the senior member of our delegation, with a distinguished career as a practicing lawyer in Bangor and later as special counsel to the Maine Board of Bar Overseers, and with the Honorable Donald Alexander, an eminent Maine jurist and recently retired Associate Justice of the Maine Supreme Judicial Court, who was appointed by Governor Mills this past fall. And I will note that Justice Alexander will be speaking to the substance of the legislation later on. The members of the commission from Maine are appointed by the governor, and all commissioners serve without compensation. The ULC itself is a nonprofit, unincorporated association that's been in existence since way back in 1892, and it's comprised of members from every state, as well as the District of Columbia, the Commonwealth of Puerto Rico, and the US Virgin Islands. The state of Maine's participation in the ULC is authorized by statute. Specifically, you can find it in Title III, Section 241 of the Maine Revised Statutes. The commission's mission is stated in that statutory provision, and consistent in fact with the internal organizational documents of the ULC itself, is to examine subjects on which uniformity of legislation in the different states is desirable, ascertain the best means to effect uniformity, to cooperate with the commissioners of other states in the consideration and drafting of uniform acts for submission to the legislatures of the states, and to prepare bills for introduction in the legislature. So the ULC serves to strengthen the federal system by providing rules and procedures that are consistent from state to state, but that also reflect the diverse experience of the states. So uniform acts allow the states to retain regulatory authority over the subject matter in question, while at the same time providing uniformity from state to state in those regarding those matters for which consistency is both helpful and important. Briefly stated, the process by which a uniform act is developed begins with a study committee during which the question of whether a particular issue is an appropriate subject for a uniform act, in which that very question is discussed and debated. If the study committee ultimately determines that it is appropriate to be the subject of a uniform act, then the committee recommends to the leadership of the ULC that a drafting committee be appointed or to deliberate on the substance of that proposed uniform act. That process occurs over a period of 2 years, with deliberation by the full commission over the first draft, followed by deliberation and ultimately a vote by the full commission in the second year. What is important to note is that both the study committee and the drafting committee processes involve robust participation from interested parties in a manner that is very similar to what you are all accustomed to here with the main legislative process. In addition, committees, the committees of the ULC are also aided by an accomplished group of staff attorneys at the ULC, as well as by other legal experts. The ULC staff resources are also made available to the states themselves as they consider the enactment of ULC legislation. And in fact, in that regard, I would note that we have with us today virtually Caitlin Wolf, legislative counsel to the ULC, who will be available to answer the committee's questions that they might have regarding the 2 acts that are before you today. So there's much more that can be said about the workings and process of the ULC, but I want to be respectful of the committee's time, so I'll end here. But if any member of the committee has questions now or later on, I know I speak for everyone on the commission in saying we'd be happy to talk with you individually or again as a group if the committee so desires. So with that, I thank you for your time, and I thank Representative Moriarty for having sponsored the 2 pieces of legislation that are before you. Thank you.
Thank you very much, Ms. Robinson. Committee members, are there any questions for Ms. Robinson? Representative Babbage, go ahead.
I will lower my hand now, Madam Chair. Thank you very much. Attorney Robinson, thank you once again. It does impact what's before us today, but it is a general question. And you know, it sounds like this Uniform Law Commission was just a wonderful idea for over a century as far as efficiency and practicality and not reinventing the wheel and making things move slowly, move efficiently as far as interstate impacts. I wanted to ask you if you could tell me about, does the Uniform Law Commission get lobbied by political interests? I think that's what I'm interested in. And is that something that you have to deal with?
So thank you, Representative Babbage. I would not say that the commission is lobbied by political interests. And I do want to note that it's a bipartisan commission.
Right.
But we certainly are contacted, as I mentioned in my remarks, by interested parties with respect to the subject matter in question. And so those interested parties are going to differ and vary, right, depending on the issue. And I would, again, liken that to what this committee and other committees in the Maine legislature invite and have before them when various interested parties come forward and testify on legislation. So there's the opportunity for interested parties, whether they be individual citizens or organizations, to provide comment, and it's very transparent. You can see with respect to the workings of any particular study committee or drafting committee, just who did come forward and provide comments either in writing or orally. So again, it's transparent, but I can say in my experience anyway, and I guess I defer to my other fellow commissioners as well, but that I have encountered political lobbying per se, partisan lobbying, if that's what you.
I appreciate that, and I offered that question in the spirit that we often look to what has been accomplished by other states in any issue, given the fact that people elected and who have the trust of their constituents, supposedly intelligent, practical people with the best interests of society in mind, if they've worked on this extensively, we can learn from that. And I think we give the same respect to Uniform Law Commission recommendations. But I did want to ask that question to see if that was a consideration that you folks had to deal with as you went forward with your 2-year process. Thank you.
Thank you.
Thank
Thank
you.
you, Representative Babbage. Senator Kime?
Thank you, Madam Chair. Thank you for being here, Mr. Robinson. And I guess I'll just take the moment to introduce myself. Sorry, I was delayed this morning. I am Lisa Kime. I represent Senate District 18, which is Northern Oxford County. Mr. Robinson, thanks for being here. I appreciated Representative Babbage's question because, and then you mentioned that the Uniform Law Commission was bipartisan. Is that true nationally or just for our state?
Nationally.
It is nationally. Oh, well, that's good to hear. And then, okay, thank you.
Thank you.
And Senator Kime reminded me that I forgot to invite committee members to introduce themselves when we started this morning. So let's finish with any questions for Ms. Robinson, and then we'll do a round of introductions. Are there any other
May
questions?
I make just one last comment? It's really in response to that question, both Senator Kimes and Representative Babbage's, because I want to make sure that I'm being fulsome, I guess, in my response. So Senator Kime, you asked whether it's bipartisan nationally. And when I say it's bipartisan, I just want to be clear that that the intent, the manner in which the ULC is conceived and constructed and constituted is bipartisan. It's not a partisan organization. In the case of the state of Maine, it's up to the governor as to who the governor chooses to appoint. And we serve for a term of 4 years. So obviously, there can be turnover. The only requirement to be a member of the ULC is that you be a practicing lawyer, a member of the bar in your state, whether that's in private practice, a state attorney, a legislator attorney, or academic, a judge, any of those fields. But so if you look at Title III that I referenced a little bit earlier, it does not say of the 3 members, one should be a Republican, one should be a Democrat, one should be an independent, or some other configuration. But I can tell you that the charter mission of the organization and the practical reality of it is that it is bipartisan. So I hope that's helpful for a clearer response. Thank you.
Thank you, Ms. Robinson. Representative Libby?
Thank you, Madam Chair, and thank you for being here, Ms. Robinson. I'm trying to wrap my head around exactly what this would do, and so I guess my question is, if this is passed and there's a judgment that was made in Canada and then it is applied in Maine, under whose jurisdiction does that fall to ensure that that is applied?
So
I'm going to interrupt for just a minute because I think that folks have joined the committee at different times this morning. Our process is that Ms. Robinson is just was presenting to us kind of a general understanding of the Uniform Laws Commission, and that we're going to hear the substance of both LD 902 and 903 shortly. So we haven't heard that yet. Any other questions for Ms. Robinson? I am not seeing any. Thank you, Ms. Robinson. You're welcome to stay on the panel if you would like. And we'll do a round of introductions, and then and Judge, the Honorable Donald Alexander has joined us. So we, Judge Alexander, could you please, Justice Alexander, you can activate your audio and video, and we're going to do a round of committee introductions before we invite you to speak. But welcome to the committee. We're delighted to have you here this morning.
Thank you.
All right, so I'm going to just call on committee members. Senator Keim has given an introduction, and so we'll move on to Representative Babbage.
Okay, yes, I'm on. Good morning, everyone. Little belatedly, my name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk. Thank you.
Representative Reckitt.
Yes, my name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Representative Moriarty.
Good morning, Steve Moriarty, once again, House District 45, Cumberland, and part of the town of Gray.
Representative Sheehan.
Good morning, everyone. My name is Erin Sheehan, and I'm proud to represent the good people of Biddeford's House District 12.
Representative Hagan.
Thank you, Madam Chair. David Hagan, House District 101, Hamden and Newburgh.
Representative Libby.
Thank you, Madam Chair. I'm Laura Libby. I represent District 64, which is part of Auburn and all of Minot.
Representative Poirier. She may have been called to another meeting. Representative Thorne.
Good morning. Thank you, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up here in Penobscot County.
Representative Evangelos.
Good morning. Thank you, Senator Carney. I made it. Representative Jeffrey Evangelos, House District 91, and I live in Friendship. Thank you.
And Representative Newell.
Good morning. Thank you, Madam Chair. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Thank you. And we are joined this morning by our OPLA analyst, Peggy Ranch, and our clerk, Susan Panett. And my name is Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And with all of those introductions, welcome again, Justice Alexander, and thank you for presenting to us some information about LDs 902 and 903.
Okay, thank you very much, Senator Carney, members of the committee, Representative Moriarty, the sponsor of these bills. I very much appreciate your considering this and hearing the bill and considering it and going where we go from there. The two bills, I'm going to discuss the Canadian money judgments registration bill first, and then the essentially an amendment to the create the Foreign Country Money Judgments Act, which, remember, amends a law which uniform law which Maine adopted in 1999. The Canadian bill, I think, is important, perhaps more important to Maine than some other states, because beginning in Washington County, from Lubec to Calais, and then going up to Aroostook County, all the way up to Madawaska and Edmundston, right across the border, we have a lot of communities that have sort of combined Canadian-American communities, just divided by rivers. A lot of people are citizens of both. There's a lot of interaction across the borders, and I think it's very useful to be able to have a situation where basically Canadian judgments can be considered the same way as judgments from New Hampshire would be, or whatever, in these actions. The proposed Canadian Money Judgments Act would do that. Yes, it's tied to the Foreign Country Money Judgments Act, but it has some differences. It does not require, a demonstration, for example, that the Canadian system is a credible due process system, which the Foreign Country Money Judgments Act does require as a prerequisite to having the foreign country money judgments considered. And so anyways, it's useful for that reason. There are all kinds of reasons judgments can be registered or want to be registered beyond being for litigation purposes. You can have them for real estate title, for persons' estates. And again, I emphasize a lot of people who are dual citizens and sometimes dual residents of both Maine and Canada. In that continuum we have along the border between Maine and New Brunswick, less so on the border between Quebec and Maine. But I say, and I've had significant experience working in that because I presided in Washington County a whole lot of time during the time I was a trial judge and afterwards. And of course, until 1999, which is after I was on the Supreme Court, we didn't even have the Foreign Country Money Judgments Act or its prior thing. So I think the Canadian Money Judgments Act is Registration Act is valuable because of the purposes it can be used for. I want to emphasize not just people who are bringing causes of action in Maine and want to register the Canadian judgment essentially to enforce it the same way you'd enforce a New Hampshire judgment or a Massachusetts judgment or a California judgment. It's also can be important just to show the existence of a judgment. For example, and the Canadian Money Judgments Act allows this, you can could register a judgment if you had a claim, a contract or a tort action in Canada, and then somebody came over here and brought the same one. And if you're being sued in that, although you weren't the person who recovered the judgment, you could therefore introduce the judgment. I've had this issue come up a few times way back in Washington County, where you could then show that this matter has already been adjudicated and then deal with it that way. So anyways, the Canadian Money Judgments Act is important because of our close cross-border relationships. On the Uniform Foreign Country Money Judgments Act, that is essentially an upgrade to essentially modernize the terms of the application to what's now the electronic age of the law, which the legislature adopted in 1999. And that's an expansion of it. If you go through, you'll see it's basically modernizing language, making it more relevant to today's electronic communications, electronic technology, greater understanding also of the various organizations of government. And basically that what it adopted is essentially an amendment to our current law. As recommended by the Uniform Laws Commission. The only difference is that in section 8505, subsection 1F, we added a reference which the Uniform Laws Commissions did not have, to say that you can't, that 8505 is a section that talks about where personal jurisdiction of another country is automatically established. And we basically amended that for Maine, at least, to say that no, your personal jurisdiction is not automatically established anytime you drive a motor vehicle or an airplane in another country. If you have an accident there, or if there's an event there. From Maine, we added that is not established if you're serving in the military or of service of the United States or the diplomatic service of the United States. So, for example, for the way we have it in Maine, if you didn't like something some members of the military did in Pakistan, you couldn't automatically say, hey, we have personal jurisdiction over them under the Maine law, and then bring and enforce an action in Pakistan to do it. Anyways, but basically, the law, with that exception, with that addition, is an update to what it is, and that's probably, and the committee's received the ULC summaries of both bills, and with that, I'd take any questions or comments or whatever.
Thank you very much, Justice Alexander. I do think we may have some questions, and I'll start by, I see Representative Thorne has his hand raised, but I wanted to first ask Representative Libby because I know that she had a question earlier and we weren't able to take that question at the time.
Thank you, Madam Chair. Thank you for being here, Judge Alexander. My question is, how would this be applied? If there was a judgment made in Canada, and let's use the example of litigation. So in practical terms, how would this be applied? Where would the jurisdiction be? Who would be enforcing any judgments made in Canada under this Uniform Registration Judgments Act?
What would be is we're talking about a Canadian judgment that will be registered. So for example, if there had been a dispute about a contract, let's say in Canada could be between two Americans, but something happened in Canada that gave the New Brunswick jurisdiction. If there was a dispute in Canada between either two dual citizens or one American and one Canadian, and there was a judgment in the Edmundston court for a contract. Let's say there's an award of $5,000 equivalent. That judgment and the American was involved was a Maine resident or a dual citizen who's also a Maine resident. You could then register that judgment in the United States and then have that judgment considered, perhaps to enforce it, which would get to the Foreign Country Money Judgments Act, or simply to have it recognized as something that the person owed, for example, if the person was being evaluated for whether a person qualified for appointment of counsel or home financing and stuff like that. Could be affected that way. Could also be recognized if, for example, the person who brought the action in the Canada and didn't like the result, then comes over and brings the action in the United States because there's jurisdiction in the United States of the person, and the person against whom the action is brought in the United States in Maine could then say, hey, there's already been a judgment in Canada that resolves it. So those are some examples of how it would be applied. If you have some other questions, perhaps you have some other examples you're concerned about, be glad to talk about them.
I do have a follow-up, if I may, Madam Chair.
Yes, go ahead.
So in using that example of a dispute of contract, I'm just trying to get my head around how this would play out practically. Using that example that you used, if a settlement was made in Canada and said that X owed Y this amount of money, and X that owed the money was a U.S. citizen, not even a dual citizen, but a U.S. citizen, and then this was recognized in Maine, who then ensures that that is carried out? Is it the justice system here in Maine that then takes over and carries out that act, or is it then adjudicated in Maine again? Or how does that process work?
No, it would be the judgment would be registered as it is now under the current Foreign Country Money Judgments Act, and then the person, the main person who wants to enforce it would enforce it. Same way as it works. We also have, doesn't apply to this law, but we've for a long time had the international child custody jurisdiction and child support enforcement laws, which have applied, and we somewhat see with some regularity on the border between Canada and Maine, applied here, being enforced by the person that wants to collect the money.
Thank you.
Representative Thorne, and actually, sorry to delay you again, Representative Thorne, but we have been joined by Representative Poirier. Would you like to introduce yourself, Representative Poirier?
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison. I apologize. I have a lot of different commitments today, so I'm going to be in and out a little bit. Thank you.
Thank you. Representative Thorne, you can go ahead with your question.
Thank you, Madam Chair. And maybe I'm getting hung up on the term Canadian Money Judgment Act. And the good judge mentioned that this was a law that was adopted back in 1999 and that these amend it. And I'm trying to pinpoint what it does that the law doesn't do currently for it. And it kind of gets down into the weeds and into the mud and down in below the mud from what I can gather, because
Not
you
really.
had referenced 805 subsection 1F, which is very specific, and I didn't get there in my document. But I'm just wondering if you can surmise in a nutshell what this does to amend it in layman's terms for me.
Okay, what the Canadian Money Judgments Registration Act does is allows you to register a judgment without at the same time being part of litigation, which has been possible for for long amount of time under the regular Uniform Foreign Country Money Judgments Enforcement Act. That could have already happened since 1999. The difference here is you can register it for a purpose, perhaps relating to, applying for a bank loan or something like that. You can register the judgment. It does not have to be tied to litigation. That's the real difference in what's new and why the Canadian Money Judgment Registration Act is needed. You can already do a lot of the sort of litigation related things under the Foreign Country Money Judgments Recognition Act, but the Canadian law allows you to just register it for any appropriate purpose and it does not have to be litigation related.
In other words, it just reaches over the border either way.
Well, what it does is says, here's a Canadian judgment that is recognized, and it's, for example, used by let's say a financial institution in evaluating your qualifications for a mortgage loan here in Maine. Let's say you live near Calais or in Washington County. You're seeking a mortgage loan. In terms of evaluating your financial capacity, the Canadian judgment could be registered. If there was a concern about if it was against you, it could affect your credit rating. If it was for you, it could affect your credit rating. It does not have to be related to litigation. That's one example.
Thank you.
I wonder if it would be helpful to do an example that involves a really practical kind of situation, Justice Alexander, of say a car accident in Canada between a US defendant and a Canadian plaintiff. And if the US defendant prevails in a negligence claim, so the Canadian court enters a judgment that there was no negligence on the part of the American who was the defendant in the Canadian action. And then the plaintiff tries to bring a second case in Maine. Can you describe how the registration of judgments would help in that situation?
Sure. Good question. You would register the judgment as a defendant. Say, hey, yes, there's jurisdiction here because you have jurisdiction of the person, but we have already litigated this in a court that has appropriate standards of due process and everything else. And so the Canadian judgment should act as res judicata, or because you've already litigated it, and bar the U.S. effort to basically litigate the matter again. You could have an example. You could have let's say a collision on the bridge between Calais and St. Stephen, for example. Same type of thing could come up, and the Canadian judgment basically, what the registration does is allow you to consider it for any reason that you could consider a New Hampshire judgment. And I want to emphasize, it does not have to be related to litigation. That's why I was using, with regard to responding to Representative Thorne, the bank loan credit rating use, because related to litigation, that's might also already be possible under the Foreign Country Money Judgments Act. Though in what you're saying, the defendant offering it, I'm not so sure, but in this way, it could be offered.
Thank you. Thanks for that explanation. Are there other questions on the part of committee members? Representative Libby, go ahead.
Thank you, Madam Chair. So my next question has to do with, if this seems pretty broad, as you're saying, it doesn't just apply to litigation, but also real estate or the car accident that was brought up. And what I'm trying to work through is that this would, I don't have any personal knowledge of Canadian laws and how their laws might differ from ours, but this would say that we uphold their laws, which we don't know in our state. And I guess that's what I'm trying to figure out. We are then going to be potentially on the hook to uphold something that may or may not even be in our laws. So can you address that?
Well, yeah, this is, and of course, we do that. Let's remember, we do that now with the Foreign Judgment Registrations Act. Anyways, we do it regularly with the laws relating to Canadian, decisions on parental rights, child support, things like that. I was asked about this exact point the last time I was confirmed on the Judiciary Committee for the Supreme Court. The concern about applying, foreign laws, should Maine courts be required to apply foreign laws? And the reality is, we do that with regard to Canada a lot. We have done it a lot with regard to say child support and parental rights. We've done it somewhat informally with regard to things like probation and bail conditions. And under the Foreign Country Money Judgments Recognition Act, we've done it there with regard to money judgments. So this isn't something new or different. What the registration does is simply allows registration for purposes beyond the usual, enforcement of laws by judgment situation.
Thank you.
Committee members, are there additional questions for Justice Alexander?
Yes.
Representative Babbage, go ahead.
Oh, thank you very much. Justice Alexander, great to see you again.
Thank you.
Delighted to have you before us. I understand the due process aspect of this. The registration is an official documentation that may or may not be used by an individual. Is that right?
Well, what the registration is simply you register it with a court here, and the law has with it a form by which you register it, which then it becomes entitled to the same consideration as a U.S. judgment. For example, as a U.S. judgment would be entitled to consideration in credit rating or perhaps in looking at some real estate issues, things like that. Or it could be talked about just like a New Hampshire judgment in all kinds of litigation situations. What this is trying to do is avoid Canadian Registration Act having to sort of file suit as a basis or have a litigation pending as a basis to register something, because there's a lot of purposes that aren't related to directly litigation in the matter. Did that address it?
Yes, and this is not merely a new piece of evidence to be entered into a legal proceeding. It would make the legal proceeding unnecessary.
Yeah, I mean, it allows, you know, the Foreign Country Money Judgments Act, one of the prerequisites, it's involved in pending litigation. And so it's used in pending litigation.
Okay.
This does not require litigation. You can simply file it to show, for example, as say, part of your, this judgment is pending, whether it's for or against you. As I say, as the example Senator Carney gave, the possibility of use of a judgment that's against you. But to say it's, you know, entitled to, it's already been litigated, it's entitled to so-called res judicata authority.
And if I may, Madam Chair, I just have one more. I know, you know, this has been enacted by 32 states. That's more than half, and you know,
Representative Babbitt, you're talking about the Canadian Money Judgment Recognition Act now, right? Not the
actually, the 32 states. I'm talking about the money judgments.
okay.
But I guess my question here is that perhaps, you know, there's even a geographic issue there with regard to why hasn't this been adopted by everyone? But I would ask you, if this were passed in 2005, is there any reason why we've waited this long to bring this before us?
Well, that's not something I know. I remember that the original Foreign Money Judgments Recognition Act was adopted by the Uniform Law Commissioners in 1962. Maine adopted it in 1999. So by comparison, in terms of the update, we're doing pretty good.
Gotcha. Okay. Thank you very much, Madam Chair. Thank you, sir. Appreciate it.
Yeah, you're welcome, Representative Babbage. I want Justice Alexander, I'm wondering if we can work a little bit on, because I'm also having a hard time sort of appreciating how the Canadian judgment legislation would work in a non-litigation context. Could you give us an example using maybe a probate matter where because we've done a lot of work on different probate code issues, so it's something that I think the committee is really familiar with. If you could give us an example of the impact of the registration of Canadian money judgments in a probate context.
Yes. Example there would be if you're looking at an estate and what is the value of the estate, what is in the estate. And somebody then comes in and says, hey, wait a minute, the estate isn't worth, you know, the house and everything of the estate isn't worth $98,000. They've got this Canadian judgment for $50,000. So the total estate is worth, you know, $140,000, something like that. Or in terms of people showing that they have an interest in the estate, for example, they can say, wait a minute, we've in probate court, we've got this judgment against the estate that's in Canada, and it's an interest we have that needs to be allocated by the estate. Maybe some or any those are a couple of examples where it could be applied in a state circumstance in a probate court, or it could be applied in a trust circumstance in a probate court.
Thanks. Those were both helpful examples. And could you give us just one more example, maybe involving a real estate situation where it would be important and helpful to be able to register a Canadian judgment?
Well, the real estate situation, if somebody brought a suit against you in the United States and you say, hey, we've already resolved this in Canada, this is the way it is, it would not, I can't conceive of a way it would affect title to real estate purely in the United States. And I guess I don't know there, I understand there are some properties upstate that maybe in both countries, but in terms of real estate, deciding a dispute about access to the real estate, things like that. Maybe if there was a Canadian money judgment right over the border that showed that this person had prevailed, and remember, this only applies to money judgments, but had prevailed and gotten damages in a action to establish an easement right up to the border of the United States property. They could then say, hey, they've already established this in Canada. Maybe it affects the United States property too. Or if you're looking at what experience a person has in a real estate matter and what the extent of their property ownership is, if that becomes relevant, maybe showing that you also had these real estate interests in Canada could affect it. It would not affect a real estate action. I can't think of a good example where it would affect a purely real estate action as opposed to a assets action in, let's say, Millinocket. But
Okay, thank you. I don't know why I thought the real estate example would be helpful, but I think the estate and probate issue is probably a really good way to kind of grasp the impact.
well, but there are properties where there's people own property on both sides of the border. Again, going up and and more so in Quebec than New Brunswick, because most of Maine and New Brunswick is divided by rivers. Most, but not all.
Okay, thank you very much. Your explanations have been really helpful. Committee members, are there additional questions for Justice Alexander? I see one more from Representative Babbage. Go ahead, Representative Babbage.
Just a quick one, and thank you very much. Justice Alexander, does this help? I mean, I live in southern Maine, so I'm not, I understand, St. Stephen and Calais and Edmiston and Madawaska and so forth, but I'm wondering if this would be particularly helpful to communities that are fluid between the two countries. Is that an aspect of this or not?
Well, that's in my experience, that's where it mostly comes up. I mean, I don't have any experience for saying, hey, when I'm presiding in court, and even after I was on the Supreme Court, I presided in Machias and occasionally Calais a lot. And those are the only places I've had, hey, we got this judgment in Canada, or there's a judgment in Canada that precludes this action, or things like that coming up. It certainly, has more significant impact on the cross-border communities. It can have impacts other ways. If you're trying to enforce a contract in Kennebunk, and the dispute is with somebody in Canada, and there's been already an action in Canada that person has taken, but it went in your favor, you could show that. If you've been able to recover a judgment in Canada for an automobile accident, you being in Kennebunk, and you are trying to enforce that Canadian judgment to the extent the United States court has jurisdiction over that person, if he comes into the United States, or if he has assets in the United States, you can enforce it that way. You're interested in Kennebunk.
And if I may, Madam Chair, my last question, I promise, is on this issue at least, is I'm seeing civil actions between individuals. Is there any ramifications regarding municipalities or maybe the tribes regarding their sovereignty issues and so forth that would be relevant to this proposal?
There might be. As you know, the Maine Supreme Court has just decided the case, sort of raising the bar a little bit and saying, yes, we are going to recognize tribal sovereignty in some areas like, parental rights, things like that. And of course, some of that stuff is cross-border and could be affected by Canadian judgments, but there's also some unique aspects of tribal sovereignty with the jurisdiction of the tribal courts, and which is one the Maine Supreme Court just decided, and that. So I can see where it could be relevant to file a Canadian judgment, have a Canadian judgment registered in Maine on some issues. But
your perspective is that this is generally helpful to those populations.
My perspective is this is generally helpful to the population generally, both the populations on the border, the tribes, and all, but also the people of Maine generally, because it basically allows cross-border activity, enforcement, respect for what happens across the border, whether that border is New Hampshire, Quebec, or New Brunswick.
Thank you. Thank you so much.
Some people say,
Thank you.
Thank you, Representative Babbage. Committee members, are there any additional questions for Justice Alexander? I'm not seeing any. It has been wonderful to have you and to see you again, Justice Alexander. Thank you for joining our committee. And as we move on to the next phase of this legislation, we may ask you to join us for a work session.
Thank you very much. Thank you, members, for listening to me, and see you tomorrow. So.
Terrific. Thank you. Let's see. I'm not sure if we have anyone else here to testify on 902 and 903. So at this point, I'm turning to those who are in the attendee part of this meeting. And I see Attorney Paul Chaikin, who we know is also one of the Uniform Law Commissioners. If you would like to join the panel and address this legislation, Mr. Chaikin, could you please raise your electronic hand? Is there anyone in the attendee part of the meeting who would like to speak on LD, not in favor of LD 902 and 903? You see that Caitlin Wolf would like to join us, so I am going to move her into the meeting as well. First, we have Attorney Sam Sherry, who has joined us to speak. Are you here to speak in favor of 902 and 903?
I am, Madam Chair. Thank you for the chance to do that. Good morning. Good morning, Ms. Carney. Good morning to each of you. I'm Sam Sherry. I'm an attorney with a comprehensive commercial law practice in Portland. My first challenge today is to follow Donald Alexander. I come to you this morning as the chair of the Maine State Bar Association's Consumer and Financial Institution section, the CNFI. I'm here because the CNFI has sent me. I'm not here on behalf of the Bar Association as a whole. I want to take a little bit of your time to talk about the CNFI section because I think it may help you to appreciate what we have to say in brief today. The Consumer and Financial Institutions section is an odd and beautiful section of the Maine Bar Association. We bring together lawyers who represent creditors, folks who are owed money. I do that work. Debtors, consumers, people who might owe money or interact in that fashion with the legal system. Regulators, folks who work for the state, who regulate financial institutions and regulate the collection processes, and attorneys who work for or work on behalf of financial institutions. The reason that that's odd and beautiful is because these are people who come together to talk and listen, who bring a wide variety of often divergent viewpoints. Debtors and creditors don't always see things the same way. Regulators and those they regulate don't always see things the same way. And yet we come together several times a year to talk, to listen, to learn from each other. I'm admitted in other states, and I can tell you that the states I'm admitted in don't have something that brings all of those groups together. In fact, many of the other sections of the bar don't bring divergent viewpoints together in precisely that way. This is my second spin as chair of the CNFI section. Last time I did this was in 2008. And the reason I mention that is because our policy in the CNFI section is we talk and we listen, but we don't do anything unless everybody agrees. I'm here today because everybody agrees that 902 and 903 are things which all of our divergent constituencies feel are positive for the people of Maine and for the administration of justice, civil justice in the state of Maine. Debtors, creditors, regulators, financial institutions came together, heard about these two bills, and decided that they were appropriate for the support on behalf of each of our divergent communities. I hope that that helps to convince you that they're worthy of your support today. Before I go, I want to note that we took up a third bill, an update to the Uniform Fraudulent Transfer Act, and we didn't reach that level of unanimity. And so I'm not here and won't be here to talk about that. This is something that we do very, very rarely. The last time I came up to speak to this committee was in 2008.
Mr. Sherry?
Yes,
I
ma'am.
just wanted to let you know that we have a 3-minute time limit on testimony, and then we open up for questions from committee members. So I wanted to thank you.
Backwards.
Pardon me?
I will talk backwards and retract my last.
No, I'm sure that you could do that, but you don't need to, although we might want you to. Anyway, let's see if committee members have some questions for you. And thank you for providing your testimony today. Committee members, are there any questions for Attorney Sherry? Go ahead, Representative Libby.
Thank you. Thank you very much, Mr. Sherry, for being here today. I found your testimony to be very helpful. Could you please finish what you were saying regarding the last time you were here, if it is pertinent to this bill?
Sure. I only wanted to say that I was here in 2008 to support what is now the Personal Property Recovery Act. That's the last time that our section found unanimity to support a piece of pending legislation before the legislature. And so it is unusual and positive for us to be here today through me. Thanks for your question.
Thank you very much.
Any other questions, committee members? I'm not seeing any, but I actually have a question for you. Could you please give us just one kind of concrete example about how helpful 902, the registration of Canadian judgments, would be?
Thank you. I've done a lot of arbitration work over the years, and arbitration is a private court. The parties agree to hire a private judge to consider something privately and render that judge's decision. When we get done with that process, that judge issues a private order. And much of the time, on behalf of my client, I will take that private order into court and have it recognized under the Arbitration Enforcement Act and the procedures that relate to it. This is a lot like that. there's been a case that has been brought in Canada. Canada has a robust legal system, one which the Uniform Law Commissioners have felt comfortable in relying on, one in which our diverse members in the CNFI committee have felt comfortable in relying on. And so we say, this bill says, you don't have to do the whole thing again. You don't have to take up the scarce and valuable time of the main court system to achieve perhaps a different result as you step to the plate for a second swing. I hope that's a helpful analogy or example to answer your question.
Yeah, thank you. That was helpful, and I see that it may have prompted another question. Representative Libby, go ahead.
Thank you. That was actually remarkably helpful for a novice to the law. So essentially, you're saying then that what this would prevent is some sort of litigation or probate double jeopardy.
Yes. Lawyers will tell you, lawyers much smarter than I will tell you, that double jeopardy is a criminal concept, right, but second swing is a decent analogy. So yeah, all of that.
All right, thank you.
Thanks for the question, Representative Libby. Representative Babich, go ahead.
Yeah, just a quick one. You mentioned that you don't come how do you do, Mr. Sherry? Good to see you. Thank you. You mentioned that you don't come before us very often, that the divergent interests you represent should agree and so forth. I have to say that when something is before us like this that is potentially complex for the uninitiated, I have a concern about power and size having influence. And so, you know, like for instance, the big banks or whatever. So I just want to be careful when we proceed in that way. So when you mention how do you define divergent interests within the CNFI division of Maine State Bar? Thanks.
What a great question. I'm happy to speak briefly and hopefully to set you at ease. We have people who work for or on behalf of large and small banks, large banks and local banks. They're the members of the section. Some of them are officers in the section. We benefit so greatly from the participation of people like William Lund, the head of the Maine Consumer Credit Regulatory Body, a long time and active participant, and our vice chair of our committee. You can picture how those are folks who look at the same situations and come to differing conclusions based on their differing perspectives at work. We have people like myself. I am nationally accredited as a specialist in creditors' rights law. I represent folks, institutions, companies, municipalities who are owed money, and I help them to bring that across the threshold. As I do that, I bump straight into the lawyers who represent consumers and who represent folks and businesses who are owed money. We don't always see things the same way, and yet all of us come in one actual or virtual room to talk with each other, to learn from each other, to exchange perspectives in the best tradition of the Maine Bar. This is what you smile to see lawyers do. And it doesn't happen everywhere. And I can tell you that our procedural requirement of unanimity tends to sharply undercut over-influence by any of those constituencies. If there are 4 bank lawyers and 1 regulator present, they're not going to swamp Will Lund, are they?
Thank you for that response, and thank you, Madam Chair.
Thank you. And Mr. Sherry, thank you so much for joining us today. We appreciate your being here. We'll move you back to attendee status. And I want to welcome Caitlin Wolf, who is here to provide testimony in support of 902 and 903. You can proceed.
Thank you very much, Madam Chair, and members of the committee. It's a pleasure to be with you. Again, my name is Caitlin Wolf. I serve as legislative counsel to the Uniform Law Commission. So my role is to work to support the enactment efforts of our commissioners, all of whom you've met today, our main commissioners. I just wanted to touch briefly on my support for both bills before you, so 902 and 903. I think it's a little bit confusing. We are trying to consider them together because, as was mentioned earlier, they are so very interrelated. So the Foreign Country Money Judgments Recognition Act, as Justice Alexander mentioned, to summarize, is really just a set of discrete amendments to your existing law about how to go about recognizing and enforcing a judgment, a foreign judgment from another country, Canada or otherwise. The big benefit here in the Registration Act, the Canadian piece, is it offers a streamlined procedure for Canadian money judgments specifically. As was already mentioned, I think that this bill in all likelihood would be used quite a lot in the business context. Obviously, there is a lot of fluid communities going back and forth across the border, a lot of business being transacted between Maine and Canada. And I think in business disputes is when this would most likely come up and really get used most often, where there is a money judgment as a result of, say, a contract dispute in Canada that would then be enforced in the state of Maine. And again, what we were looking for, what the commissioners were looking for when drafting the Canadian Registration Act was we wanted to streamline the process. So save litigants money. You don't have to come to the state of Maine and start a whole new lawsuit again to fight over the same issues that you already had resolved in Canada. In addition, decongesting court dockets. I wish Justice Alexander could have addressed just how busy he and his colleagues are, but that was a concern of the commissioners that they wanted to address as well. Given the unique relationship between the United States and Canada, it's our top trading partner. We know there's a tremendous amount of business occurring between our borders. We wanted to make sure that because we share and trust the legal process in Canada, that we offered a streamlined way to recognize and enforce Canadian money judgments in the United States. Again, thank you so much for your time this morning. Just wanted to offer my support for the bill and say that I am here today and beyond. If any of you committee members have questions, concerns, resources as you continue to think about these bills, I am happy to help. So thank you again for your time.
Thank you very much, Ms. Wolf. Committee members, are there any questions? Representative Babbage is okay, great. It looks like we don't have any questions. If we do, we will invite you to our work session on these bills. Thank you for being here today. And at this point, I'm turning to the attendee list and would like to know if there's any other attendee who is here to speak in support of LDs 902 and 903. I'm not seeing any. Is there anyone here to speak in opposition of 902 and 903? If so, please raise your electronic hand. Not seeing any. Is there anyone here to speak neither for nor against 902, 903? And again, I'm not seeing anyone else. So with that, we thank everyone who presented on LDs 902 and 903. The public hearing on those bills is now concluded. At this point, we are going to move on to our final public hearing for this morning, and that is LD 348. And LD 348 is sponsored by our colleague and committee member, Representative Jeff Evangelos. And Representative Evangelos, welcome, very hearty welcome to the committee, and please begin presenting your bill when you're ready.
Thank you, Senator Carney. Good morning, Senator Carney, and Representative Harnett is in another committee, but good morning to him as well. and other distinguished members of the Judiciary Committee. I am Representative Jeffrey Evangelos from Friendship, and I represent House District 91. I am speaking today in support of LD 348, an act to give oversight powers to the Maine Commission on Indigent Legal Services. As the summary indicates, this bill creates a process for the Maine Commission on Indigent Legal Services to remove an attorney from the roster of attorneys qualified to provide legal services. Currently, there is no process in place for this purpose. This bill authorizes the commission to remove an attorney from the roster when the commission determines, after due process notice and hearing, that the attorney violated a law or standard adopted by the commission. And thank you for your consideration. And I want to elaborate for the committee and give some background so that Mr. Andrus knows why I brought this bill forward. In March of 2019, I became aware of a court judgment issued by Federal Justice John Woodcock against Hancock County's assistant prosecutor in the matter of a malicious prosecution in the case of Vladek Filler. Justice Woodcock compared Filler's experience with the criminal justice system to Frank Kafka's book, The Trial, in which a man is arrested and prosecuted for reasons never made clear. Woodcock went on to state that Mr. Filler endured a living nightmare. The American Civil Liberty Union, in a friend of the court briefing in the Filler case, stated, and I quote from the court, Kellett's act, the Assistant District Attorney's act of splicing an interrogation video in order to alter its meaning and impair its veracity constitutes a crime. The Maine Bar cited this Assistant District Attorney for 7 bar rule violations. In November 22nd, 2019, I attended a court hearing in Hancock County. After this assistant prosecutor, who was no longer selected to be a prosecutor in that office, she was forced out. I found out that she was rostered on the Indigent Legal Systems roster. And I want to tell you a little bit from the transcript what her actions did to this man. According, and I'm reading now from the transcript from Justice Woodcock, except for murder, there is no crime that a man can commit against a woman more heinous than rape. The state prosecutor who was assigned to Mr. Filler's case committed numerous violations of Maine bar rules and engaged in malicious prosecution. After the bar found her in violation of 7 bar rules and recommended her suspension, she was then sanctioned by Supreme Court Justice Gorman in order to take a remedial training so that the Brady violations that she committed and the falsifications of evidence, in effect, she framed a man into prison, and he won 2 legal judgments because of it. Just 15 days after she promised Justice Gorman not to engage in that kind of activity, this now private attorney, under oath in the matter of Hodgson versus the state, a post-conviction appeal, attended by Walter McKee as a witness regarding ineffective legal counsel. Under questioning from David Wyrens, she admitted that just 15 days after promising Justice Gorman, she returned a cell phone that contained exculpatory evidence to the accuser without making a copy. And the defendant was not able to retrieve information that he was being extorted for money. So just 15 days after. So in combination with Justice Woodcock's findings and what happened in November, I filed a complaint with literally hundreds and hundreds of pages of documentation to support it, court transcripts, Judge Woodcock's findings, to the executive director, because I don't believe an attorney in that kind of standing should be subsidized by the taxpayers. Subsequent to that, I waited a year I made repeated requests to the executive director as to what the status of the complaint was and as to whether the commission was going to take it up. Well, the commission never did take it up because the executive director at the time never brought it before them. So the commission chair, who is still the current commission chair, called me up one day and said, "What is going on with your complaint?" And I said, "I don't know." I said, "You should know. I've asked it to go before the commission and it hasn't." And he told me, "Well, there's no process that we have within the commission to bring these complaints forward." So Mr. Tardy suggested that I bring the bill forward. So I did. There has to be, with the reforms we're trying to undertake within the commission, there has to be a process for which an attorney becomes derostered. I know we have bar rules, but somebody that's committed 7 bar violations and had their law license suspended is still on the roster. And this prosecutor framed a man, falsely accused him of raping a woman. And she is on the roster in Hancock County to represent defendants for sex crimes. Yeah, I think that's pretty outrageous. So I did bring the bill forward. Mr. Tardy wanted me to bring the bill forward so that there was a due process within the commission. And we know that part of our problems gaining traction with Governor Mills in regards to the reforms we're all seeking is that she wants us to have the commission develop systems of accountability. So this is just a small step that will allow the commission to hear a complaint, and if they find that the evidence is there. The excuse I was given why my complaint was rejected was that I did not prove that the person I filed the complaint with had committed a crime. Well, that's not a standard that anyone should be held to. I'm not judge, jury, and executioner. I filed a complaint simply to have the taxpayers no longer subsidize this person's job. She's licensed to practice law in Maine. That's her right. She got her law license back. That's fine. You know, hang out the shingle and work. But I don't think the taxpayers should be paying for somebody who's committed these kind of egregious offenses. She did it more than once. She's a repeat offender. And there needs to be a process in accountability to allow the commission to act on these people. Otherwise, we're going to get right back into the issues that Senator Keim has raised regarding, you know, accountability. So this is just a small step forward. But I wanted you to know what motivated the bill. And it was this specific case. This person is free to practice law privately, but I don't think the taxpayers should be supporting someone who has committed, 7 bar violations, cited by a federal judge for framing a man, malicious prosecution, ruining a family's life. No, I'm not going with it, that the taxpayers pay for someone like this. So I set this process up in this bill to allow the commission to hear a complaint so that it isn't just in the hands of the executive director. I also want you to know that after a year of waiting, on a Friday, I finally got the decision that nothing was going to be done. I wrote the executive director back immediately. And the email I got back was an auto reply that I no longer work here. It was the very last thing done before his departure. So, you know, I'm very, very concerned. It was made to sound like I supplied no evidence. I supplied the transcripts of all of the court cases. I supplied the brief that the American Civil Liberties Union filed alleging crimes were committed in the fabrication of evidence. I submitted every single piece of documented evidence, not my opinions, all supported by the actions of Justice Woodcock. So I'd be happy to answer any questions. Thank you.
Thank you very much, Representative Evangelos. Committee members, are there questions for Representative Evangelos? Go ahead, Representative Babbage.
Thank you, Madam Chair. Hello, Representative Evangelos.
Hi, Chris.
Jeff, can I ask if your major concern here is dishonesty or negligence as a factor?
My major concern is that, well, neither or all of the above. My major concern is that we have to have a process on the commission where legitimate complaints are heard, and it's not left in the hands of one person to make the decision. I don't think that Mr. Andrus or Mr. Pelletier should be making sole discretionary decisions. If somebody brings a serious complaint about a lawyer forward and wants them taken off of the roster, there has to be a fair process to protect that accused attorney to get a hearing in front of the commission. That's where I'm coming from. So, you know, you are a lawyer and you've been accused of something, and somebody wants you removed from the roster because they don't want the taxpayers paying your salary. You know, hey, I didn't do it. Okay, come before us and you'll get a fair hearing. That's all I'm asking for here.
And you don't feel that the judicial branch's policing of their own is satisfactory?
Well, it certainly wasn't satisfactory in this case. You know, 7 bar violations. The main bar made a recommendation that she lose her law license, and Justice Gorman, you know, suspended her for 30 days. I mean, it was against the recommendations of the bar to allow her to continue to practice. But Gorman gave her a break, and then 15 days later, she did it again. She returned a cell phone to a man's accuser that it contained exculpatory evidence. And, you know, the man was in prison for 3 years because of it. Filler served a month in prison and ended up with a $1.8 million judgment and a $375,000 judgment against Hancock and Washington counties prosecutions and law enforcement. I think that there has to be a process beyond the main bar for the commission to say, you know, the main bar may be comfortable allowing this person to continue to serve, but we're not comfortable allowing the taxpayers to continue to subsidize them.
Thank you, Representative Savage and Representative Evangelos. I just remind committee members that, as Representative Evangelos indicated in his answer, that this is really about the establishment of a different mechanism for seeking review of someone's membership on the Indigent Legal Services Panel. So if we can focus our questions on the review process itself and the change in the law that the bill would accomplish, that would help us do justice to this legislative proposal, and will also allow us to move forward with our work. So are there additional questions that are related to the legislative proposal that is before us?
Would like to respond. You're correct, Senator Carney. If there are any questions, I'll stop. But I had multiple commission members contact me and say, you know, what's the status of this case you brought forward? And I go, I don't know. Why haven't you been told? You know, the executive director didn't inform the commission, apparently. So this didn't just come from me out of left field. It came out of documented court cases and concerns of different commission members as to they should have been involved and they weren't.
Yeah, no, that came through loud and clear in your introduction. And I think, as I said, I think it's a really important legislative proposal. And I want to make sure that we really kind of focus on the change that would be accomplished by the proposal. Hopefully it wouldn't be used very often, but in serious cases, you could have an attorney who's still, you know, a member of the bar who's engaged in unethical or untoward conduct. All we're saying is, sorry, pal, you're not going to be subsidized by the taxpayers any longer. They shouldn't have to pay for this. Let's move on and see if there are any additional committee questions. I'm not seeing any, so thank you very much, Representative Evangelos, and I will turn to the attendee space, and I believe that we have Attorney Zachary Hayden, who is here to testify in support of this legislation. Is that correct, Mr. Hayden? Can you raise your, you're being transported through cyberspace as we speak.
Good morning.
Judiciary Committee. and you can proceed with your testimony.
Thank you so much, Senator Carney. Good morning, members of the Judiciary Committee. My name is Zachary Hayden. I'm Chief Counsel at the ACLU of Maine. Thank you for the opportunity to be here this morning, and thank you to Representative Evangelos for bringing forth this important piece of legislation. The ACLU of Maine is in support of LD 348. We hope that it will gain the support of this committee. It is important that MCILS has among its tools for conducting oversight of the lawyers appointed to handle cases in Maine, the ability to decide that a lawyer should no longer be representing people at the state's expense, either because that lawyer is not performing or because the lawyer has done something that would bring the state's system into disrepute if the state were to continue to appoint somebody as a representative of the state to handle matters where a person is entitled to counsel. So that is our reason for being supportive of this legislation. I did submit written testimony, and in that testimony, I sounded a note of caution that I want to also mention in my oral testimony, which is simply that the Maine Commission on Indigent Legal Services has an obligation to conduct oversight of the lawyers who are rostered, the lawyers that it is appointing, to establish a system for evaluating those lawyers and supervising those lawyers, managing the caseloads of those lawyers. And the commission, the Maine Commission on Indigent Legal Services, has not done any of those things, even though they are clearly required to do so under statutes adopted by the legislature. So adding to the responsibilities of the Maine Commission of Indigent Legal Services when they haven't even been able to satisfy the obligations that you've already set forth for them, could be difficult. And my second worry with this legislation that I wanted you to be aware of, not as a reason to not support it, but just something to be aware of, is that it draws attention to the issue, which Representative Evangelos ably discussed, of attorneys who are not living up to their responsibilities. And that is absolutely true. That does exist. But it is really the state, the executive branch, the Maine Commission on Indigent Legal Services, that is not living up to its responsibilities. They are the entity with the responsibilities to supervise and oversee the system, and that is where there's the greatest need for accountability. With that, I'm happy to try to answer any of your questions.
Thank you very much, Mr. Hayden. And I need to go to state and local government to present a bill, I think. I'm going to go check on it. So I'm turning the chair, the virtual gavel over to Representative Babbage, and I hope to rejoin you shortly. Thank you very much, Representative Babbage, for taking over as chair.
Okay, yes, ma'am. I'm glad to do so. Thank you, Senator. Do we have questions for Mr. Hayden? I actually have one for you, if I may ask. In the wording of the bill, it talks about. Let me look at it very quickly here. If that the attorney has violated the law, that would be one of the. Is there an example where an attorney might have violated the law, but is reinstated, in which an indigent defendant could be benefited by their services, or do you support that particular phrase remaining in the proposal?
I think that's a great question, Representative Babbage, and there's absolutely no reason why somebody who has had difficulties with the law, who has maybe been convicted of a crime or sentenced for a crime, shouldn't be able to be rehabilitated and participate in public life, including serving as a lawyer. And there are many excellent lawyers who had problems with their past. They did what they could to get their lives back in order and became lawyers and can be excellent lawyers. The problem is that the state of Maine, the Maine Commission on Indigent Legal Services, has no mechanism in place for identifying lawyers who have had problems, who are having problems, whether those problems are of a criminal nature or problems practicing law and being competent attorneys, and then helping those lawyers work through whatever issues they need help with, whether it's they need to know how to, keep their funds in order in a way that's consistent with the bar rules and consistent with the law, or they need to know how to perform the tasks of an attorney. Many, lawyers who are having difficulties, whatever those difficulties are, can often learn how to do the right thing. But the state of Maine has invested no energy, no time, no resources in making sure that the lawyers that it is responsible for supervising, for appointing, are able to go through that process.
Thank you for that. Representative Moriarty, do you have a question?
I do. Thanks very much, Mr. Chair. Mr. Hayden, just if you could refresh my memory, is it the commission itself that has the power to place an attorney upon the roster, or is that done in the judgment of the director?
That's a good question. I'd have to go back and look at the statute, because you are correct that the statute does set out different responsibilities for the commission itself and for the executive director. And that particular act, I don't know the answer to. I'm happy to get that for you for the work session of who has that responsibility.
Sure. So thanks very much for that. I'm assuming the commission may, and your this bill would basically give them the corresponding authority to remove.
That's my understanding.
Right. And then just to follow up on Representative Babbage's question, it appears to me that the commission would also have the authority to reinstate upon a proper showing that if there was a personal crisis or maybe a substance abuse crisis, if that was resolved, the person would be eligible to apply for reinstatement in the Judge Commission.
That's my understanding as well, and that is as it should be.
Okay, good. I agree. Thank you. Thank
you, Representative Moriarty.
Thank you, Representative Moriarty. Are there any other questions from Mr. Hayden? Mr. Hayden, can I ask you if you've had the opportunity to review the MacDill testimony?
I have not. No. Is that up on the website?
It has been submitted, but I was going to ask you for a response if you had. But we'll hear from them, and you'll have the opportunity at some later.
I'm sure it's excellent, but I'll have to review it on my own. It's possible that we have a different perspective on this matter, but I'm sure that their observations are well considered and well thought out.
Thank you. Any other questions? Last call. Thank you so much, Mr. Hyde. Appreciate it.
Thank you, Representative Babbage. Thank you, committee.
Are there others that would like to testify in favor of the bill? Actually, I don't have access to the panel, but so if Soupy could notify me, I guess not. Hearing none, last call. Is there anyone that would like to speak to the committee who is in opposition to LD 348? I can't see the panel, but is Tina ready to be?
Yes, sir.
Okay, thank you. Ms. Netto.
Good morning, everyone.
Welcome.
Thank you. My name is Tina Nato. I am the Executive Director of MACDL, the Maine Association of Criminal Defense Lawyers, and I am presenting testimony in opposition to this proposed legislation. To clarify first, Representative Moriarty's question to Zach Hayden, it is the Executive Director who determines who is on a panel or rostered for certain types of crimes. I believe there's a misapprehension and or I don't want to call it a misrepresentation, but there is a process currently within the commission that deals with discipline and deals with issues regarding removal and suspension. That process came about through legislation, but the commission itself decided to do rulemaking and invested that authority, the initial authority to review complaints, to decide whether or not an attorney should be removed or suspended or otherwise disciplined within the role of the executive director. That is the current process. So in my testimony, I have attached the current rules, which is chapter 2, regarding attorney discipline and how the executive director responds to that, as well as chapter 201, which outlines the appellate process where the commission sits as an appellate body if an attorney is aggrieved by the decision of the executive director. So if an attorney is suspended or removed, the attorney has the standing to appeal that decision to the full commission. As you'll see from the attachment, it's a very extensively drafted process. And then through the Administrative Procedures Act, they can then, if they're still aggrieved, appeal that decision through Rule 80C of the Civil Rules of Procedure to the Superior Court. So there are procedures in place, and attorneys have been disciplined. So I guess I'm a little frustrated with this proposal because it's a blunt instrument that would completely obliterate what's already in place, the nuance of what's in place. And we should recognize also how nonprofits work, how commissions work in various ways. There are roles that the staff plays and there are roles that the commission plays. The staff, namely here, the executive director, is charged with the authority of overseeing and supervising and disciplining attorneys. The commission is tasked with creating rules and supervising the executive director. So there is already a check and a balance in the system that if the executive director and the person with whom Representative Evangelos has a problem is no longer the executive director, they can remove that executive director. They can have conversations. They can decide within their own rights to amend the rules themselves, rather than impose this kind of blanket legislation that, again, would just override all the work that's been done. These processes and procedures have been in place for over a decade. It's interesting that the commission itself did not ask for this bill. I don't know what Representative Evangelos' conversation was with Chair Tardy, but Chair Tardy is not here from the commission saying, please give us this authority as the commission. That is not what we're here today on at all. The commission takes no position, my understanding is, I think, and the current executive director will explain why, but this is just not necessary. Maxwell doesn't oppose being supervised and, you know, being part of a system that actually disciplines attorneys for misconduct. That is not a problem. The problem is when we're not following the procedures that are already in place, creating unnecessary broad legislation that doesn't actually understand the process that's currently in place. That's a problem that we have. So for those reasons, we're opposing it. And I'd be happy to answer questions from the committee.
Thank you, Ms. Nitto. Normally, as a procedural point, a person who introduces or sponsors a bill does not question a witness in opposition, but unless the committee has objections, I'll call on Representative Evangelos to ask his question if he wishes to.
Thank you, Mr. Chair. The rules are that we're allowed to ask a clarification question, but not, get into it. So I understand the parameters. And the clarification question I have for Ms. Nadeau is the process that you just outlined, can you tell me the last time it was used or if it's ever been used? Could you give us an example?
The process, which part of the process? An attorney, the executive director reviewing a complaint involving an attorney?
No, the process that you said is outlined in the provisions of law and the Administrative Procedure Act, where the executive director has made a decision and then it's been appealed to the commission, and the commission heard, in effect, had a hearing on it. Can you tell me if it ever has happened once?
I am not a commissioner. I am not the executive director. I don't necessarily have access to that information. I do know that that procedure is in place. So an aggrieved attorney, whether they're disciplined for, misconduct or what have you, and there's other delineated issues that can be appealed to the commission as well. I don't know. You
So
should,
you have
you
no
should ask Executive Director Andrews about that.
I will, but you presented it as evidence, so.
Okay, okay, yep, I think she's answered. Thank you, Representative.
A point of clarification, Representative Babbage. The point is, if this process is in place and it's never being used, it's just another reason to bring the bill forward.
Sure, you can, and you can make that case again at work session. Thank you, Representative. Thank you, Miss Neto. I'm going out on a limb here, but I'm thinking of the Maine Elections Commission. I mean, if there's a punitive action to be taken, even though the executive director might have significant powers, there's usually to my knowledge, in that instance, a commission directive as far as final determination of any penalty or whatever. That was not part of the process that was adopted by the legislature 10 years ago, is what you're saying.
No, I'm saying the process was actually adopted by the commission itself. The commission itself, through its rulemaking authority, granted as a final agency action anything that is not appealable to the commission as a final agency action imbued into the executive director. If it is appealable, if it's one of the things that's listed as appealable to the commission, then the commission's decision is final agency action. So either one of those things, if properly termed those, final agency action, that's when it can get kicked up to the Superior Court on an ADC appeal. So that's the operative phrase. But again, the legislature gave the commission certain authority, and the commission used that authority to initiate and institute a process that has worked for it for over a decade. And I'm not familiar with the Commission on Elections, unfortunately, so I can't really make that.
Yeah, no, okay, I didn't really expect that, but I appreciate that response. Representative Evangelos, did you have?
Yes, I've actually been before the Commission on Government Ethics, filing a complaint for campaign ads, malicious campaign ads. And the process is you file the complaint with the executive director, but the full commission hears the complaint, exactly like this bill outlines. And again, I have to, on a matter of clarification, Ms. Naidu has just attempted to say we have a process that's working, but there's no evidence that they've ever even.
Jeff, yeah, I appreciate what you're saying, but she's entitled to present as she wishes, and we'll talk about it at the work session. So thank you. Yeah, thank you very much. And thank you, Ms. Neto. Is there any other questions from Ms. Neto from the committee? Seeing none, thank you very much, Ms. Neto. Appreciate your testimony. Is there anyone else that wishes to speak in opposition to LD 348? I don't see. Is there anyone, hearing none, is there anyone that would like to speak neither for nor against LD 348? Is Mr. Andrus coming in? Yes, you're welcome to come in.
Okay, I've just clicked back in, so I'm not sure whether I was recognized.
Yes, you were.
Okay, thank you. Good morning, everybody.
Welcome, Mr. Andrews.
Just turn this up a little bit. All of you know me. I am Justin Andrews. I am the interim executive director at MCILS. I am not the person who was the executive director during the period that leads to this discussion. A lot of what I was going to cover, Ms. Neto covered, but I can answer some of the questions quickly as part of my start. Since joining the commission on January 19th, I have invoked this formal process 15 times. As I think you all know, I was assistant bar counsel at the Board of Overseers immediately before starting this job, and holding attorneys to account is not something that I'm squeamish about, not necessarily something you can rely on in every executive director. So we do need a process that fails safe for the indigent people and the people of Maine. But I have started 15 formal investigations. Can't get into details of any of them under our confidentiality statute, but the first of them has made it to the appellate level and is pending appeal before the full commission now. And so the answer to the question, does this process get used? The answer is absolutely. The other part I wanted to raise just very, very briefly is that in addition to the standards that the commission put into place through rulemaking to create this process, I have drafted a standards document I'd be happy to share with anyone who's interested in it, talking about thresholds for criminal convictions and bar licensure findings and how they ought to inform the executive director's discretion before a matter gets to the commission for an appellate decision. The commission does not have an opinion for or against at this point. That does not represent ambivalence on the part of the commission. That represents that the commission didn't reach the issue. We do have a commission meeting in 7 minutes, which I may be late to if you have questions for me, of course, but I will raise it at that commission meeting and find out, hopefully be able to report back through work session if you'd like, what the commission's view on it is. It may not be possible to do that if the commission members don't feel adequately educated, but it's not ambivalence. It's simply not having reached the question, but there is no position at this moment. I'll stop there since I agree with what Ms. Neto said with respect to the process. It's in chapter 2, in one of our rules. And then there's the standards document that I wrote on February 8th. Some of you may have seen it, but I'd be happy to give it to anyone who needs it. And of course, happy to appear to work session if that's helpful.
Thank you very much, Mr. Andrus. Are there questions from the committee for our guest? Oh, hold on a moment. Yes, there are. Senator Carney, are you here?
I am here. Thank
Wonderful.
you. I'll take that as a hearty welcome back.
Yes, it is.
Mr. Andrus, I know you don't have much time before your meeting, but I was wondering if you could please give us your opinion as to whether you think the current process is working well, actually working well, barely adequate, or not working at all.
So I have already made my apology to my commission, and I have as much time as this committee would like, and will arrive there when I can. But my answer is, I think it works reasonably well. I think that, like at the Board of Overseers, you have an individual who assesses a complaint and does an investigation to determine whether or not it's worth passing on. Unlike at the Board of Overseers, on the existing structure, I have the ability to suspend somebody immediately if I think there's cause to do that. They have recourse, which they should have, but if there were something that rises to the level of criticality, I can move immediately. And then it goes to the commission. Now, the thing that existed at the Board of Overseers that doesn't exist here is when I dismiss something at the Board of Overseers, there was an opportunity for a public member to review it and determine whether or not the dismissal was warranted. So there is a little distinction there. I don't want to suggest it's precisely the same. But I do think for the executive director to essentially have the prosecutorial authority to investigate the case and decide whether to make a charging decision, which is really kind of what we're talking about, that's the appropriate place for it to be. If you go with the bill as drafted, you lose the ability for the executive director to immediately suspend somebody. That's number one. You also lose the appellate review, because if the first level review goes to the commission, there's no appellate review inside the commission, all of the work of determining whether that first passive discretion was done properly is going to happen on the ADC appeal in the Superior Court. And that's going to be much more unwieldy.
Could I ask one follow-up question, please?
Absolutely.
Can you just speak to us a little bit about the timeliness of a response to a complaint by the executive director versus by the commission as a whole? I know that you said that the commission wasn't able to weigh in on this legislation because it wasn't reached at one of their meetings. And I sense that there's a distinction there.
I'm not sure I understand the question in terms of the distinction, Senator. I'm not trying to dodge that. I just don't know how to answer it.
You want me to re-ask it?
Yes, please.
So you had mentioned that you, as the executive director, can immediately suspend an attorney from the referral list.
Mm-hmm.
And if I'm assuming, well, does the commission acts as a body, I'm assuming, and they vote on matters. Is there a delay just by virtue of the fact that they act as a commission, investing that power in the commission versus how it's currently vested in the executive director?
Yes, certainly. So things that have to go before the commission need to be, there needs to be a noticed commission meeting before there can even be a discussion among commissioners about how to respond to something. So if I got a complaint that an attorney had committed serious misconduct that warranted an immediate suspension, I can turn them off now, immediately. I give them notice of that and they can appeal that, but I can start the day it happened. Now, I haven't seen one of those since I've been here, but I've assessed several to determine whether they're at that level. If I had to bring that to the commission, I would need to notice a hearing, go to the commission, go into executive session. If the commission felt like they needed more information or there wasn't enough information, they'd have to report that back out. I have to go get that and set that up over again. Whereas if I get a complaint and it worries me, I can pick up the phone and call a judge or opposing counsel or other people involved, and determine quickly whether or not I think that there's an immediate problem that needs to be dealt with. So I think that's what you're asking. How does that? Yeah, that's definitely would be more delayed, more attenuated going through the commission as that first pass.
Thank you.
Thank you very much, Mr. Andrus. I see Representative Evangelos has a question. Jeff, if you can hold on for just a minute. I just want to say something, where I have this moment of presiding, and I say this to all of us, and I'm probably violating this as much myself as anyone else, but the public hearing is an opportunity to ask questions and not offer rebuttal. Sometimes if we do give a declarative statement, we may end it with, is that so? Do you agree? But the idea is to have the self-discipline to not have the debate during public hearing, but during a work session, especially among the members of the committee. And with that, I say that with equal treatment for all in my mind, but so I'm a little uncomfortable about recognizing the sponsor of the bill, but I understand how it can move the discussion of the issue forward. So if you have a question for Mr. Andrus, Representative Evangelos, I'd be glad to recognize you.
Thank you. Just again, we have the right to ask clarifying questions, and that's all I'm doing. I just want to know, Justin, when somebody, in this case, like myself, brought a complaint forward, and it wasn't handled right, but that's all right. What do I have a right of appeal, or does the person who brings a complaint forward have a right of appeal? And so my clarification question is, do I have a right to appeal the decision that was made in this case? Thank you, Chris.
No, you do not.
Thank you.
And I'm sorry, I'm answering quickly without waiting to be recognized, Chair. I apologize for that.
No, you're absolutely in order. Go ahead.
So the person who makes a complaint here to the police, to the Board of Overseers, generally to the Elections Commission, perhaps unless they're a candidate, but in every other venue that I'm aware of, is not a party to the action. And that's a really important distinction. It is not a civil action between the complainant and respondent attorney. And so just as You have no right of appeal if the police choose not to pursue charges or district attorney chooses not to pursue charges. Just as you have no true right of appeal at the Board of Overseers, there is no right of appeal here. The distinction between here and the Board of Overseers, and I want to just draw one thing. Some folks have used the word discipline. What I do is not discipline. That's the Board of Overseers. What I do is make contract decisions about whether I, on behalf of the agency, will continue to contract with an attorney. It is not discipline. It is a contract decision. But having said that, the chief distinction is the opportunity for somebody in the Board of Overseers, a complainant receives notice of a dismissal. They do have the right to request review by a public member who may then determine that the dismissal was an error. And perhaps a mechanism to do that, a single member of the commission reviews, something like that on request would accomplish that same function. But it wouldn't be a true right of appeal in my view. And there is not one now.
Thank you. That was very clarifying, Mr. Andrus. I'm not seeing any other questions for you, and I actually do want to give you an opportunity to get to that meeting so that perhaps you can entertain a discussion on this issue and provide for us a little bit more feedback at the work session, if that's possible.
I will try and do that. Forgive me for asking, when is the work session?
You know, does anybody have that available for us?
If it's not immediately scheduled, I can plan around it.
Yes, it is not this week, so we don't have to worry about that.
All right, perfect.
Okay, good.
Thank
all
you.
right, thank you so much for your testimony.
Thank you all.
Is there anyone else in the attendee list that wishes to speak on this issue that has not already done so? Seeing none, I'll give a last call. Is there anyone that wishes to speak on LD 348? Seeing none, I will bring to a close the public hearing on 348. Thank you very much, and I'll recognize Chair Carney to bring it to a close if she wishes.
Thank you very much, Representative Babbage, and thank you for chairing while I dashed over to state and local. So we're done with our morning's work. We'll be on recess until 1 o'clock when we have quite a significant list of work sessions to do. And I would just ask committee members to please be ready at 1 o'clock unless you have a conflict that takes you to another committee so that we can get started on our afternoon's work. Thank you, everyone. See you at 1. And please remember to turn off your audio and video during the break. Hi, committee members. It looks like a number of us are back. If you have returned to the committee, could you please activate your video so that we can determine whether we have enough folks to get started. Hi, Chris. Hi, Jim.
Hello. It was good to see Representative Thorne in the University of Maine hat by the Portland headlight. I'm a big Maine baseball follower and have one of those.
I actually, when Maine 1982 was my senior year up in Presque Isle, and I pitched a perfect game against Caribou. And I had then coach John Winkin call me up, and he asked me what my plans were after high school. And I told him I was enlisted into the United States Air Force. And he stopped his conversation right there. He said, "I wish you the best of luck, young man. Thank you for choosing to, serve your country." He didn't try to talk me out of it. He didn't try to say, young man like you pitching a perfect game of baseball, high school baseball. It had been 15 years. He didn't do anything. He just said, "I wish you the best of luck, young man. Thank you." So I always respected him for that, as much as coaches want to win, that he didn't try to twist my arm out of my plans to come to or attempt to come to Maine.
Yeah, and sometimes 18-year-olds don't know what they want to do, and you had direction. So
I did, yeah. No, it was.
Yeah.
I just wanted to see what was outside of Maine.
Yeah. Actually, Jim, that was the time when I actually got interested. Jeff Paul was the son of a fellow that I taught with, and he was on the Maine team that went 4 straight years to the World Series. And that was 80 to 84. So
yeah.
Yeah.
And then later, my brother-in-law was Brian Butterfield.
Ah, wow.
Yeah. So
wow.
I get a inside track on some great conversations about his dad, Jack Butterfield. And got to follow him for quite a few years up in Toronto and, out of the Yankee organization up into Toronto with Buck Showalter and so forth, all through the Red Sox. So, yeah.
Great.
I'm
happy
Looks
to be
like
a wannabe.
Looks like we are back. Enough of us are back to resume our work today. We are not required to have a quorum once we start our meeting, which we did this morning. Well, it looks like we just about have a quorum. Let's see. Representative Libby and Representative Poirier are available as well. I think I think it would be important to wait for just a couple of more committee members to join us, because on these work sessions we want to have good representation of ideas. So let's wait just a few more minutes, everyone. Thanks.
And I just got a call. I've got to go to state and local.
I have a bill there as well. Did your bill not get heard this morning either, Steve?
It didn't. No, they took the 5th bill first, and it set everything off schedule. So.
Okay. Yeah. Well, we'll see you when you return. Thank you for letting us know.
Okay, I'll be back.
All right, committee members, I think that's sort of an indication of things to come this afternoon. We're all going to be pulled in a lot of different committee directions. So let's just take up our work. on our work sessions. And the first bill on our work session list is LD 355. That is an act to require pest disclosures in all real estate transactions. And this is a bill that we already had a work session on. We had asked the sponsor to take some time to work with some of the people who were opposing the bill. And I see that the sponsor is available on the attendee panel. So let's quickly check in with the sponsor and then move on to our work session on the bill. Let's see. And I am not, I'm not empowered to move attendees onto the panel. Soupy, could you please bring Representative John Connor onto the panel?
I think she was already in the process of doing that.
Oh, wonderful. Thank you.
Oh, no, there he is. Okay, here he comes.
Oh, great. Thank you. Thank you, Soupy. Good afternoon, Representative Connor. We just want to check in with you. Were you able to reach an agreement with other folks, or do you have a potential amendment to present to us?
Thank you, Madam Chair. I submitted an amendment to the committee. I believe it was last night. I apologize for the late incoming amendment. And so you should all have that now. And I also apologize. I was in state and local government. I thought my bill was coming after yours. And so I was worried. But yes, we're both bouncing back and forth to that committee.
Okay, thank you. Peggy, do you have access to that amendment? Because I'm not sure that.
I do. I haven't sent it to you. I really can't send you amendments until somebody has authorized me to send it. And I don't think Representative Connor realized I was waiting for him to tell me to send it. But
my apologies.
No, my fault. I should have made clear. I had the same conversation with Representative Libby earlier today. So here it comes, and I can also show it on the screen if you'd like.
Yeah, could you please screen share it? Because I don't think we'll have, given the number of work sessions we have today, I don't think we'll have time to go back and forth to our emails.
Sure.
Thank you.
Does someone get the bill number?
LD 355.
Thank you.
So, I don't know if you want me to talk about this, or you want Representative Connor to speak about it.
Well, let me just ask Representative Connor a couple of questions. Representative Connor, is this, thank you for bringing us the amended language. We appreciate that very much. Did you reach out to Attorney Cashman and others who were in opposition to this bill? And can you report to us what their perspective is on it?
Madam Chair, I can. So I reached out to Mr. Cashman prior to the first work session, and we had discussed an alternative of putting the disclosure on the realtor's sales disclosure document without putting it into statute. That was, I'll be completely honest, that was the last contact that we had. I did send Mr. Cashman this amendment based off of the committee's remarks in the last work session about getting it out of the hazardous materials subsection and putting it into its own known defects subsection. So that's basically this entire amendment, is just to put some language. I believe it was Representative Moriarty that had spoken to the known defects part of it and wanting it to be specific to primary residence only, which that did not fit into the hazardous materials subsection.
Okay, thank you very much for that explanation and for working on the amendment, Representative Connor. We are now going to, what I'd like to do is, Peg, if you can stop the screen sharing, please. And let me just bring Mr. Cashman in from the attendee space so that we can check in with him. Mr. Cashman, if you can, great, thank you. Have you seen the amendment?
Yes, I did. I received it. Appreciate the sponsor sending it. We just got it about a half hour before this, but we haven't had a chance to look at it. And we're still very concerned about this language. It's still vague in terms of, how you define infiltration. And, the inclusion of the term primary residence in the language is also concerning. If there were other residential structures on the property, you would want to have that disclosed as well. But I think our biggest concern here is starting to add specific enumerated things under known defect in the statute. Right now, known defect is a very broad and all-encompassing term. So if you start listing things out, it could confuse things or encourage people not to disclose something because it's not already listed, even though it says, including but not limited to. So we're still very concerned with this language and would respectfully request that the committee not move forward with the bill. And, I'd be happy to propose what our language would be for amending our seller disclosure law, which we would do voluntarily.
Well, that's a little outside the scope of the work session, and we appreciate that offer. We're gonna, because we have so many bills to work this afternoon, we're gonna really focus exactly on the bills in front of us. So we appreciate
no
your
problem.
comments.
If I may, Senator, just suffice it to say then that our offer is that we would, without anything in statute, we would voluntarily modify our seller disclosure law to specifically jog the seller's memory about any insect or animal problems that have been created on the property.
Thank you.
Thank you.
Thank you. Representative Connor, I want to just give you one more opportunity to weigh in with us on your proposed amendment before we move into a motion and a vote on the bill.
Thank you, Madam Chair. I appreciate that. And I apologize to Mr. Cashman for getting it at the 11th hour, and I appreciate them reading it. My only question would be if the board is willing to put it, the disclosure on their document, what would be the harm in putting it in statute as well? That would be my only request in going forward. So thank you.
All right, thank you very much. I see that Representative Babbage has his hand raised. Is that for a question of either Representative Connor or Mr. Cashman, or no? Okay, so I'm going to move them both back to the attendee space. And then I'll recognize you, Representative Babbage.
Yeah, thank you, Madam Chair. I appreciate very much Representative Connor bringing this forward. And I understand the concern, but I have had reservations about moving forward on this bill because I think documentation of animal or insect behavior regarding the residents could be a gotcha kind of thing if something is omitted. And I don't think, I think the inspection process and the question and answer process between seller and buyer and their representatives is important in satisfying the buyer. But I really do not want to provide a platform for what in some cases could be frivolous litigation. And so that's where I come from. And I would like to move that we pursue a ought not to pass report.
There's an ought not to pass motion. Is there a second? Seconded by Senator Keim. Committee members, is there any additional discussion? I am not seeing any additional discussion. And I did want to, as we move on to the vote, want to express thanks to Representative Connor and Mr. Cashman for thoroughly vetting this issue for us today. And with that, our committee clerk has magically appeared. And I think that we're ready for the vote, Soupy. Thank you.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Moriarty. Representative Moriarty is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, 4 are absent.
Thank you very much, Ms. Panett. So the vote is 10 in favor of ought not to pass and 4 absent. And with that, we'll conclude the work session on LD 355 and move on to our next work session on LD 478. Representative Babbage, your hand is still up. I just wanted to check in with you. Oh, great, thank you. This LD 478 is an act to establish a fund to compensate unjustly incarcerated persons. And Peggy does have an analysis for us. And Peggy, if you could take us through sort of just in light of the number of bills we have, the analysis, maybe a higher line review, and then we can ask you questions about the specific things that we're most concerned about.
Thank you.
Thank
So
you.
there is an existing program to provide compensation for people who are unjustly incarcerated, but it requires a pardon from the governor, as well as a statement by the governor that the person is actually innocent. And there have been no applications for this since it was enacted, so we have no fiscal information about it. So this bill would replace that process and would require for a claimant to go forward and to seek compensation. The claimant would have to establish by a preponderance of the evidence, so just more likely than not, that one, the person was convicted of murder or a class A, B, or C crime, and then subsequently in prison, so they had to have actually spent some time incarcerated. Then the conviction was reversed or vacated, and either the charges were dismissed or on retrial, the person was found not guilty. Then the person also has to show, this is by a preponderance of the evidence, that they did not commit the crime or the crimes for which they were convicted. And that includes not being an accessory or an accomplice to the crime. And then the last one is that the person did not commit or suborn perjury, fabricate evidence, or by the person's own conduct bring about the conviction. So if all those steps are met, then the person is eligible to apply for compensation. And the way to get the compensation is they would file a claim with the district court within 2 years of the dismissal of their criminal charges or the finding of not guilty. And it would be a finding of the district court that the claim, although the person could ask for a jury trial, in which case it would be transferred to the superior court. And then the bill would establish a compensation of $50,000 for each year of imprisonment and $10,000 for each year served as a registered sex offender. If the defendant had actually already received some kind of settlement for the wrongful imprisonment, then that would be deducted from whatever would be paid out of this fund. What's not identified as the actual source of the funds, other than I think that what we call the cascade, but because we had no information under the existing system, we really don't have any information right now about how many payments there would be, and so what the cost would be. I know the Criminal Law Advisory Commission, there was kind of a split decision. They testified neither for nor against, and they identified a couple of issues with the bill, but also the Representative Evangelist provided a lot of information about what the other states are doing through the Innocence Project. Innocence Project identifies 35 states in the federal government with compensation programs. They have different levels of what the process is for people have to go through. If you have my bill analysis, we did link that. We also put the chart in the electronic LD file. And so there's a comparison of those compensation programs. Representative Evangelos provided lots of information about different cases in other states. I think that's all I need to say, but I'm happy to try to answer any questions.
I did want to ask you to do a kind of a slightly deeper dive into the constitutional issues and the concern that that this statute would take away under Maine's constitution. The governor has the exclusive right to issue pardons. Could you comment on that a little bit, please, Peggy?
So I think this raises, this is a little bit different because what's happening is the person has their conviction vacated by a court. The court has actually said this was a wrongful conviction, and so the person was wrongfully incarcerated. So it's not that the governor is pardoning somebody or reducing their sentence. It's the court reversing the judgment of the court. So I realize why somebody would raise that question, and I suppose you could always raise that question, but I don't think it rises to the same level when we talk about expunging criminal records. This is saying the person actually did not commit the crime. And if you remember, some of the testimony was that at least the practice for the past many years, in order to get a pardon here in Maine, somebody has to show remorse and show that they've changed, which doesn't mesh with somebody claiming that they are actually innocent. And so it's a different process than a pardon.
Thank you very much for addressing that. Senator Kime, you had your hand raised and I kind of jumped in there and asked a question. Go ahead.
Thank you, Madam Chair, and no problem, because I did have that question among others. But the bill actually, just to follow up on that one before I move on to others, Peggy, the bill actually does say a certificate of innocence. And so I guess I can see that it's not the same as a pardon, but how does one prove innocence? Because a pardon doesn't assume that a person is innocent. It's just sort of like blanket forgiveness. But how does one prove innocence? Because one of the things I find about number 3 and 4 is that exactly, how do they prove they did not commit the crime and therefore that they're innocent?
And that is the question that the some folks on the Criminal Law Advisory Commission raised, which was you say you didn't, and you prove that by a preponderance of the evidence. I don't know how easy it is to do that. That is actually fairly common in other states, that is one of the things that they have to prove. I don't exactly know what that process would be like, other than unless you can point to somebody else who was probably the perpetrator.
And so then I guess if you're going to point to somebody else who was the perpetrator, then other than that, I mean, so proving your innocence means you have to have another trial. Is that how you would assume it?
In so 2 is the conviction was reversed or vacated, and either the charges were dismissed or on retrial, the person was found not guilty. So the court has determined that the person is not guilty, court with a jury, if it was a retrial with a jury. And then 3, the person is still proving this by preponderance of the evidence, that they did not commit the crime. They were not an accessory or accomplice to the crime. And I know that's one of the issues that Clark had raised. And so that's, you either have to have the charges dismissed, the conviction vacated, or on retrial found not guilty.
Right. And so not guilty doesn't necessarily mean innocence either. So I'm trying to figure out like how this all works together. It doesn't make sense to me, practically speaking, but I will let other people ask questions. But my last question just for the moment is, when you list 1, 2, 3, and 4 in the bill, the only "and" in there is after number 3. So can you help me understand, does that mean that under this bill, they have to establish all 4, or it's 1 and 2 and 3 or 4, or is it all 4?
Right, they have to establish all 4.
Okay, so should there be an "and" after 1 and 2 or no?
Not in our drafting protocols.
Okay.
So if these were alternatives, if you only had to prove 1, we would say "or" in that situation. Or if you had to prove 1 and 2 or 3 and 4, then we would structure it very differently. It would be very clear. When you have an "and" in this list, it means all of them are required.
Understood. Thank you for clarifying that.
Representative Evangelos, I know you have your hand up. Is it for a question to Peggy, or did you want to speak on the bill? Because I'd like to get the questions for Peggy on the table initially.
Well, I wanted to, is my mic on?
Yep.
I wanted to respond to the line of questioning with Peggy that just occurred and provide a clarification.
Okay. Let me just ask you to hang on then for a minute, because I want to see if Representative Babbage has another question for Peggy, and then we'll come back to you. Representative Babbage, did you have a question for Peggy?
Yes, Madam Chair. A quick one. I just wondered regarding preponderance of evidence. Is that a standard that's used in other states?
I think it is in some of them. I must admit that is not a question I've looked at. I'm pretty sure that I've seen that in some of them. And I couldn't tell you if it's clear and convincing in others. I'm sorry. I can go back and look at that if you want.
Anything else, Representative Babbage? Okay, Representative Evangelos, go ahead.
Thank you, Madam Chair. Just to answer Representative Babbage's question, the model that I used came from the Innocence Project. They helped me develop the language from the previous session, and they based it on many of the laws in other states that use the preponderance of evidence. But I want to remind the committee of something. I think we all need to keep this in mind. It is not predicated on a criminal defendant to prove their innocence, and that is not a standard we ever place on anyone. It is the prosecution's and the court's duty to find somebody guilty beyond a reasonable doubt. And there's a big difference there. You're not guilty or charged. There's an assumption of innocence in our country. And so that's why in some of these exoneration cases, the prosecution will simply just drop the charges and walk away. The only point where this word innocence comes in is on the last page of the bill, that if the court finds the claimant is entitled to the compensation, they issue a certificate of evidence to set the process off. But we are not requiring a criminal defendant in any of our court proceedings to prove their innocence. That's something that a jury adjudicates on, or a judge in the case of a judge-only trial. So let's keep that in mind. You are innocent in this country until proven guilty. The burden is not on a criminal defendant to prove that. The burden is on the prosecution to prove that you're guilty. So I don't want to get hung up on that word innocence. We have heard multiple testimonies, mostly with indigent legal, and from some pretty credible people, including Walter McKee, Robert Cummins, and others, that it is their opinion, and Walter couldn't elaborate because of his attorney-client privilege, that we have innocent people in prison. And we have a process currently under our Maine law that allows no recourse. Senator Carpenter, a former attorney general, was the one that said we need to get rid of the word pardon in there. It's not necessary. And Peggy gave the proper analysis. We are not taking away the governor's pardon authority. There's nothing to pardon if you've been exonerated. When you've been exonerated, you've been found not guilty, that the prosecution didn't meet the burden, and you've either been exonerated or freed by the prosecutor because they don't want a new trial on appeal was granted and the prosecutor throws the towel in. This happens to be happening, by the way, all over the country. The images are clear. The prosecutor, the defense counsel, and the criminal defendant, or the person in prison, appear on the front steps of the courthouse and they say, today we got it right. The prosecutor admits that the mistakes were made. And we also provided volumes of evidence that in over 50% of these unjust incarcerations, that police and prosecutorial misconduct were involved in it. And so I was hopeful, and Senator Kine, I was really hopeful that we could get to a unanimous report on that. And I know the hang up 2 years ago was the amount of money. And I mean, if it would help, you know, I don't want to change the compensation rate, but if it would help the Republican members who have misgivings, you know, I'd be willing to go down to $30,000, but I'm not willing to surrender any of the language. I know I saw the amendment that was put in. I think it was $550,000 or $500,000. So, you know, let me get this straight. You serve 30 years in prison for something you didn't do. You're exonerated through our courts, and you're entitled to $15,000 a year for missing the funeral of your parents, for missing the education of your children, for missing your relationship with your husband or wife. That is just not adequate. That's not even minimum wage. Minimum wage now is 20 grand. So I would throw that out there, but other than that, I'm sticking with the language of the bill and everything as it's written.
Let's give Senator Kime an opportunity to respond to your question. Would you like to respond, Senator Kime, or?
Sure. So I have no issue around the minority report we had last time, which was it did cap it at 500,000, and I want to make sure that there's compensation for people that are unjustly incarcerated. What I am struggling with is the process that we're getting there. I understand, you know, as the sponsor of the bill, and then this is your passion as well. You have a lot of knowledge, but I also have to make sure that I get my questions answered as well from other perspectives than only yours, in order to understand my own vote and where this needs to come from. So I do have more questions. And I mean, one of the other concerns I have is that just because just because there's a change in findings doesn't necessarily mean a person is innocent. So I question the ability that if a claimant is entitled to judgment, that then they get a certificate of innocence, because those two actually aren't the same. So we're just saying, okay, because they can also have their conviction vacated because there was a mistake in process and in other reasons. So then we're equating the same. I don't know how that's possible. And then I also don't read the language here when it says they did not commit the crime or the crimes for which they were convicted, and you're saying they don't have to prove that. I agree. In our country, you're innocent until proven guilty. But then how does this get proved? How are we proving that they didn't commit the crime or the crimes of which they were convicted? And how do they get in this pipeline? How many people are going to go through and, based on the preponderance of the evidence, do this? I don't understand that part. So I don't know, Peggy, if you're the right person to answer this or who is. It seems to me, even if a jury finds someone not guilty, that doesn't necessarily equate with innocence either. But be that as it may, how do we get to this process?
Is that something you want? I mean, I can, I think the term innocence is what seems to be tripping you up.
Partly, but then also the process ahead of time, like, how does this happen? Like, how does someone make the decision how does it get found that a person did not commit the crime or the crimes which they were convicted for?
Before this even applies, the person would have to have their conviction either vacated, reversed, and the charges dismissed, or they were found not guilty on retrials. So before this even applies, that criminal justice activity has to have happened. Once they go through that, and you might be able to find numbers of how many people are actually in that situation in Maine, then this would kick in and they say, okay, I've met number one and number two. I was convicted and now my conviction's gone. It's been vacated, reversed, whatever. So now I have to decide if I want to apply and do 3 and 4, also apply for compensation, do 3 and 4 work in my case too. So if they were convicted of a class A crime, but they were convicted of a lesser crime that was part of it, then they're not gonna, I don't think they're going to be able to apply under this. So convicted, it's been reversed, vacated, or they had a retrial and they were found not guilty. So now they're kind of put in the shoes of somebody who hasn't been convicted. And so I think what Representative Evangelos is saying is they don't have to prove their innocence so much as the state has not carried its burden of proving that the person is guilty for whatever reason, whether it was because it was vacated or there was a new trial. So I don't think you actually get to the term innocence until they've been through the process and the court has awarded them compensation. And now that the court has awarded them compensation, part of that is a certificate of innocence. And I didn't realize that expunging the records was there too, and we might need to word that a little bit differently in order to make it clear that the records are, the person's been exonerated, as opposed to the records being erased, because I think that's where there's a concern. But anyway, That, I mean, that is really a technical issue, but that's where the certificate of innocence is. They don't have to prove that they're innocent. They have to prove that they did not commit the crime. I mean, they have to show that they did not, by a preponderance of the evidence, that they did not commit the crime.
Can I jump in with a question? Just Peggy, and is that something that happens in a district court action that is brought?
That's my understanding, is that the person files in the district court, and if they want a jury trial on that question, it can be moved to the Superior Court. I'm not really sure how that works with the Uniform Criminal Docket anymore, but right.
Okay, thank you. Go ahead, Senator.
So they would go to court asking for a jury trial on whether or not they committed a crime, or is that in step 2, you mean?
That's step 2. That's after they've already been exonerated. They no longer have a conviction. And so now the question is, are they going to have compensation for the time that they've been incarcerated or on the sex offender registry?
So, so number 3, then, if they were charged with and convicted of rape, say, and then it was, something was found legally as an issue. And so then rather than retry the whole case, they get offered, or they are charged then with assault, but they've spent some time imprisoned for rape. This wouldn't apply. Is that right? Because they're still guilty of something, but not the original charge.
I don't think it's written that way. I think it's written that if they were convicted of burglary because they drove a car, so they were an accomplice to that, so accomplice liability, so they can prove that they didn't engage in the actual, breaking and entering with the intent to commit a felony, they wouldn't be eligible here if what they're saying is, well, I didn't get convicted of the burglary. Yes, I was driving the car. 3 says, no, you can't be an accessory or an accomplice to that. I don't know. I mean, maybe I described that incorrectly about if you're talking about a rape versus an assault. I don't think that would fall into this, but I'm not really sure.
Right. Well, yeah, I guess what I'm, I kind of just wanted to understand that more, because, there can be mistakes made, obviously, which leads to imprisonment, which shouldn't at all. And then there's mistakes that are made that, just makes a case not as airtight. And so they change what they're moving forward with for for a conviction. And so I was just so are you saying then that if they're convicted of something still, that this doesn't count, that it would sort of eliminate them from this process?
So
or you don't?
It sounds like what you're asking is, if somebody's been convicted of a Class C crime and they appeal it and it's been vacated or reversed, but they do find them guilty of a Class E crime instead, that conduct rose to the level of a Class E crime, would they be able to do this? I don't know. I mean, part of me says yes, because they were convicted of a Class C crime and they spent time in prison for that, and they have since been found not guilty of that Class C crime.
Is there someone like the judicial branch or something that could look at this law and give us a more definitive answer on that, on how they would read this law? Right.
Perhaps Representative Evangelos has answered this question before. I'm looking at subsection 2, which says concurrent sentence. So a person is not entitled to compensation for any part of a sentence of imprisonment during which the person was also serving a concurrent sentence for another crime to which subsection 1 does not apply. So I'm wondering if that can be interpreted to say, okay, you were serving time for this Class C crime. That's been vacated, but you've actually now been convicted of a Class D crime, which doesn't make you eligible for compensation. So that might actually say you would not be eligible for compensation if that's the amount of time you would be spending incarcerated for the Class D or the Class E that you are eventually convicted of. But you know, part of this is if the prosecution didn't put the whole case together correctly and prove every element beyond a reason, beyond a reasonable doubt, and met all the evidentiary and prosecutorial requirements, then the person was not appropriately convicted, and therefore they could be eligible for compensation.
One other question, and then I'll just simmer on this a little bit. But in one, it says was convicted of murder and subsequently imprisoned. And how broadly interpreted would that word imprisoned be? Would it be detained, jailed? Do they have to be sentenced and imprisoned? Just wondering how broadly that is. It very narrow? Is there's someone sentenced and imprisoned, or what would that be?
Right. Imprisonment means a term of incarceration, and that's paragraph A says the person has served in whole or in part a sentence of imprisonment. So there are sentencing alternatives, but I don't know that imprisonment would be interpreted as anything other than being, in a secure facility.
Okay. And not just being detained, though.
No, well, you're usually not detained after you've been convicted.
Right. Okay. Yes. Thank you.
Thank you. Representative Babbage, is your hand up with a question?
Yes, it is, and it's an easy one for Peggy.
Oh, I love those. Thank you.
On page 3, line 40 is 22108, exceptions to immunity. And it does say the state is liable as provided in this chapter. I just wanted to make sure that's not an expansion beyond. I mean, could somebody sue for damages above and beyond compensation?
No, well, I think what that's saying is you have the Tort Claims Act, which would probably make the state immune, but this says we're going to waive that immunity just for the purposes of this compensation. So that would be the limit of the liability. I mean, unless there's something else that the Tort Claims Act is going to allow, but no, I think that's it. It's a narrow exception, and it's just for compensation under this statute.
Yeah, I understand that's probably the intent. I just wondered if those words meant that additional litigation couldn't be brought for the same injustice.
I think that this is intended to be the only remedy for unjust incarceration. I mean, there might be some other claims that somebody might be able to impose cruel and unusual punishment or something like that. Some kind of civil rights violation, but for the unjust incarceration tort.
So this is a section that is merely seen necessary to enable the rest of the bill.
I believe so. I mean, I think we've seen other situations where the legislature might have thought there was an opportunity for the state to be pitching in on some kind of compensation, but without actually saying we are waiving the immunity of the Tort Claims Act. The court might interpret it as
Gotcha.
That's not a waiver.
Thank you very much. Appreciate that.
Representative Libby?
Thank you, Madam Chair. My question is, I'm trying to get this concrete in my head, how this works. And so my question is, and I'm going to use a really extreme example, but let's say someone did murder someone and they are convicted of the crime, but their case is found, the evidence was handled incorrectly and their case was vacated. Would that person be eligible for this under this bill? Or would they not be able to under number 3?
You're right. 3 the person would have to be able to prove by a preponderance of the evidence that they did not commit that crime.
Okay.
They did not commit murder.
Okay. So would that be different than in the trial where they were convicted, but that evidence was deemed unworthy to hold the conviction? What is the evidence that can be used to prove that they did not commit the crime, and could this be worked for nefarious purposes is my question.
Right. So if the conviction is vacated,
yep,
because there was prosecutorial misconduct or bad evidence, there could actually be a subsequent trial, usually, and they can correct those on the retrial. If there's an acquittal, double jeopardy steps in and they can't retry. But in all those other circumstances, they can usually retry the case if they want to. And if they believe they have the evidence to prove beyond a reasonable doubt that the person actually did commit the crime. So, I mean, there are certainly situations where there have been convictions that have been overturned. And then the prosecutors say, okay, we've got this figured out, and we'll go back and we'll retry this case.
Okay, thank you.
I'm muted. I would like to interrupt just for 1 minute. I am being called to state and local government to present a bill. And this is a really important conversation that I would really like to continue to be part of. I also sense that maybe this might be a good time for people to caucus if they wanted to. So could we take a brief
Point of
recess?
order. I mean, isn't it customary to recognize the sponsor to speak on bills? I mean, we just recognized, a sponsor when we get mice running around houses, and I don't feel like I'm being given an opportunity to speak and answer some of these questions. I'm the bill sponsor, and before we take a break and caucus, I would like to address the concerns. You haven't even heard from me, really.
I thought you spoke extensively twice already.
I didn't speak
I also
extensively at
think
all,
that
briefly.
Peggy's role as a legislative analyst is a little bit different from the bill sponsor. And so I think it's fine for committee members to ask her questions.
I do too. I would like to respond to a couple of the concerns because Peggy said perhaps Representative Evangelos has some answers he'd like to provide, and I do.
Can you, is it acceptable to you to wait until I return from presenting my bill in state and local, or do you want to do it right now? I can hand the chairmanship of the meeting over to Representative Babbage if that is the desire of everyone on the committee.
Well, we don't take votes on committees to allow other sponsors to speak, so I'm not going for that. I would just like to speak for 2 minutes then before you leave, because I want you involved in the conversation.
Okay. I do need to leave. I'm going to let Representative Babbage take over the chairing the committee, and I will return everyone as soon as I am able to. Thank you very much.
Okay, thank you, Senator.
So am I recognized to speak? I thought I had the I mean, if you're not going to allow a sponsor to speak on a bill, that's pretty bad precedent to be set. When
Representative Evangelos, don't predetermine what's about to happen here. I'm just smiling. Your hand and my hand is up. I don't need to ask my question right now, and I certainly would like to hear from you. And if we do caucus this, we will certainly share your points if we have a summary representation at caucus. So yes, Representative Evangelos, what would you like to tell the committee?
Thank you. Well, I wanted to back up what Peggy is saying. and respond to Senator Keim and Representative Libby's legitimate concerns. First of all, if the state has made some procedural errors on trial and something is thrown out and the state believes they still have an excellent case, I will guarantee you in every single occasion in the history of this state, a new trial is held and the charges are brought forward. The fact is, because of the weakness in our post-conviction law, which we're going to handle on a different day in this committee, the people who were involved in this last session know that we have a very weak post-conviction ability to bring evidence forward. We've never had a significant felony exoneration in the history of the state of Maine, not one, a couple of minor ones. So in the case of procedural problems on the prosecution side, they just will bring, a new trial will be brought forward. The other thing I want everyone to understand is we're only talking about a very, very few people. 90% of the people or more in the Maine State Prison took a plea deal. They pled. They're not eligible to proceed on this statute. There's a few people who have maintained their innocence, and they're the only ones who would benefit from this if they went through a post-conviction appeal process and were found exonerated or not guilty because of a reasonable doubt. And then that would set this process off. So there's plenty of safeguards in the bill and in the process. The prosecution will always bring charges forth if there was just a procedural error. If they have the evidence, they're going to bring the charges forth. They always do. And again, we're only talking about a few people who pled innocent and have never changed their story. They still have to go through a post-conviction appeal and overcome the burdens that are in our laws to get exonerated. As Mr. McKee said, we're probably talking about 3 or 5 people, and the other states have not been, their systems haven't been overwhelmed with these cases. But I think the other thing that we're not considering, you know, the problem with human nature, and we're all guilty of it, me included, you know, until it happens to you or someone in your family, you've got a son or a daughter who's innocent and sitting in prison, the enormity of it just doesn't become real. It's like it has to happen to you. And when it does, and these families that I talk to, you know, it's destroyed them. And we heard that from Sanborn and his wife. So I just wanted to get clear on those points. Unfortunately, there's this caucus process that's going to go on, and the bill sponsor's not involved in it. So I'll sit tight and let you do what you have to do. But if I'm not going to get to a unanimous report, you know, I'll just, you know, have to do what I have to do. Hopefully we'll get an ought to pass. And with that, I will leave it to the chair. And if I need to speak again, I'll raise my hand.
I appreciate that. Thank you very much, Representative Evangelos. Are there questions actually for the sponsor from the committee? Is there any request for information by anyone? I'm sorry, Senator Keim. I'm sorry, I have the attendees up here. My mistake. Senator Keim, go right ahead.
Thank you. Yeah, so Representative Evangelos, you said a couple of things that are different than what CLAC had said. One of the concerns they brought up is that one of the objections they had was that was the apparent availability of compensation to someone who pled guilty in the first instance. So are they reading the bill wrong? Because you're saying that if someone pled guilty, they aren't eligible for this.
Correct. If you pled guilty, you're not going to be able to file a post-conviction appeal. You pled guilty, you're out. You know, you don't qualify. This bill only applies for people who asserted their innocence at trial and who lost their case and were incarcerated. Can
you show me in the language where it says that?
I'm not sure I can find it right now.
Oh, well, maybe Peggy can. We can just wait on that one. But let me follow up with one other if I could.
But I just want
The
to
other
know that
thing is that they asserted that it could potentially lead to a large number of frivolous claims. Whereas you're saying it could not, which it may be partly a misunderstanding that they're assuming that people who pled guilty in the first instance can then still move forward with this. And you're saying they can't. So maybe that's part of it. But what else would they be looking at that would lead to a large number of frivolous claims? Because that's the other part that I'm concerned about as well.
Well, we did handle that in the last session, and Mr. McKee did speak about it. There are no frivolous claims. Again, the only people eligible to even pursue this are people that pled innocent, were found guilty, that brought new evidence forward, overcame the hurdle for a post-conviction review, and upon adjudication of that post-conviction review, were granted a new trial. And then subsequent to that, if the new trial resulted in your exoneration and freedom from prison, that's the threshold that we've dealt with around the country with all the other states. It's the same here. If you pled guilty, you're guilty, and that's the end of the road. You're not eligible for this bill in a guilty plea, so you're not going to get frivolous appeals. You don't have an avenue. You pled guilty. What are you going to do? Tell the judge I pled guilty and I changed my mind? It doesn't work that way. So good question, but no, the other states are not experiencing any frivolous claims. And let's face it, the National Register of Exonerations and the Innocence Project has documented hundreds and hundreds of cases. And we just saw one last week again. A guy that did nearly 50 years down south, an African-American man, was freed for something he didn't do. So yeah, that's the answer. You pled guilty, you're not eligible for this process.
So if I might suggest, I know that Senator Carney wanted to be part of this discussion, and I think it's important that she is, and I do have more questions and I would like to caucus, but I feel like I don't quite have enough information to caucus with effectively at this point, but I hate to gather more and more of it and then leave Senator Carney out. So I don't know if we would want to pause or to move on to a different bill or something to respect her request to be part of this, or what the committee feels. But as I put that out there, I'll also ask Peggy if in the interim, I tried to look and see if John Pelletier was part of today's meeting, but I didn't see him in the attendee list. But I would be curious to know if, when Clack raised those two concerns that I just asked Representative Evangelist about, if they were misreading the bill, if we could just have a little clarification from him on that. Maybe you have time to shoot them an email and get a response on that as we're still discussing this. And then one other further thing, just yeah, Representative Evangelist, I think this is an important bill. I thought it was an important bill last session. I need to just make sure that when I'm voting on, I understand the process, and that I'm sure of myself. And then, of course, all of my colleagues who will also expect me to do the right thing here, because they expect me to do my due diligence in Judiciary Committee. So that's what I'm doing. It's not that I don't, I see the need. I just need to make sure that the process is one that I understand and I can get behind. And that my vote reflects that. So with that, I think, Mr. Chair, if you just want to weigh in on our waiting or not waiting.
Well, I understand that, and
Thank you, Senator Khan. Yes.
Is there a question, Chris?
Sure, Representative Evangelist, go ahead.
I understand that, and I understand that neither of our chairs are here today, and also I think it'll be worthwhile to continue the discussion. With Senator Carney, in respect for her, has asked for that. And we have a ton of work to do today. And I would think when we revisit this, we'll get Mr. McKee to join us, because I think he gave the critical testimony that countered the points that Clack met. So with the committee's leave, and I don't want to cut Representative Hagan off, because I know a tabling motion is non-debatable. So Mr. Chair, I am prepared to make a tabling motion, but not until my colleagues have been heard.
Okay, thank you for that, Representative Evangelos. I have one question, but Representative Hagan, did you want to continue?
I was just going to, out of respect for Senator Carney and Senator Kime's wishes, to get it right on this bill to table until we can handle it in full strength. Because
Right.
I also thought it was a great bill, worth looking at last time and this time.
Representative Evangelos, I have one question that I don't think is too complex to ask you before we depart, because I know the Innocence Project has done wonderful, significant work all across the country, and they've identified a system that has not served among especially for minorities or low-income folks, but they've identified a system that's very unfriendly to them. But in trying to correct, I don't want to overcorrect. And one thing, the word innocence, certificate of innocence, the way I look at it, presumption of innocence is extremely important, but it is different than a declaration of innocence. And so to issue a declaration of innocence through a certificate based on preponderance of evidence and not a higher threshold is a low bar and to me potentially inaccurate. And so I'm mulling that over, and I just want to give you an opportunity to react to that if you wanted to before we go on.
Sure. I know that there's a process that sets off something called a certificate of innocence, but it's only after the court has found that you're entitled. The court has made its ruling, and then this is an application that you make to set the process off. We can take it up in work session if you would rather get another term in there. And I'm open to all suggestions. I understand inserting the word innocence in there, raises a concern. But keep in mind that in this country you are innocent until proven guilty, and the burden here is the court has found that you've met the burden, and therefore they're issuing this certificate. And it's called a certificate of innocence used in other states. It's a word, but what it means is that the state didn't meet its burden, that you were innocent, exonerated, or not guilty by because of reasonable doubt.
Right. Thank you so much, Representative Evangelos. Appreciate that. With that in mind, Representative Hagan, did you want to make a motion?
I do. I make a motion to table this. Thank you.
And is there a second? Thank you, Senator Kime. I think on a tabling motion, I can do that by a show of hands. So all those in favor of tabling LD
478.
478 is right. Yeah, thank you. 478. Until later in this session. Thank you. And it looks unanimous, I think. Thank you, sir, very much. What is the will of the committee here regarding, do we want to recess briefly, or do we want to go on to LD 448? What is the will of the committee here?
Well, Mr. Chair, I think Senator Kime and I had hands up. I only have a quick question. May I?
Go ahead, Representative.
Is it, Peggy, is it my job to ask Walter McKee, or is that something you do as the analyst to appear next time?
Oh, you can request it.
I can reach out to him.
Okay, I will too, but I would appreciate if you do that for me. Thank you. That's all I had.
Sure. Well, regarding 478, right?
Yes.
So Not seeing, oh, I'm sorry, Senator Khan.
My hand is hard for you to see today, I think.
I'm sorry about that.
So I was going to make a suggestion that we take bills out of order and maybe deal with one that was easy, and then take a caucus break after Senator Carney is back, so that if you guys did want to caucus, you would be together rather than not having her with you. But an easy bill, I think Senator Carney and I had chatted about earlier, was LD 560. And I didn't know if maybe we wanted to take that one out of order.
Without
Because
objection? Is there anybody that objects to taking a LD 560 at this time?
Is there a reason? Sorry. Is there a reason why we wouldn't want to take up 448? Because it might also be relatively straightforward.
Okay. 448 is next on our agenda.
Unless I have the wrong one.
Recording of witness interviews. Is that what you're talking about, Representative Sheehan?
Yes.
So you are objecting to 560 going out of order. Might as well continue on if you think that might be straightforward as well. If
Does
that's
anyone else have any thoughts on it or want to contribute why 448 would not be, why we would take that one out of order? Is it because, I mean, I just thought maybe Senator Carney would want to be present for that conversation, but could be wrong.
Senator Carney maybe want to be present for which conversation? 560?
For 560.
Okay, okay. Well, if you don't mind, Senator Carney, let's go ahead with 448 and introduce that one. Is that possible, Peggy, that you could give us a analysis?
Am I on? Yeah, LD 448. So for LD 448 is actually a repeat of LD 801.
Point of order, please.
Representative Libby.
I apologize, Mr. Chair, but myself, Senator Keim, and Representative Moriarty have all had our hands raised to speak to going ahead.
I'm so sorry. Yes, go ahead, Representative Libby.
Thank you. Given Senator Keim can speak to having had a conversation about 560 with Senator Carney, but I think that the bill that we're looking to address, 448, is one that may seem very simple on the surface, but that there may be a good deal of conversation about. So I would request that we, Senator Keim can speak to the conversation that she had with Senator Carney.
Okay. Senator Keim, do you want to share what you shared with Senator Carney?
Yes, absolutely. And we had chatted briefly about 448, and I do have a few different questions around that. So I think it is going to be a little more lengthy, and I think it might be best if she was here for that, which is why I had suggested the LD 560, because I thought that one, we were all generally in agreement on that. And so I thought it would be, something we could sort of take on and then set aside. But I'm happy to even take a break if the committee would prefer that. We could take a break right now as well.
Representative Sheehan, does that satisfy your concerns, or what would you rather do?
Yeah, I just wasn't privy to the conversation, so I'm fine with it.
Well, let's move on. Let's move to LD 560 unless there's opposition to do so. We could have a vote on procedure here, but I don't think that's necessary. So Peggy, are you prepared to give us an analysis of 560?
Yes, I am. Oh, and your committee clerk is raising her hand.
Yes, ma'am.
I apologize. I have a lot of sponsors that want to be contacted, and the sponsor for LD 560 wants to be sponsored. So if you need somebody, I just need to call them.
Okay, Representative Corey is actually in the attendee list.
Oh, excellent. Oh, that works out perfectly. Thank you.
Thank you for that, and thank you, Representative Corey. Okay, you may proceed, Ms. Reinsch. Go ahead.
Thank you. So Maine has what's called a safe haven law, which allows, so generally it's a crime to abandon your child, but there is an affirmative defense for relinquishing your child, surrendering your child to specific safe havens, and they're listed in the statute. And so they're listed two places. One is the affirmative defense in the criminal code, but the other is in Title 22 under the Child Protective Services Act, which says here are the people who can appropriately accept an infant. Has to be under 30 days, 31 days old, I think. And although the person who accepts the child can't really track the person who's relinquishing the baby, they can ask for information. So that information is collected about the infant and can travel with the infant wherever the infant goes to a foster home or adoption. So what this bill would do would be to add one more kind of category of where the child can be relinquished without being seen as abandoning a child. And that would be using what's called a safe haven baby box. Other states use them, have different terminology for them, but the idea is a device, a drawer, or something that allows a person to place the baby safely in and retain their anonymity about dropping off that child, and that child is in a safe place, and it's in a safe place where there are medical providers available and can respond to the relinquishment or the surrender of the baby. So that's what this bill does. There are a few other states that have adopted the statute. There are actually some states that have allowed the construction of the infant safety devices, as they're called in some places, even without a statute that authorizes, that says that this is part of their safe haven law, and there are some bills pending. So what the bill specifically does is it includes, right now, it just includes surrender to a law enforcement officer, staff at a medical emergency room, a medical services provider, a hospital staff member at a hospital. It adds in a firefighter at a fire department facility into the affirmative defense in the abandonment of a child statute. And then it amends the Child Protective Services Act to include a firefighter as somebody who can receive the child, and adds in a person staffing a facility with a safe haven baby box. And it defines safe haven baby box, and Representative Corey has an amendment, and Representative Libby asked that I distribute it because she's going to offer it in the work session. So a safe haven baby box means a device or container to safely accept delivery of a child less than 31 days of age. That is, 1, voluntarily installed by a medical services provider, law enforcement agency, or fire department. 2, physically located inside a hospital, law enforcement facility, or fire department facility that is staffed 24 hours a day by a medical services provider. And 3, located in an area that is conspicuous and visible to the employees of the hospital, law enforcement agency, or fire department. One of the people that testified or that sent in testimony noted that you might need some parameters on what that actually is, because anybody might want to pitch in and provide this without meeting any kind of requirements. And so if you want me to go ahead and talk about this, Representative Libby, I'm on a roll.
Well, thank you,
Keep on
Peggy.
rolling, Peggy.
Okay, I'm sorry. So rather than putting dimensions or requirements in the statute, we referenced compliance with requirements adopted by DHHS. And some of those requirements would be that there would be that there's an alarm, there's somehow somebody's notified when a child is placed in this device, and that there's also notification to a 911 dispatch, and that the department has the authority to adopt rules to ensure the safe design, installation, and use of these. So, I mean, there were some questions raised about whether the language says that this has to be located in and physically located inside a hospital, law enforcement agency, or fire department, and maybe that's a little too restrictive because it means that somebody has to come inside. But I mean, those are just some of the issues that you can work out if you want to go forward with this.
Thank you very much, Peggy. Representative Record, did you have a question? Representative Record?
Sorry, I was saying I don't have a question, I have a motion.
Okay.
And that motion is ought to pass as amended with the verbiage that Peggy just articulated.
Is there a second?
Second.
Thank you. Thank you. I think I saw Representative Libby's hand, so I'll take that second, although I think that was not her voice. So thank you very much. Are there questions? Peggy, I'm sorry, Representative Moriarty.
Thank you, Mr. Chair. I have a slight language change to suggest to the amendment. And specifically, these subparagraphs 1, 2, 3, and 4 all refer to fire department. And then the second paragraph under number 4 says the department shall adopt rules. Well, I wondered what department that was. The summary says it's the Department of Health and Human Services. But with all the repetitions of the term fire department, I'm just suggesting for the sake of clarity that the second paragraph under number 4 in parentheses should say the Department of Health and Human Services to distinguish it from one of the fire departments listed in the previous paragraphs.
That seems like a friendly amendment. Is that okay with Representative Libby and Representative Record?
Yeah, I assume that it sounds sort of like language review to me in a way.
Let's just do it now.
Yeah, fine. I do have a question for Peggy. Just for a clarification, I like the intent of this bill, but I just wanted to say, question that the implementation of this procedure is voluntary on the part of any municipality. Is that right? It says voluntarily installed, but I wanted to make sure that and I think that implies that it's a voluntary decision, not just the process of installation. But would you agree with that, or does that need to be clarified?
I don't know that it needs to be clarified. The question is whether somewhere along the line somebody's going to direct, say you have to install one of these.
Right.
I know that's not the intention. I think keeping voluntarily there is about the best you can do.
Great. We have a motion and a second, and Representative Libby's hand is up. You are recognized.
Thank you, Mr. Chair. I just wanted to come back to something that Peggy had mentioned in the analysis, and that is the question of physically located inside versus on the property. And so I thought it would be good to have a conversation around that, if it should be physically inside a building, especially a building like a law enforcement facility where someone might be reluctant to go inside. So I would welcome thoughts on if it should be located on the property, because number 3 still has located in an area that's conspicuous and visible. So what are thoughts about on the property versus in the building?
Is there anybody that would like to answer Representative Libby's inquiry? Representative Moriarty?
Thank you, Mr. Chair. Here, just a few thoughts. First of all, each one of these facilities must be staffed around the clock by a medical services provider, and we now have an alarm requirement as well. So I think that on the property will work and will be sufficient to protect the health of the baby and the anonymity of the person dropping the baby off. So I don't think it needs to be inside, physically inside the building.
But Representative Moriarty, you're saying the wording, you're saying that the current wording is or is not appropriate?
I guess I'm saying it's probably not necessary.
Right. That's what I thought. That's where I thought you were going at the beginning.
Yeah.
Thank you. Okay, that's the same hand. Is there another comment from the committee? Yes, Peggy?
So along these lines, so it looks like the model language is inside, located, let's see, physically located inside a hospital, law enforcement agency, or fire department. But I will note that the Florida bill that is pending refers to it as physically part of the hospital. Physically part of the hospital, emergency medical services station, or fire station. So I mean, I think the idea is you wouldn't want to have a standalone, box in the parking lot.
Right.
And I don't know if you spent any time looking at the websites that were sent to you, but usually they're exterior walls. I don't know if that's considered inside the hospital or the police station because it's on an exterior wall. But I mean, I think that was a concern. That it is the model language.
And you say the model language says inside. Yes.
Yes,
And
this bill is based on the model language.
If we were to err, we'd probably want to have it safer for the child than not. So on the property alone would be, it could be a little bit what we might not expect if we're merely talking about a bit of acreage that must be defined.
Right.
Any
So
other comments? Yeah. Representative Libby? I'm sorry.
So I appreciate that. My thought with on the property, and so maybe it's the language that needs to be adjusted, is that in the instances that I've seen, and I don't know if this is maybe what Peggy was referring to, these boxes they're kind of a pass-through, some of them, I think, where you access it from the exterior of the building, but then it can be accessed from the interior of the building as well. And so it wouldn't be on the property would not mean just like a freestanding like mailbox. In my mind, it's that kind of pass through, but somebody doesn't actually have to walk into the building and face a daunting situation to do that. And the other thing that I just want to clarify is that in the what I seconded, we do have DHHS is approving the plan for each of these. Okay. So those were the two things I wanted to address. So whatever that language would need to be so that on the property is more of this pass-through situation rather than a terrified teenager having to walk into a building.
the motion on the floor. By
Not to pass as amended.
is the model language with the DHHS language, is that correct?
Well, I think there might have been is that it? I thought there were a couple of other things in that amendment.
I think that's, I mean, one could certainly, because we have rulemaking there, the Department of Health and Human Services could make sure in the rules that it doesn't mean that you have to go inside and, you know, go up to the admitting desk in a hospital in order to do this. I don't know if you want to stick with the model language and rely on rulemaking and people who want this to work to be placing these devices in reasonable places.
That's fine with me.
Fine with that. That does sound like a positive way forward. Is there any other comments on the part of the committee before we go to a vote? Seeing none, Soupy, I think we're ready for a roll call.
Thank you, Mr. Chair. Senator Carney.
I'm sorry, I just rejoined the committee meeting. I have no idea what we're voting on.
We didn't even know you were there.
I literally transmogrified over the moment Soupy called my name. So Soupy, can you just continue and catch me on the second round?
Yes.
Absolutely.
And Peggy might be able to help you with the amendment to LD 560 is what we're working on right now.
Right, we're using the amendment that Representative Libby had circulated with the clarification that the requirements are adopted by the Department of Health and Human Services to make sure it's not confused with fire departments.
Yes.
Thank you, everyone.
Okay, go ahead, Soupy.
Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 11 members voting in the affirmative, 0 members in the negative, and 3 members are absent.
Thank you, Madam Clerk. LD 560 is reported out, ought to pass as amended. And I'd like to return the gavel to Senator Carney.
Thank you very much, Representative Babbage, and I really appreciate you taking over as chair. Could you please refresh me as to what I missed?
In actuality, we did discuss Representative Evangelos's 448 for an additional amount of time. We came to a point where we felt it would be best to adjourn and have you back in the conversation. But we decided to take up a bill where we thought we could negotiate in a reasonable amount of time. And so we did do LD 560 and we just concluded that. So technically speaking, it would be up to you to either continue on or to recess for a quick caucus on 448, whatever's your pleasure.
Is it 448 or 478?
I'm sorry, what if I
448.
could? 478, I apologize.
Okay. And so did you all take up 448?
We have not.
Okay, great. Representative Moriarty?
Well, actually, 478 was tabled.
Okay.
Yeah, yes. Well, that's a good point. When you table, you can take it off the table at any time, but I was at the time that we tabled, I was thinking that we were going to take it up at a later time, which is at our discretion. So I leave that up to you, Senator.
Thank you. Thanks for updating me. Representative Evangelos?
Yes, thank you, Madam Chair. I had suggested that out of respect for you that we table the bill. And also Peggy's already reached out to Mr. McKee, who was unable to attend the work session today. And I think he would be of great assistance to answer some of the legal technicalities. He's already written me and told me that he will be available at the next work session. So I'd be happy to just maintain the tabling status, and we'll just have to take it up at a different work session. We'll notify Mr. McKee and any other party that wants to participate. But his testimony was essential to answering some of the very legitimate legal technical questions that have been raised. So we tabled it out of respect for your absence, and now we'll have more input at the next work session. So I'd prefer not to take it back up today, given that we've already told Walter we're rescheduling.
Thanks for that input, Representative Evangelos. And I agree with you. I sensed in that conversation that a lot of us needed to think more and get more information about LD 478. So we'll leave it on the table for now. Thank you. So let's go back up our list a little bit and take up LD 448. This is an act regarding recording of witness interviews. It's actually kind of a very simple proposal. It just requires law enforcement departments to create a policy regarding witness interviews. It's not requiring that, well, I should stop talking and invite our analyst, Peggy, to give us maybe a brief analysis of that bill, Peggy, because we did talk about it, and I think we may be ready to move forward. Thanks.
Sure. So we had kind of initially started to talk about this, and then people realized that they might have some additional questions. But LD 448 is, as Senator Carney said, it's amending the provision in the statutes dealing with policies that law enforcement agencies are expected to adopt. And those policies are the Maine Criminal Justice Academy initially adopts model policies, and then law enforcement agencies can adopt those policies, or they can adopt things that are more protective, or I mean, I'm not sure what kind of parameters I have to use when dealing with something a little different than the Criminal Justice Academy's policies. So most law enforcement agencies, when they have to adopt a policy, adopt the model policy that the Criminal Justice Academy puts forward. So I included in the bill analysis the actual policy that the Criminal Justice Academy has adopted for it's a policy on interviews, and you can see exactly what's there. It's pages 3 and 4 in the very top of page 5. Now, this policy right now applies to law enforcement interviews of suspects in murder, Class A, Class B, and Class C crimes. So interviewing suspects can be different than interviewing witnesses. And the idea was that this would have to be a policy that how you identify witnesses, how you record those interviews, what would happen if the witness doesn't want to be interviewed? What would happen if the witness doesn't want to be recorded? Those are all things that can be accommodated in the policy. And I included Governor Mills' veto message for the bill last year on 801, and she was concerned about requiring that witnesses be recorded. And this policy is not, this is not a requiring witnesses, but having a policy on how witnesses would be recorded if they are recorded by law enforcement. I had a very brief conversation with the director of the Criminal Justice Academy. He was most concerned about making sure you weren't expecting any changes immediately, that it takes time for the board to go through and adopt policies. And but once they had a policy, they would expect law enforcement agencies to abide by it. I'm not sure if you have any questions, if I can be helpful in any of those. It looks like minor cost absorbed as worded.
Thank you very much, Peggy. Senator Keim, I think your hand was up first.
Thank you, Madam Chair. Yes, so Peggy, a couple of questions. So if the Criminal Justice Academy creates a model policy, it then becomes a minimum standard, and then the law enforcement agencies, it's my understanding, have to meet that minimum standard like within a year.
I think that's right.
So my question is, the sheriff came in opposition and then changed his testimony, but was that because was there a different amendment or I mean, offered that he at the public hearing that he hadn't seen?
No, I think he had interpreted it as requiring the recording of witnesses in all situations, and I included his testimony that he gave, but tried to indicate that, I mean, he prefaced it by saying, well, if I had heard that before, I wouldn't have submitted this.
I remember. What confused me is that if
they would be law enforcement, a lot of the members on the board are law enforcement, they would understand that you wouldn't want to impose a standard that would be impossible to comply with. I know that Walt McKee is in the attendees, and he offered information if anybody wants to hear from him. I mean, I can look up who the members of the board are if that's helpful to you. But I mean, some of them are practitioners in the art of law enforcement. And so I think the idea is, and even Clack was in favor of this, the idea was that they would adopt standards that would take into account the various situations where where a witness wouldn't want to be recorded because they're concerned about their safety, or what happens if who's a witness versus who are you talking to for background information. So I think they're aware of that. I can't guarantee what they would adopt in a policy, just like putting this in. You're right. They could adopt a crazy policy, and law enforcement agencies would probably come to you and say, why in the world did you adopt this law? But can you fix it?
Right, and not necessarily a crazy policy, but maybe a policy that doesn't work for every law enforcement agency across Maine, which is when we heard this bill last time, that's what we heard, and why it didn't work for all Maine people. The other question I have, so I remain concerned about what their policy would look like and how they're going to adopt that, and maybe there's someone that could answer that. My other concern is that as this bill is simply asking the Maine Criminal Justice Academy to craft a policy, they're saying they can do that within existing resources, and absolutely they can. But the policy that they then create could be very costly depending on what it is. And so what sort of provisions do we have around that to gauge what they're doing? Because what we're hearing from MCILS and pretty much everyone, DA's offices, everyone is saying what has now become so time consuming in the work that we're doing is reviewing video. That's literally, they've said it to us on so many bills. And then here we would be possibly every indictment could have 3 to 4 witnesses. And if they're watching all these recordings, it could be a very time consuming process. So how do we capture the cost of whatever policy they want implemented? So those are 2 things, sort of broad concerns I have that I really feel I need the answer to before I can vote appropriately on this bill, because it's very much at stake here. What the impact of their policy is. We're just sort of broadly giving them the ability to create costs and policy that maybe or maybe not works for all. I'm thinking I represent a lot of small law enforcement agencies. So do you have any suggestions on how we can get a little bit more of that information?
Right. I mean, I don't, other than if you wanted somebody from the Criminal Justice Academy to come and talk to you about what they think about when they put together these model policies. Do they not only think about how hard it is for the various size law enforcement agencies to put them into place, but they think about the costs that would be involved and just kind of the practicality of implementing this. We can ask them and see. I don't know if that would answer your questions, though.
I think in part it would, because we're saying, just exactly what, as legislators, when we pass a law that is actually going to be a cost to municipalities, we have a very high bar set for that. And so, if they would then pass a model policy that would be very costly, we would have to know. And the only other question I have is, are witnesses allowed to say no to being recorded? Is that some sort of personal right that they have? And would that, if it is that something that would be respected? So.
Right. And I think that was one of the things that the policy could address as well, and make it very clear that a witness could refuse to be recorded if that was what they wanted to make happen.
Thank you.
I know that there are lots of hands raised. Peggy, I just wanted to ask a clarifying question based on Senator Kimes' question. So this bill, LD 448, actually doesn't require any agency to adopt the model policy that might be proposed by the Criminal Justice Academy, right? That was just kind of an example of how an agency could obtain a policy without spending a lot of agency resources?
Well, actually, the statute says, I'm looking at Title 25, Section 803.
I got it. You're right.
They shall adopt written policies. Yeah.
Got it. Thank you for clarifying. I was looking at it in isolation. Appreciate that.
It doesn't say what has to be in the policy.
Right.
But, they do have to adopt a policy that addresses that. Yeah.
Thank you. So I think that Representative Babbage was next.
Madam Chair, actually, I was prepared to make a motion, but if you, I can do that now, or I can. I would like to preface the motion by merely saying that I think the intent here is to expand the recording of important participants in a case, and I think that would be a good thing for justice. If this were if we were asking some reform organization to come up with a policy, I might be a little more concerned along the discussion that I just heard, but we're giving it to a law enforcement board primarily in order to establish what I'm sure could be comparatively a minimum standard as a model policy, but yet would enhance justice in the state of Maine. So I like the direction of this bill, and I'd like to, and since the second sentence in the summary, I believe, has been shown to be inaccurate, that it is not a requirement to record the interviews of witnesses at this point. This is to the development of a policy that I move ought to pass. Thank you, Madam Chair.
Thank you, Representative Savage. Is there a second on that motion? I see Representative Reckitt waving her hand. Are you seconding the motion? Yes. Thank you, Representative Reckitt. And now I'll move down the line. Representative Moriarty, your hand is raised.
Yes, it is. Thank you, Madam Chair. In response to Senator Kimes' comments, we're sort of in a chicken and egg situation. We won't know how much the ultimate trickle-down cost will be until the policies are drafted. And we can't call someone from the academy in to speculate what those costs might be, not knowing what rules have in fact been drafted and promulgated. So we really kind of have to do one thing or the other, either authorize them or instruct them to draft and adopt policies, or to leave the matter untouched. And I think we're safer in going with a situation in which they are instructed to adopt policies, because in the case of murder and the three most serious classifications of crimes, what a witness says or doesn't say is very, very important and can be a serious issue at trial if there is disagreement. So I would support Representative Babbage's motion.
Thank you, Representative Moriarty. Representative Thorne?
Thank you, Madam Chair. And I can't help but sit here and think, again, as a non-attorney, how we ever got along up to 2021 without this requirement. How did we ever, as a legal system, muddle through getting testimony from a witness without a written policy being established? And I'm brought back to the Miranda rights, where you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney will be appointed. So then we get someone who commits a crime and they get off because they didn't get read their Miranda rights on a technicality. And I can't help but think that this just creates another loophole, another technicality to violate written policies so that a witness's testimony can be thrown out. I don't see where it advocates for anybody, where it helps anything. Especially if there's no standardized policy, if it's going to be this police department writes their policy, that police department writes their policy, sheriff's department will write theirs, the state police will write theirs, the warden service writes theirs, that there's no standardized written policy of procedures that, for my 21 years of looking at regulations and everybody's on the same page, it just creates a scenario where, one department has one policy written and another policy in another department. And I may be wrong on that. And if so, Peggy, maybe you can correct me that this is not going to be willy-nilly, everybody makes up their own policy, that it would be a standardized interview policy that pertains to witnesses. There's a question in there somewhere.
Right. So the whole purpose of this section of the law is so there are model policies that apply to all the law enforcement agencies. And so the Board of Trustees of the Maine Criminal Justice Academy goes through and adopts these policies. And actually, Representative Reckitt was on the board for many years. After the board adopts them, they distribute them to all the law enforcement agencies. And if these are mandatory policies, then it says the chief administrative officer of each law enforcement agency shall certify to the board annually that the agency has adopted the written policies consistent with the minimum standards in all of these policies. So I think the idea of putting it here is that the board would adopt a standard policy and then every law enforcement agency would adopt the same policy. I think the question is what's going to be in that policy that the board adopts. You know, how stringent is it going to be? Is it going to be flexible enough to deal with different types of witnesses and different types of situations? And the idea is the board has the expertise to do that. And then a law enforcement agency wouldn't have to worry about trying to figure out what applies when. They would adopt the policy, and then that would be standard from law enforcement department to law enforcement agency, sheriffs, municipalities, small towns.
Right.
Yeah. I don't know if that answered your question.
Well, and I can't really apologize to the committee for joining the Judiciary Committee when I did, and I know a lot of water's gone under the bridge before I arrived, and I may have missed the advocates for this, whether they were this was written on advocating for witness protection and rights, or whether it was intended to help law enforcement streamline their ability and effectiveness. I don't know from what angle this comes from as far as who it benefits the most. Does it benefit the witness that may unknowingly say something that incriminates themselves and they didn't mean to, and therefore if they weren't given they didn't follow their policies, that testimony could be thrown out? I think it just, every time we develop another rule, I think we develop another possibility that we're going to violate that rule in the proceeding process, so that somebody can say, no, that witness's testimony has to be thrown out because they violated Chapter 6 of subsection 5, paragraph 4, line 3 of the witness policy for collecting interviews. So I'm just a little bit skeptical that it creates potentially more loopholes to be found than it creates goodness. That's all.
Thank you, Representative Thorne. I think we next, Representative Reckitt was next.
Thank you. You're right. I was on the Academy Board for 15 years. And so I'm well aware of what the method is to adopt policies that are uniform or not uniform in the state. Generally, what happens is the National Association of Police Chiefs is contacted because they have model policies for this, that, and the other thing. So they obtain that one and then discuss whether or not it's appropriate for Maine. And it certainly could be articulated that departments over X size would have to have Y and Z, and smaller ones less. But it would also, I think I saw something in the proponents piece about the interviews that are required now are of suspects, what is only above a certain level of crime. And it may be that these witnesses are in that same category. You would only do it in that level of crime, but that would be up to the policy to look at. And frankly, there's always a huge debate, well, usually not much of a debate by the time they get it done, but there's a subcommittee established to look at that part. They go get the national models, they see whether they're appropriate to Maine or not. And then they come to the board for discussion and revision if necessary. But generally, the staff of the academy and the police chiefs associations do a pretty damn good job of crafting all this stuff together. And I have absolute confidence that the academy is not going to do something that says to the town of Bridgeton, you got to interview, you got to record the interview of every shoplifter in the town. You know, you can't, it's not going to happen. It's not going to be crafted that way. It's not going to be unreasonably done. The academy crowd is very, you know, and they, and it's all straight away and nobody's pulling anything on anybody. The other thing that makes me uncomfortable is I know this is Tom Hartnett's bill, and it's unfortunate he's not here because when I've heard him speak about it, he talks about it in a way that is very minimalist, not talking about the entire world's going to get interviewed, or even that you have to interview people if that's not your policy. I'm sorry for sounding muffled, but I have electricians running around the house, so that's why I have the mask on. But I just think the academy's used to doing these things, and I think that they can do it effectively and accurately, and which is why I'm in favor of this bill. So,
Thank you, Representative Reckett. Representative Moriarty? Oh. Did you want to speak?
I did. I didn't realize I was on mute. I was thinking about Representative Thorne's comment about the Miranda rule. And it's true, if that rule is not adhered to, that a confession obtained from a criminal suspect can be thrown out and the person may be released or acquitted as a result. I'm not aware, though, that if you're dealing with a witness who is not a suspect and there's some problem with the recording of that witness's statement, that the witness's entire testimony would be thrown out. There may be some credibility issues if the person taking the statement and the person giving the statement disagree on what was said, and that would become a troublesome fact issue, but it wouldn't result in the tossing out of a confession from an accused person. Another thing to bear in mind is that this doesn't require, at least the statute doesn't require video recordings, simply that witness statements be recorded. That could be done as simply as with a digital recorder that fits inside your coat pocket. And the expense there is minimal, and it's solidly recorded electronically for as long as you want to keep it. So just some quick thoughts.
Thank you, Representative Moriarty. Representative Libby?
Thank you, Madam Chair. I am just wondering, does the Academy have the authority to write a model policy without us putting it in statute? Or do we have to put this in statute for them to be able to write a model policy and put into place?
I don't know.
I guess my question is this even necessary?
if I could be
Go
recognized.
ahead, Representative Reckett.
I mean, I think it could be done if there was some kind of groundswell from within the police community to do this, perhaps. But it's not going to be, the uniformity won't be there unless everybody's in agreement. And the Academy has the capacity to make everybody in agreement because they're in charge of certification of everybody. And if they're not certified, they're not working. So it's they have the club as well as the carrot, and I think that I'm trying to think of the times that I was involved with policy development with them, and I don't know whether it came from the legislature or not. So I don't want to tell you something's not true. So, but I think it could probably happen either way. But I can't guarantee you that.
Committee members, I just want to call everybody's attention to the fact that we're 2 hours into our afternoon session of work sessions. I think we've voted on one bill. And so I would just ask committee members, if you have, I want to know if people are ready to vote on this bill. I sense that people are asking a lot of questions in order to persuade each other, but I also sense that committee members may have already made up their minds. And so I know that there are a number of hands up. If you have a question or would like to contribute something to the conversation, please do so. But otherwise, I think that we should move to a vote. And so Representative Libby, you had just spoken. Do you have something additional to add?
I do. I would just like to add or to respond that I came into this and many of our our work sessions with a quite open mind about this bill. And I find that having the time to have the discussions is incredibly helpful. And without it, my default is always no.
Yeah, I appreciate that. I also do learn a lot from the discussions. We have 170 bills that we are responsible to to the legislature and to our constituents and to folks in Maine to make decisions on. And so it's a difficult balance. So I understand where you're coming from. We have a lot to do, however, in addition to that concern. Representative Evangelos?
Thank you, Madam Chair. Senator Carney, I agree with you. And there is a motion on the floor?
Yes.
Okay. And it was ought to pass, correct?
Yes.
Okay. And I just want to point out that this bill has no harmful consequences. It's a benefit to the police and to the defendant. It's just will be a recording that substantiates certain facts. So it protects law enforcement and the defendant. And I see no harm here, and I am ready to vote.
Thank you, Representative Evangelos. Representative Thorne?
Thank you, Madam Chair. I'm pretty much exacerbated, and I have a lot of questions. That's just my nature. And without having all of them answered, I'd have to vote no on this, but I'm ready to move forward. Thank you.
Thank you, Representative Thorne. Representative Babbage?
Yes, just very quickly, I appreciate the fact that Representative Moriarty mentioned, this could be cumbersome in 30 years ago when we had to use VHS or whatever it is. But now that we have digital, the fact that Clark and Defense are both in favor of the bill. And my point that I wanted to clarify earlier that I didn't make clear, we can be more specific as to what's being required here. But I think rather than the legislature doing it, I think giving it to this board, which will establish minimum standards for law enforcement, is exactly the right direction. And so I just want to make that clarification, and I'm ready to move forward. Thank you, Madam Chair.
Thank you, Representative Babbage. Is the committee ready for the vote? Senator Keim?
I would like to request a corner caucus.
That's fine. How much time would you like?
5 minutes.
Okay, so and I also know that we've all been sitting in one place for over 2 hours. So let's take 10 minutes and gather together again at 3:20. And please deactivate your audio and video because the live streaming continues. See you all at 3:20.
Sun shining.
Yeah, it's looking pretty outside. Little cloudy here, but some sunshine as well.
Right.
It's very cloudy here. I hope we get some sun.
Yeah, there's a nice big open patch in the clouds and it's shining right on my window.
Good spot for a cat to curl up in a sunbeam.
Yes.
Peggy, before we get started, because I guess we're still waiting for folks to come back, but the questions I asked about this bill, I would still like that information, even though I recognize we're going to go to a vote. If it's possible to still get me some information around the questions I asked, I would appreciate that.
Okay.
Thanks.
And I think we're just waiting for a couple of committee members to return from our break. Well, it looks like we're all here back. Thank you everyone for being so prompt with the break. And so I will ask the committee, are we ready for a vote on LD 448? It looks like we are, and welcome back, Supi. You can proceed when you're ready.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No. No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes. Yes.
Thank you. Representative Evangelos votes yes. Representative Newell. Representative Sanborn. Representative Sanborn is absent. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Newell. Representative Newell is absent. I have 6 members, Madam Chair, I have 6 members voting in the affirmative, 5 members voting in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. And so with that, the ought to pass motion has 6 votes, ought not to pass 5, and there are 3 members who can vote sometime in the next 48 hours. With that, we'll close the work session on LD 448. And Senator Keim, did you wish to be recognized?
Yes, thank you. Just so the committee's aware, and as I mentioned to Peggy, I would like the information, and it's possible that I will change my vote on the floor after I get the further information that I feel I need to make a better decision. Thanks.
Thank you. We'll move on to our next work session. This is on LD 402. And Peggy, if you could again give us sort of a more big picture bill analysis, and then we'll probably ask you for some more deeper questions as we go along, just in light of the time constraints. Thank
Sure.
you.
Okay, so this bill adds a new section into Title 22, which allows anybody who's receiving a vaccine, so not just COVID, but any vaccine, to opt out of the sharing of their personally identified information with any third party, including the federal government. We asked a lot of questions of DHHS, the CDC, and they sent a memo that I circulated last night, and I hope that provides you a lot of information to your questions. And I know that they were going to try to be here, although they had lots of other things going on too. If I can answer any questions, I'll be happy to try.
Can you just, I think the questions that were asked related to how much information was shared, and we heard back from the Maine CDC. Can you just quickly summarize the information that came in yesterday?
Right. They emphasized that the personally identified information is redacted from the record that's shared, and the data that's provided by the state is de-identified. They have a policy that about sharing, making sure that things aren't shared willy-nilly. They have talked with other states. Maine has determined that certain data, such as race and ethnicity, are important data to the state's equitable distribution of vaccine and vaccine-related services. The state has its own policy about data privacy and protection, and they say it approaches that in multiple ways. The Maine CDC requires data use and sharing agreements with anybody prior to sharing the data, including identified data as well as redacted data. And their privacy policy is posted. And it also says that their rules allow for the patient to choose to be excluded from the immunization information system. And the vaccine data for individuals opting out of the IIS is not available to report federally. So it sounds like their rules all actually already allow for people to opt out.
Thank you very much, Peggy. Representative Sheehan?
Thank you, Madam Chair. I would like to make a motion in light of what Peggy said, ought not to pass, and I'd just like to speak briefly to that, if that's okay.
Yes, let's get a second and then you can speak to it. Representative Babbage?
Yes, I second the motion.
Thank you. Okay, back to you, Representative Sheehan.
Thanks. So I also had some concerns about the need for fine-grained information, especially names and addresses being shared. But the memo that we received really reassured me that this type of information is redacted as a matter of course, and that individuals are able to opt out of this sharing. So that's why I'm making the motion. Thank you.
Thank you very much. I think Representative Thorne was next. Did you take your hand down, Representative?
I did. I was ready to vote also.
Okay, thank you. Senator Kime, did you have your hand up?
Yes, I'm sorry about Peggy. I was trying to get in and find out where that memo is. I am just, maybe my inbox is too big. It's not attached to the bill analysis, so is it in the electronic file?
It should be.
Great, thank you.
Okay.
Well, I would, because the information's so accurate, the memo so accurately addresses the subject matter of this bill. Peggy, could you please screen share it?
Sure.
Because I do think it's important for folks to have a chance to look through it.
Okay, give me a second.
This is where it should be comes in.
Right, this is where it should be.
While Peggy is looking for that, Madam Chair, I just wanted to ask if I adopt Representative Hagan's and Evangelos's method of stating their vote twice, does it count twice?
Vote,
Votes only
often.
ever count once.
Vote early and often.
Okay. You good?
Yeah, we see the memo up on the screen. Thank you. Can you just
I'm
yeah.
hoping to scroll in a minute.
Yeah.
I've been having trouble with my Adobe program. Here, let me stop and I will see if I can pull it up in a different way. Oh, now it's working.
Of course.
Of course.
Thank you.
Okay. Is this what you wanted to look at, where they emphasize personally identifiable information is redacted, the data provided by the state is de-identified, and then here's all the fields that they collect and then how they deal with it. I don't want to make anybody give them motion sickness by moving too fast. Or did you want to look at some of their
Let's do this, Peggy. Can you just take us back up to the first paragraph and just let folks read through that, the beginning part before we get to the tables? Thank you. And we'll just take a moment here.
That's good.
Committee members, is everybody set with this portion of the memo? And if please just raise your electronic hand if you'd like Peggy to take us through each section of the chart that shows what's reported and what's redacted, or if this initial introductory paragraph is enough. So if you'd like to see the charts, just raise your electronic hand, please.
May we see?
Go ahead, Chris. Representative Savage.
I should just obey instructions.
Okay.
I just wanted to know if I could see the first part of the listing of redactions, if I could. But that paragraph is very good. Thank you.
So these are the data fields that are collected and then how they handle them.
Great. Yep. Thank you very much.
Is that enough?
Yep.
Would anybody like to see additional data fields? Senator Kime?
So just as we're looking at this, a question came to mind. Peggy, so right now this is set up on their rules, through a rulemaking process, but they could also at any time change that to share. Is that correct? And since it's not, this information isn't protected by Maine law, but this is what they've established.
I'm not sure how much of this information would be protected as, medical information. And they would have to have some kind of a data sharing, agreement to share that information. So I don't know how much is protected by federal law, and I don't know how much is protected by state law already. without having anything specific apply to vaccine information, just because it's medical information already.
Right. So then on the very last page, it says, I think the very last question, is there a way to opt out? And it references CMR chapter 274, but those are the department's rules. So they could also change those rules because it's not law. Is that correct?
It is. I mean, and they'd have to go, I don't believe those are major substantive rules, but they would have to go through a rulemaking process to change them. So there would be notice of that. Not that your committee would get notice of them, but HHS would probably get notice of that.
Thank you.
Representative Libby?
Thank you. Senator Keim had brought up something that I was concerned about, given that that is rule and not statute. I think it sounded to folks like maybe this might be duplicative, but I don't think it does duplicate anything. It simply puts it in statute. My concern in looking at the information that is given out, I realize that it doesn't give out name, but it does give out date of birth, gender, and while it doesn't give out town, it does give out zip code, which is more specific than town. And frankly, anybody savvy with a computer these days, it would not be difficult to extrapolate from date of birth, zip code, and gender more detailed personally identifying information. So I think this is a worthwhile bill. Our personal information is, as a nurse, it's always been paramount to protect my patient's medical information. HIPAA is very specific on that, and I had an acquaintance that lost their job, and I think they're licensed because of revealing not even the name of a patient, but just some information. I think I hold that pretty dear. So I certainly support this bill, and I appreciate that it puts in statute what we already have in rules.
Peggy, would you mind going back to the first chart again?
I was about to stop sharing.
I'm glad I caught you. Gotcha. Okay, thank you.
So I understand Representative Libby's concerns. It doesn't mean that this information is shared publicly. It still needs to be, they still have to have data sharing agreements, who they're going to provide that information to. I'm just seeing what else is required. I don't, are you done looking at this? Should I stop sharing so you can see each other?
I think so, Peggy. Thank you. I think next we have Representative Libby. Your hand is still up. Are you all set? You have another question? Okay, go ahead.
I just want to follow up, Peggy. You had just said in regards to the data sharing. So I guess my question is, if this is only in the rules and there could be a data sharing with not just the federal government, but a third party, that it seems like that leaves a lot of flexibility in the rules as it is right now. Is that correct?
I don't know what who else they would be sharing it with, other than maybe insurance companies or research. Great. I think, rules do provide a fair amount of flexibility, but only, they're dependent on what the wording of the rules are. So if the department needs more flexibility and they have to adopt a rule that provides that flexibility, then that's part of the rulemaking process.
And I would just remind committee members that the legislation we're considering actually does direct the department to adopt rules to carry out the purpose of this section. And so that it seems like it would direct the department to adopt the rules that are already in place, to my reading. But Representative Hagan, you may proceed.
Thank you, Madam Chair. I'm aware that the sponsor is in the other room, wondering if we could also hear from him at some point.
Yes, we certainly can. Let me bring Representative, Soupy, could you please bring Representative White into the panel? I don't have the authorization to do that. Thank you. Welcome, Representative White. How are you?
Good, thank you. Appreciate the discussion on this bill. Let's see, okay. And I did get this memo last night, and I appreciated it. It certainly addressed many of the questions that we had no idea about in the beginning. Excuse me. When this was brought to my attention a few months back. So it did, again, it addressed much of the concerns. I would say the last question about being able to opt out was that was unknown at the time. So it's nice to have clarification on that. Still a little concerned that we're not allowed to opt out of some of the things federally, but I would expect that's out of our hands at this point. So, I think it's addressed many of the things that I was hoping it would. And if it could be put into law, it'd be all the better.
Thank you very much, Representative White. Thank you for joining us today. And I imagine you've been waiting for a while in the attendee space. We appreciate your patience.
You bet. I gained a new appreciation of the work in your committee. So thank you.
So I'm not sure who's next, but I suspect it was you, Representative Thorne. So why don't you go ahead, please?
Thank you, Madam Chair. And I just wanted to let Representative White know you're sitting in my chair virtually. I'm in the nosebleed section back there in 125. I never would have thought it would have been a screen sharing position, but there you are. The impetus behind this obviously was so that nobody other than the state would get the information that you needed to vaccinate. Is that correct?
Yes, that is correct.
Okay. And that currently, and I may have missed that in the language, but does currently the state have the ability to share that with the federal government automatically?
That's where the confusion was originally. Sorry about that. And I believe this memo addresses some of those concerns. Originally it was to on this testing to get some of the funds, I believe, that was going to be required. So there was a lot of confusion, when it was addressed. The COVID situation certainly brought this to the forefront, but and it brought a lot of questions up. So there was a lot of unknowns, and I believe the memo has addressed most of those concerns and what exactly is shared and what isn't.
Thank you. I just wanted to hear you vocalize that. Thank you, Madam Chair.
Yeah, thank you very much. And thank you, Representative White. Representative Poirier, I think you're next. Go ahead.
Thank you, Madam Chair. Just a quick question, if anybody can answer. I want to know if people at the time of vaccination are made aware that their information will be shared, and if they're made aware that they have an option on the state side to opt out.
I'm not sure there's anybody present today who can answer that question. I wish that we had thought of that in the bill hearing itself, because I'm sure that Ms. Beardsley could have provided that.
Just a quick follow-up, maybe
Yep.
for anybody on the committee. I know some of you have had the COVID vaccine. By chance, would anybody be willing to share if they were told at the time they had their vaccine that your information would be shared, if you're willing to share that information?
Representative Moriarty?
Yep, I've had both vaccinations. I signed some papers, but I don't
That's right.
recall
Exactly.
being told anything about the sharing of information. I can't vouch for what I may have signed.
Thank you very much.
Thank you for confessing that. Senator Keim?
Oh, it's so true. Oh no. And it's worse when they're online forums and they're, you sign your life away just so you can be on Facebook or something. Sorry for diverging here. Okay, so what I'm wondering, Peggy, is I so appreciate this memo and all the information shared. And I would like to move forward with probably what would end up being a minority amendment, I'm guessing, but with language that would set this in law so that when the department, so they already have the rules in place, but they're by their own volition, so to speak, as opposed to by, a law that the legislature has passed. So can you just help me understand, and maybe we could just do this in language review or something, but what would language look like that acknowledges where they currently are, rather than say, hey, adopt rules when they've already adopted rules? I can see that the language would need to be changed. Can you help me understand how we would word that?
So what you're really looking for is for somebody who wants to receive a vaccine to be able to completely opt out of the sharing of any information that's collected, whether it's personally identified or otherwise.
Right, unless the
is that what you're talking about?
Right, except where the federal law obviously supersedes state law on that.
Or is there information that you want to specifically say they can opt out of? They can, I don't, somebody can always say, I don't want the vaccine, and then that information is not collected. But I don't think that's what you're saying. You're saying the person could receive the vaccine, and the rules, you want to put in law that the rules have to provide for an opt-out of the data sharing. The state can still collect that information, but they can't share it with anybody.
Right. And I guess, though, when you say that, it would also be in the negative as well, right? So if you don't have a vaccine, that shouldn't be shared, right? I mean, I don't know that anybody collects that information. Right. So I guess I didn't really think about that, but it's both, right? Basically what we're trying to capture here, what I would like to capture, is that in law, we set out that there is privacy around vaccinations. Like the state can't say this person has, that person hasn't, or, that type of thing. So it is the personally identifiable information, except where it's exempt from state law. But I can see that it shouldn't say the department shall adopt rules, because they clearly already have. And yeah, I think it would be good for us to follow up with the department with Representative Poirier's question, but again, not something we have to discuss right now. But I think it would be good information for us to know, is if they actually tell people, hey, you can opt out and here it is. But maybe it's in the long list of stuff we sign and don't, I don't know.
Right, it was a full page.
Yeah.
Right, and I signed it twice.
And you didn't read it either? Oh, no.
All right, committee members.
But you're really focused on personally identifiable information. So we could write a statute. We could write language that says the department has to adopt rules that allow recipients of vaccines to opt out of the state sharing personally identifiable information about the recipient.
Yeah, I think that works. Thank you.
All right, committee members, are we ready for the vote? Representative Poirier, your hand is up. Is that residual or a new question? New. Okay, go ahead.
I'm all set. I'm sorry.
Okay, Representative Evangelos? We're not able to hear you.
Sorry. A very quick question. Peggy, did I hear right that what the department or the CDC sent you included evidence of a clear opt-out option?
That's currently, my understanding is that's the rules. The very last piece on the memo that they sent says the rules provides the option for the patient to choose to be excluded from the immunization information system.
So what we don't,
it's not reported federally, right?
okay. So what we don't know is what form it's on and whether people can see it easy or something. Is that like even the lawyer on the committee missed?
I just wanted my vaccine.
No, I only got one, J&J. Anyways, okay, well, that's encourages me that there's a process in place. And I did want to, I know we have a lot of work to do, but this will take 30 seconds, Madam Chair. But when I was a kid, we had the polio and, you know, you got your shots. Your parents had papers on you. And so if you moved, you showed them to the school so you didn't have to get vaccinated again. Things weren't electronic. I don't know what they were doing sharing our information, but I did know that if you didn't get the polio shot, you weren't allowed in school. It's just, they did make rules around this stuff and, because, you know, kids were dying. So thanks.
Thank you, Representative Evangelos. Representative White, your hand is up, but we are trying to move toward a vote. Did you have something you wanted to contribute?
Yeah, just quickly, the intent too here is that we want to encourage people to get, you know, vaccinations that come, whether it's the COVID or other ones that may come in the future. And if they are, you know, leery of it because of their data being shared, that was much of the intent of this bill. And I think as noted already real quick is that the last part that does say you're allowed to opt out, but that's not clear to anybody. I mean, I also had my, you know, COVID and I had no idea. I mean, it would be nice if that was put somewhere where people would understand it. I expect that most people aren't going to be worried if they know it's done properly and safely, that the data is, you know, protected in many ways. So thank you for that. I just want to make sure.
Thank you, Representative White. Representative Babbage?
Yes, ma'am. Thank you, Madam Chair. I wanted to thank Representative White actually for bringing this forward. That wasn't my first point. I guess that's a good point. My memory is the first point. I had the shot 6 years ago. I did read it carefully and then signed it, but I can't tell you exactly what was on it 6 weeks later. But I want to thank the representative for bringing this forward because I shared the concerns that he had, but I have been very pleased to learn what I have in the interim, and so that's why I'm not sure I feel that adding statute in this case solves a positive purpose. So thank you. But I want to thank the representative because I did not know what I know now if he hadn't brought this forward. Thank you.
You're welcome.
Thank you, Representative Babbage. And Representative Libby?
Thank you. I just wanted to share with the committee, I was just made aware of this. This is a consent form. It is buried in the fine print here, if you can see it all. A very small disclaimer about information, the record of this vaccine administration. I do appreciate what Representative White said about folks and reluctance in getting the vaccine, the COVID vaccine particularly, if they think their information is going to be disseminated. So that is, I think, a valid concern with what we're seeing these days. So I will certainly be voting with whatever minority or majority report that would be voting for this bill. I think it behooves us to encourage folks in whatever way we can, right?
Thank you, Representative Libby. Representative Evangelos?
Thank you, Senator Carney. I just wanted to point out that when we run into things like this, sometimes in the Judiciary Committee, we'll vote and then the committee will have a short discussion about writing a letter to the department asserting that legitimate concerns have been raised and that they need to make the size of that box bigger. That's a legitimate letter that we often write the Attorney General or one of the departments when something like this comes up. I'm prepared to vote, but I think a letter should go out to the department to make sure that the print and the box are big enough so people are seeing it. It seems like a simple ask and a simple fix. Thank you.
Thank you, Representative Evangelos. That's an excellent suggestion, and I think we should follow through on it. I appreciate you bringing that up. Committee members, are we ready for the vote? Thank you, Ms. Panett, for taking the vote. And this is on Representative Sheehan's ought not to pass motion. We're ready.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
I vote no.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Votes no. Sorry, dog was barking.
Representative Thorne votes no. Representative Evangelos.
That sounded like a yes vote on that first noise. Representative Thorne. I'm voting yes.
Representative Evangelos votes yes. Representative Newell. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 5 members voting in the affirmative, 6 members voting in the negative, and 3 members are absent.
Thank you very much. And with that, the work session on LD 402 is.
Wait. So the people who voted ought not to
Thank
pass.
you.
Do you all want something? I mean, you didn't vote ought not to pass. You voted no on the ought to pass motion. Do you want an ought to pass as amended, or you want an ought to pass?
I would like ought to pass as amended because I think we need to recognize that the department is already doing this and make sure the language reflects the current practice.
Okay. And are there any other reports other than that? No. Okay, so there's no straight ought to pass. Okay. I will bring it back for language review. Thank you.
Thank you, Peggy, and thank you for catching me before I moved on to the next
Sophie
matter.
and I are good at that.
Yeah, and as you are at everything that you're doing for the committee. Thank you so much. Okay, so now we're gonna, that concludes the work session on LD 402. And so now we will move on to our work session on LD 363. This is an act regarding the statute of limitations for injuries or harm resulting from, I'm going to say PFAS substances, sponsored by Representative Pluker. And Peggy, would you like to provide us with the bill analysis?
Madam Chair,
Yes, Representative Moriarty?
are we taking this together with 627?
Well, I think for work session purposes, we take them separately because we'll have to vote on them separately.
Okay.
I understand that, but I think your discussion is going to be the same. So once you have the discussion, then you can vote on one and vote on the other.
Okay,
Right.
yeah, so let me just correct the record then. So we're doing a work session discussion that will address LD 363 and 627, but we'll vote separately on those measures. And so go ahead, Peggy.
Right, so
Hold on, we have a whole bunch of hands up. And
Okay.
I think that Representative Evangelos was first, so go ahead, Representative Evangelos.
Madam Chair, I believe that we received testimony information that these are identical bills. They do the same exact thing. So we're trying to save time today. So if Peggy can establish that they're identical bills, we usually just, I don't care which one. It's not about who, what, and where. We vote to kill one of them and then vote on the other one. It's just to expedite a process. Sometimes a sponsor will come forward and say, Joe's bill does the same as Sally's bill. So we got to kill one of them. I'm just trying to expedite the date, but let Peggy weigh in on that.
No,
Sorry.
I think we all recognize that that's what we need to do. And I was just trying to take up the first one, thinking that we would resolve it and then vote not to pass on the duplicative bill. Representative Babbage, you're next. And you're muted.
I apologize. I was about to make a motion, but I'm willing to wait until the conclusion of analysis if you want to go through that.
Go ahead and make a motion.
Okay. We have two bills. They are identical. Normally, the procedure would have been, if in a non-COVID world, that the first one submitted would be the sponsor and the second one submitted would be the co-sponsor. I merely move to pass on LD 363.
Thank you, Representative Babbage. Is there a second?
Second.
Seconded by Representative Moriarty. And Senator Keim, did you wish to speak?
I was only going to ask Peggy to confirm for me that both bills are identical.
Well, as my geometry teacher used to say, they're only identical if they're exactly the same. And they're not actually exactly the same. The language is the same. The format is slightly different. There's a separate paragraph in one of them, but the language in that paragraph is just tacked on to the end of the first paragraph in the other bill. So
okay, so but substantively
it's exactly the same.
Okay, thank you.
Thank you for that clarification, Senator Keim and Peggy. Okay, Peggy, we are ready for your bill analysis, I think.
Okay, thank you. So usually the statute, this is statute of limitations day, by the way. The statute of limitations for a tort is 6 years. And it's from the time that the cause of action accrues. And what these bills both do is they're saying, don't start that clock running until the damage, the harm from whatever that activity has been discovered. So it would still be 6 years, but instead of whatever date you're basing it on, depending on who would be the person you're holding responsible for the damages, we're going to wait until you discover or reasonably should have discovered the injury that was caused by that person's actions. So that's what this bill does. It focuses on any harm or injury caused by a perfluoroalkyl or polyfluoroalkyl substance must be commenced within 6 years after the plaintiff discovers or should have discovered the harm or the injury. It also addresses the Maine Tort Claims Act. And so it just establishes a discovery rule. We do have a discovery rule for medical malpractice, and it's shorter, but so we do have that's about the only other discovery rule we have in the state, if I'm remembering correctly.
I think that's right as well.
And that's a very limited medical malpractice. It's something like something left in a surgery. It's not general medical malpractice. So it does not. So it specifically says it does not affect the application of notice requirements for filing under 8107, which is the Tort Claims Act notice requirement or the statute of limitations for the Tort Claims Act. So if you're dealing with a governmental entity, those still apply if the governmental entity is going to be the defendant in these cases. You obviously had a whole lot of testimony on this, and this is one of the recommendations from the governor's PFAS task force. Some of the members, I believe it was a majority of the members of that task force, thought there should be this discovery rule. And in fact, the governor's office does support the discovery rule. Their testimony against it is that you're opening up claims that people thought were that didn't realize were going to happen, and that you buy insurance because you know what the risks are, and so you can figure out what those costs are and have some predictability about liability in the future. There were folks who testified neither for nor against because they were concerned about the application. Is it going to apply to, you have the Maine Tort Claims Act protecting water treatment plants that are owned by municipalities, but what about the private water treatment or sewer utilities that aren't covered by the Tort Claims Act? And I'm just trying to figure out if everybody else, this is an issue that of course is being dealt with all across the country. NCSL has some information. Many states already have discovery rules for harm caused by hazardous substances. And I believe there is one other state, might be New Hampshire, that is focusing their discovery rule on PFAS. But most other states address it through more general hazardous substance damages. Okay, I think I'm done.
Thank you, Peggy. Representative Hagan, go ahead with your question.
Thank you very much, Madam Chair. I had to move to my truck. So apologies for the background. It's my Ford pickup. Anyway, the sponsor of one of the bills, Representative Perry, has an amendment and would like to address the committee. And I would like to ask if he could do that.
Okay, I have, I'm bringing him through cyberspace right now.
All right, thank you.
Representative Perry, thank you for joining us, and Representative Pluker has also joined us. And I would just ask if you could both let us know whether this is well, first of all, let me ask you, Representative Pluker, are you also proposing this amendment?
I have not seen the amendment.
Okay, thank you. Okay, Representative Perry, if you can please activate your audio and video and let us know about your amendment.
Hi, thank you. Thank you very much for having
welcome.
me on, Madam Chair. Yeah, and I just wanted to echo real quick what Representative Babbage said, and I spoke to Representative Pluker. I didn't care one way or the other, and he didn't either on which bill you used. They're virtually identical. I believe that the analyst has been working with Kate Knox and maybe Ben Gideon on the amendment. There was a small issue about the retroactiveness of this because one of the people that brought this forward in the last legislature that Representative Ingerson brought is in my district, Mr. Stone, and also the issue up at the Tozier Farm. They just wanted to make sure that the look back for them on the statute of limitations that they'd be involved. So I'm not the lawyer in this group, so I'm in full support of amending it as the analyst has been working with the other lawyers on exactly how that might work. But as I said during my testimony originally, this started in my district. It spread through other places in Maine. And if you don't have an issue in your district now, you're going to, because this is going to be a big issue. So hopefully we can come to something on this to help those farmers and the people with the water problem and stuff. It's really important. So I would kind of defer to, I think Ben Gideon's on the call too, but I think Peggy's been working with them on an amendment.
Thank you very much, Representative Perry. And Representative Pluker, I know that you had your hand up. Is there something that you wanted to add?
No,
before
thank
we
you. I
turn
was
to the
just trying
amendment?
to get pulled into the meeting.
All right, great.
Get it.
Well, we're glad that you're both here. And so Peggy, are you able to share that amendment?
Actually, you know, I had a conversation a while ago with Kate Knox, and I've really been tied up. I have not been working with either her or Ben Gideon on the amendment. So if they have it, maybe they can share it or email it to me and I'll be happy to share it.
Okay, let me do this because I think that if there is a proposed amendment, we should incorporate that into our conversation. So I'm going to bring Ben Gideon onto the panel and ask him if he could share with us the substance of that amendment. Welcome, Mr. Gideon, to the Judiciary Committee. It's nice to see you.
Thank you. Thank you for having me.
Yeah.
I've been following your progress all day.
I bet. Can you please share with us the amendment?
So I actually hadn't crafted the language specifically, but basically what it needs to do is to revive any statute of limitation that has already expired. As many of you know, the PFAS contamination problem dates back to the 80s and 90s. So for my clients, the stones, the chemicals that were deposited on their property occurred in probably the late 80s and early 90s. And that's true of many other farmers across the state. So if you take 6 years from those dates, their statute of limitations, you can make the argument is already expired. And the way the courts address legislative changes to statute of limitations is that they will only apply them prospectively unless the legislature is clear and unequivocal that the statute is meant to apply to revive statutes of limitations that have already expired. So it needs to, and I believe there's an example of that perhaps the legislative analyst could comment on in a bill that was passed last year or last session or recently on the paper streets bill, if you're familiar with that. And in that case, the legislature provided a 2-year window, I believe, for people whose claims had already expired to bring forward claims, under the new statute. So I don't think a window would work here though, because the problem is most landowners and farmers they're not aware of whether their property is contaminated yet because they haven't been tested. And just the testing process itself can be very expensive. So.
Yeah, thank you. That's helpful. And you may not be aware of this as the committee members are, but we're actually about to do a deep dive into revival issues in conjunction with a couple of other bills that are a little bit further down on our work session list today. So this is a great suggestion. And I think we actually are in a position to understand and those issues. And we appreciate you bringing them forward to us today. Thank you very much.
Thank you.
Yeah. Committee members, are there questions? Let's start first with questions for either of the bill sponsors, and then we'll move on to we'll send them back to the attendee space and ask questions of Peggy. So and we'll also ask Mr. Gideon if he would entertain any questions, although I think the revival issue will be better addressed by the Attorney General who's with us today. So questions for the bill sponsors. Representative Evangelos?
Oh, excuse me.
We're not able to hear you, Representative. Thanks.
Thank you, Madam Chair. Actually, my question was for Mr. Gideon, and I just wanted him to help me understand, because I think I do, but I need his guidance.
Did you want him to explain the revival concept a little bit?
No, I want to ask him a question. May I proceed?
Yes, go ahead.
So, Mr. Gideon, I'm reading the summary of the bill, and it says the substance must be commenced within 6 years after the plaintiff discovers or should have discovered such harm or injury. So your worry is the within 6 years after the discovery that may involve a discovery that has the statute of limitations already expired. So you don't think this language is strong enough, and we need to address that. Am I getting that right?
That's correct. I mean, if you look back, it was alluded to the sexual assault revival of the statutes. For example, the courts have ruled in those cases that for claimants whose cases had already expired at the time the legislature amended the statute, even though the statute became indefinite, it did not revive claims that had already expired before the statute became indefinite. So our concern here is that when the 6-year clock ran on the time when the chemicals were deposited on people's property, the argument could be made that the statute had already run at that point. And even though you'd be changing that now to say the clock doesn't begin until you discover, that would be it would have to apply retroactively to the claims that had already expired, or the courts may conclude that the legislature only wants that to be the rule going forward.
That's great. Thank you.
Yeah.
Pretty hard to know about what you didn't know about, and then have the statute of limitations expire on you, and then you find out about it. So it's a good remedy, and I thank you for making it crystal clear for me.
Thank you very much, Representative Evangelos, and thanks for the answer, Mr. Gideon. So committee members, any other questions for either of the bill sponsors or for Mr. Gideon? Go ahead, Representative Babbage.
I guess, whereas Mr. Gideon is here, I will, we actually had this discussion about prospectivity, and the question became, once this is passed, it's the only statute on the books. And when the person discovered or should have discovered it, would be the law of the land. Isn't that the case? Or
I mean, if we had to go to court to make the argument, that is the argument we would make. But I can tell you, in reading the cases construing legislative changes to statutes of limitation, they're construed very strictly against the claimant. And the best reading of the cases is that unless you explicitly make it such that it would revive already expired statutes, the courts are likely not to revive them. And so you're right, it's the law of the land, but it's only the law of the land as of September 2021. It wasn't the law of the land in 1996 or 2006, right? So that it just sort of begs the question of which law applies to the case. And you can resolve that ambiguity by legislative decree. I mean, there will still be constitutional challenges that could be raised, but those are fairly weak. The ex post facto doctrine of the constitutional law does not generally apply to civil matters. It's only a criminal doctrine. So I think as long as you're explicit in your intent and put it into the statute itself, then there would be, the likelihood is that that intent will be effectuated and the courts will honor it.
Yeah, I guess what I'm saying is, or what I'm asking is that the nature of the law itself deals with a historic application, either the date of discovery or the date you should have discovered it. So I don't think this might be necessary, but it certainly would clear up an ambiguity, is what you're saying, in order that the claimant have justice.
It's better to be safe than sorry, but yeah.
Thank you.
Thank you very much, Mr. Gideon and Representative Babbage. Committee members, any final questions for either of the bill sponsors or for Mr. Gideon? I am not seeing any. Thank you, all three of you, for joining today. We appreciate your contributions to the work session.
Thank you.
Committee members, please raise your hands if you have questions for Peggy. And Representative Libby, go ahead.
I have less question for Peggy and more of a general comment on where we're at now, having heard from Mr. Gideon with the amendment. And so I just wanted to bring forward that obviously we have these two bills. We currently have a motion for one. LD 627 is a bill that is very bipartisan, and Representative Perry has done the legwork to bring in Mr. Gideon for a thoughtful amendment. I think given the nature of the partisan direction we've seen some things head in Maine, it would be a nice gesture to this committee, to our legislature as an example, and to the people of Maine to pass 627 as an example of parties working together, especially with Speaker Fecteau on that bill, as well as Senator Diamond out of Cumberland. So I just wanted to put that out there, and I would welcome any commentary on that from my fellow committee members.
Go ahead, Representative Moriarty.
Thank you, Madam Chair. The only commentary I can offer is that this year, of course, we know that the revisor's office made no attempt whatever to cull out identical bills. They simply cranked them out as they, in their course of business. I had the same situation maybe 6 weeks ago before a different committee in which I was the sponsor of a bill that was identical to someone else's bill. Mine happened to be filed first, and that committee simply announced that as a matter of procedure, they take the first filed bill in the event of two or more identical bills. They expressed no judgment in terms of merit or who else had signed on. It was just a matter of who got to the line first, for what it's worth.
Thank you, Representative Moriarty. Representative Evangelos, and then let's move on to talk a little bit more about the substance of the bill. Go ahead.
Representative Moriarty's right. This never even should have happened. And one way we can resolve it is find out who had the LR number first, and you pretty well can figure it out from that. Anyways, Representative Libby, I really appreciate your idea, and because of everything that's going on, 98% of the time I would vote or agree to go along with it. We don't, I think, probably have to vote on this. But anyways, Representative Pluker is my best friend in the legislature. He's my seatmate and he's my neighbor, and we're buddies. So I'm not going to be able to join you on this one, although I join you in spirit.
That's a really thoughtful comment. Thank you, Representative Evangelos. Representative Babbage, I just wanted to call ask you, since you made the motion on LD 363, would you accept an amendment to include language that revives any claims that have expired in order to subject them to the new discovery rule statute of limitations?
Madam Chair, I would like to hear from the Attorney General if they're available. Are they in the panel?
Yes, I'm not sure that we asked him with regard to these bills, but let me invite him over and we can ask him. Just a second.
I guess I would comment, Madam Chair, that I am wary about opening this up more than we need to, but in order to accomplish coverage, for instance, of the Fairfield folks and the Arundel folks, we certainly are answering their call for justice in this legislation. So, but my first response to this after contemplating it was that it is covered by this bill as written, but if the Attorney General says that it may not be, then I would be certainly welcoming that amendment.
Okay, yeah. And Representative Babbage, it's a call for justice on behalf of people throughout the state and the state itself, because
Exactly.
as a state, we're investing a lot of resources in cleaning up the PFAs. So Representative Moriarty, you have your hand raised, but we wanted to pose the question to Attorney General Taub. Do you have something that needs to go first? Okay.
Nope, I'll wait.
So welcome, Mr. Taub. We are completely putting you on the spot because I don't think we asked you about these bills.
Oh.
Have you heard our conversation, and are you able to weigh in on the appropriateness of revival language in these PFAS bills?
You have a real asset in Peggy because she gave me a heads up that it was possible that you may be asking me about these other bills. So I thank her for that. That said, I don't really know much about the substance of the two bills. In other words, I don't know what kinds of claims they're trying to get at. But I will say that I agree with what Mr. Gideon said, which is that if there's no language in the bill that expressly says that the intent is to apply this to claims that have already expired, it's likely that a court would only apply this prospectively. So if there's a claim that's expired, it probably would not be revived by this legislation in the absence of some clear statement from the legislature that was the intent. In the other two bills that we'll be talking about later, there is specific language in both of those with respect to sexual abuse of minors. So there's no question in those bills that that's the intent. This one, I don't see language like that. I will say, I guess I part ways a little bit with Mr. Gideon in terms of sort of the constitutional issue. And we can talk about this either now or in the context of the sexual assault bills. But I will say that whenever a legislature tries to revive expired claims, there is going to be an argument that it violates the due process clause because a number of courts have held that if you're a defendant, once the statute of limitations has run on your claim, and so the claim is now expired, you have what courts sometimes call a vested right in forever being free from that claim. And so there's some limitations on the extent to which the legislature can revive that expired claim. And I don't know if you want to discuss that in more detail at this point or if you want to wait. The other thing that I'll say, and this is sort of, I don't really know what kind of claims these are trying to get at, but usually the magic words in the statute of limitations is that it's set from a certain number of years from when the cause of action accrues. And cause of action accrues is always subject to some judicial interpretation. And so I don't think in this case, for example, it would necessarily be that the cause of action accrues at the moment that the substances are deposited on someone's land. A court might hold, and this is the case like with asbestos cases, a court could hold that the cause of action doesn't accrue until someone actually suffers an injury from the substances. Or for example, like the medical malpractice surgical sponge case, the court there held that it doesn't accrue until the person actually discovers that they have a sponge. So like all that's just a long way of saying that it's kind of an open question right now what the statute of limitations would be for these PFAS claims. But again, I do agree that absent language, specific language, a court would not likely apply this retroactively.
And if I might, Madam Chair, Mr. Taub, if language were to be included, would it be date specific?
Well, I'm not sure if I understand the question. I mean, one option would be to say that expired claims have to be brought within a certain period of time. And that kind of gets into the two sexual assault bills, where I think there's one that revives expired claims for like an unlimited period of time. And then there's another one that says you have to bring once the claim's revived, you have to bring your action within, I think, 2.5 years. So Representative Bebbage, I'm not sure if I answered your question or not.
I think you gave us some options. I'm not sure as to what the amendment proposed was for us to adopt here, more precisely. But thank you for that. I appreciate it.
And I think, Representative Babbage, that what we could do is that we could propose to amend the statute in order to create language that would ensure that claims that had been time barred, if they had been based on the strict 6 years from application, to revive those claims. That I think that if we can describe the effect and coverage that we want, that we will be able to work with Mr. Taub and with our analyst to come up with the appropriate legislative language, if that's the direction the committee wishes to go.
Thank you. And given that, which I think is a very fine suggestion, I would accept the amendment to the motion. So, and I'd like to just clarify that although I mentioned Arundel and Fairfield, I'm normally very reluctant to craft legislation that is directed to specifically address an individual's legal dilemma. But this is something that could be potentially impactful to a great number of Maine citizens. And so I will clarify that's my directive here. So thank you so much, Madam Chair.
Thank you. And it does have a statewide impact because, again, the state is working very hard to clean up all of this, the PFAS contamination. So then the motion has been amended to address revival of claims, and we'll go back to hands that have been raised. And Mr. Taub, if you wouldn't mind staying on the panel for a little bit, we might have some more questions for you. Representative Moriarty, go ahead.
Well, thank you, Madam Chair. I think we're in a bit of a conundrum here because I think we really, in some fashion, we need to get a sense of the committee as to whether the committee intends to apply this retroactively to the date of the spreading of the sludge. And then if that's the intent, the question is who drafts the language that would be sufficient to satisfy the very stringent legal standard. It was indicated that retroactive revivals are strictly construed against the plaintiff. So this is going to take some expertise. The question is whether Attorney Gideon would be willing to provide suggested language to the parties with whom he has been working, or whether Peggy has samples of such language from prior situations already in her possession.
Yeah, I can address that, Representative Moriarty, and that's a good point, is that how are we going to actually get the language? And I think it makes sense if we are comfortable as committee and the folks who are inclined to vote for legislation with this amendment, that we can describe the impact that we want and rely, I think, on Attorney Gideon as well as on our analyst and Attorney General, Assistant Attorney General Taub, because I think between all of those resources, we will be able to effectively address that issue. But you're right, it's going to take some focused work.
Yep.
Senator Keim?
Thank you. I just wanted to weigh in on just my concerns around the bill and just the way that I'm viewing this and my hesitations. One of the biggest issues I have with this is that I see it creating sort of a litigious environment where there's fingers pointing in every direction. And the real winners here are lawyers, and it's not the people whose land needs to get cleaned up, and it's certainly not like the local businesses that were also sort of inadvertently tied into this. And so I've been really struggling with voting for this for that reason, because what I see is such a much more broad issue. I mean, right now, we're still using these substances everywhere. They're in everything we use. They're everywhere. And yet at the same time that we allow individuals to sue somebody for what's happened to their property, they're still being spread. It's still being used. It's still in everything. And so I know that's another bill and it's for another time, but again, it just points to the fact that I think what we're doing here is enriching lawyers, and what a remedy that really needs to happen is not only do we need to just frankly outlaw these things from use, but then we have a more global problem, and it's really one that nationally and then as a state we have to take on funding this. And I would much rather see us channeling the funds to these people so they could have remedy, rather than this law that just allows people to be tied up in endless litigation, and who knows when they actually get compensation. So I feel like we're giving them this, and these people need something. This is horrendous, but we're not actually giving them what they need, because we're giving them endless lawsuits and we're giving lawyers money. That being said, I discussed this with someone I respect, and asked about how to approach this, and was told also that it's hard for us as the state to stand in the way for someone to seek a remedy. And so with that, I understand, and I think these people do, I don't want to stand in their way for a remedy, but I guess I would say that my vote in favor is very hesitant, because I think they're thinking they're getting something that I feel in essence they are not. And so it's a lot of concern. And I hope that we as legislators, as other issues come before us that deal with this, that we remember that and think, okay, this is a global issue, not a singular issue. And, I am concerned about our local businesses that are going to get wrapped up in this, because they ended up sort of being middlemen. They didn't know the products they were using, just like, anyone that uses dental floss didn't know they were contributing to this problem, or using nonstick bakeware didn't know they were contributing to this problem, but we all have been contributing to this problem. And so to leave a certain few holding the bag for a global problem is another issue I see with this type of legislation. So I felt I needed to share all of that, because I think making certain that we weigh things is important, and the end result of this, I'm afraid, is not going to be what I want to see happen for those people.
Thank you, Senator Keim. I did want to respond because I agree with you 100% that we need to stop having these substances come into our state and be used anywhere in the world. And I did, because I sit on the Environment and Natural Resources Committee, I just wanted to reassure you that there is really good work happening in that committee right now to address this issue and to prevent items with PFAS in them from being sold and used in Maine so that we can stop creating the ongoing situation. A lot of the farm contamination that we're dealing with right now has to do with spreading biosolids, and that actually stopped a number of years ago. And so there have been some efforts. And I also think that in addition to helping farmers resolve their personal situations, I think that dealing with the statute of limitations in a way that allows claims to be brought forward can help the state also advance claims to recover from the harm that our state has suffered in remedying all of this. And so I do think that there's a lot of good to come out of this legislation. I appreciate your openness to it. Representative Libby?
Thank you. I just wanted to get on the record. I appreciate Representative Evangelos educating me regarding usual protocol, and I just wanted to make note that Representative Perry's bill is LR 534 and Representative Pluker's bill is 788 for LR.
Representative Evangelos?
Well, that's how it usually goes. But I wasn't using accepted protocol. I was making a statement about my friendship, but I understand.
Committee members, is there additional discussion regarding the pending motion, which is ought to pass as amended with an amendment that would ensure that claims which might have been expired under the current statute of limitations could be allowed to be brought on behalf of the people who were injured by the PFAS contamination? Go ahead, Senator Keim.
Yeah, just to clarify on that. So what we would be doing is agreeing in theory, but then looking at language later. Is that right? Okay.
Yeah.
And then I guess just to follow up on what Representative Libby said, would we want to just follow usual protocol, and that way when other bills come in front of us that are exactly the same and have two sponsors, would we want to just take the one that was submitted first, following what would have been protocol if we followed our usual one? I don't know that either sponsor cares, and I guess we could have asked them when they were with us, but.
Yeah, I think Representative Perry said he didn't care actually, but I don't care. I do think that this is such a huge and devastating problem for farmers in Maine and for our state as a whole that we should find a way to move forward and not let this be a stumbling block, because it is a really significant and weighty issue. Representative Babbage?
Yeah, thank you, Madam Chair. I'm hoping that the discovery standard remains with some clarification that it can be retroactive in that wording.
Yeah, that's the intent.
And regarding the bills and so forth, I think I'm going to ask that the motion stand as it is. When Representative Libby brought this up, I actually had to look at co-sponsors. I had no idea who was co-sponsoring the bill. I knew Representative Pluker was an independent, but I didn't. So I'm not thinking this is part of a Democratic Republican thing. I really, but I appreciate the discussion, and we'll go forward.
Representative Hagan?
Thank you, Madam Chair. In speaking with Representative Perry about this earlier today, he made it very clear he does not care which bill is used.
Thank you, Representative Hagan.
And
Committee
if I
members?
may, I just add one thing, Madam Chair. I want to thank Representative Perry for bringing this forward. And I also want to thank Representative Ingerson, who brought this to us last year. I don't want him to be forgotten in this process. I appreciate that.
Yeah, thank you. Committee members, any other discussion before we move on to a vote? Representative Evangelos?
No, I'm all set. Thank you.
Okay. And Representative Babbage, or is your hand residual?
I'm
or-
sorry, it is not. It usually is there, but no.
We're all going to be so happy when we are not raising electronic hands anymore. Committee members, are there additional questions for our analyst, for Peggy? Is there additional discussion of the proposed legislation or the pending motion ought to pass as amended? I'm not seeing any. Ms. Panett, could you please call the roll?
I would be happy to, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kine.
Yes.
Senator Kine votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And so LD 363 passes out of committee with an 11 to nothing to 3 vote. And that ends the work session on LD 363. And we'll move on to a work session on LD 627, expressing a lot of gratitude to Representative Perry for bringing the legislation forward and also for alerting us to the very important amendment. Representative Evangelos, your hand was up first.
Yeah, I just want to make sure I heard it right. That was ought to pass as amended, right?
Yes.
Okay, thank you.
Representative Moriarty?
Thank you, Madam Chair. With thanks to Representative Perry, I move that LD 627, I move ought not to pass on LD 627.
Thank you. Is there a second? Representative Sheehan seconds. And Ms. Panett, I think we're ready for a vote on the motion.
Thank you. Senator Carney.
Actually, I should just check in with the committee. Is there any discussion? Not seeing any. Okay, thank you. Yes.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorn votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Senator Sanborn. Senator Sanborn is absent. Senator Kime.
Oh, I'm sorry, I had to take a phone call. So what are we voting on?
The motion is ought not to pass.
On what bill?
LD 627.
Oh, okay, yes.
Senator Kime votes yes. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Newell. Representative Newell is absent. 9 members voting in the affirmative, 0 members voting in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And that concludes our work session on LD 627. And so we'll move on to our next bill, which is LD 690, an act to ensure that victims of assault, battery, and false imprisonment, including victims of domestic violence, have parity under tort law. And let's see. Let's start with the bill sponsor is not in the attendee space. And but Peggy, can you please give us a sort of a more of a summary analysis of this? And again, let us ask you questions if there are specific areas where we want to do a deeper dive.
Okay, I hope so.
Thank you.
So the standard statute of limitations is 6 years unless something else applies. And that's section 752. This bill amends section 753 of Title 14, which right now says actions for assault and battery and for false imprisonment, slander, and libel must be commenced within 2 years after the cause of action accrues. So it's a 2-year statute of limitations rather than normally a 6, like for a car accident. So what this bill would do is strike out assault and battery and false imprisonment from this statute, which would mean the general statute of 6 years from the cause of action accrues would apply. You can't bring a case after that. And so that's what the bill does. By striking it out of this statute, it makes the general statute apply to those tort claims, assault and battery and false imprisonment. Professor Riggins from the law school had done research and discovered that there was an act in 1625 or 1623 which somehow sorted out assault and battery from other torts, and she surmised that this was just an artifact of laws from way back when. So the idea here is people who are victims of assault and battery actually have to bring their civil claim for damages faster than somebody who suffers any other kind of tort. There was although it's not raised in the bill, there was a question raised at the public hearing. I think Senator Carney raised it about what happens to those people who were victims of assault and battery or false imprisonment longer ago than 2 years, but within the 6 years, does this revive their claims? And so we have that same question that we just talked about a little bit, and we're going to probably talk about a lot more in the last 2 bills today. That was not necessarily contemplated by this bill, but obviously the question is raised. I don't know if you need anything more about the bill itself.
I think that's great to get us started, Peggy. Thank you. Senator Kime, go ahead.
Thank you. I was just going to make a motion not to pass.
I'll second your motion. Committee members, is there any discussion? I would just actually like to address briefly the revival issue. I know I asked about it in the original hearing on the bill, and the sponsor really asked us to do something quite simple with this bill, which was to change the statute of limitations going forward, and did not propose a revival. And I think we've heard that revivals can be subject to a couple of different kinds of challenges. And where this is such a simple, straightforward proposal, I think it makes sense to not incorporate revival language. I would like to propose, and I probably should have said this before I seconded your motion, Senator Keim, but that we make this an emergency measure so that it does go into effect sooner as an alternative to proposing any kind of revival language. I don't know if you would accept that as an amendment to your motion.
I would. I can't imagine that anyone has any issue with that, but I would like to hear from the committee if they do. But I am fine with that, with an emergency enactor.
Does anybody have concerns about including an emergency enactor? Okay, thank you, committee members. And so there's a motion is ought to pass as amended with an emergency enactor. Committee members, is there discussion on this legislation? Is the committee ready for a vote? Looks like we are. Thank you, and thank you, Ms. Panett, for joining us.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. So the measure LD 690 ought to pass as amended with a vote of 10 to 0 with 4 absent. That concludes our work session on LD 690 and brings us to the final 2 pieces of legislation on our agenda for today. These are work sessions on 2 different bills that address the same issue, which is the statute of limitations for claims by victims of child sexual abuse. And this is the set of legislation that we asked a member of the Attorney General's office to provide us with some feedback on regarding revival of claims. And I think if it's okay with everybody, we can proceed by having Peggy give us kind of a summary bill analysis, and then we'll bring Mr. Taub in from into the panel to address the questions related specifically to the revival. And with that, Peggy, we're ready when you are.
Okay, great. Thank you. So the current law for statute of limitations for civil claims, so filing a lawsuit against somebody for damages, basically based on a sexual act toward a minor. Right now, there's no statute of limitations, which means there you can always file a claim, but that only goes back so far because the statute of limitations used to be much shorter. And then it was extended and a discovery rule was adopted. And when the legislature started expanding the statute of limitations, they included an application clause, kind of what we had talked about before, which said, okay, this applies to everything constitutionally going forward. And it also applies to claims whose statute of limitation hadn't already run. So if the statute of limitations was 6 years, the legislature passed a law that extended it to 12. It went back and pulled in all those potential claims that were 5 years old, that had the 6-year statute of limitations hadn't run yet, and extended it. But it does mean that there is a point in time where when the cause of action accrued before that, those claims are not, you cannot file a claim under our current law. So both of these bills address that, but in different ways. LD 589, Representative Gramlich's bill, amends the Tort Claims Act to the main Tort Claims Act applies to governmental entities and governmental employees. It has 2 limitations that aren't there in current law for claims against other civil cases. One is a notice of claim provision, where you have to notify the governmental entity that you're going to file a claim against them. And I must admit, I don't remember exactly what that is. It used to be 180 days, and I think it might be a year now. But it also has a shortened statute of limitations, which is 2 years to file a claim under the Tort Claims Act. So that's a special category of claims with defendants. And this bill in section 1 says, hey, that notice of claim, that limitation on notice of claim doesn't apply in these child sex abuse cases. And section 2 says the statute of limitations, that doesn't apply either. Section 3, in the other bills, we were talking about a revival of claims or revival of claims with a window. This is a revival of claims with a window. It says that, okay, all those expired claims, we're going to give you a limited period of time for you to bring those claims now. So rather than them being foreclosed forever, we're going to give you 2.5 years after this passes. You can get your case together and you can file this case. You have 2.5 years to file a claim in court against the perpetrator, against whoever is responsible. And then after that 2.5 years is over, that window's closed, and we're not going to revive those claims forever. We're just reviving them for that short amount of time, which is intended to give a little bit more predictability for anybody whose claims have actually been expired. And then sections 4 and 5 are more kind of procedural. 4 is directing the courts to establish a priority in trial for handling these cases that are coming up in the window, to make sure that they're not foreclosed. And section 5 is judicial training, making sure that all the judges, all the people in the courts are aware of the issues that are involved with civil claims against for sexual abuse of minors. Section 688 is addressing the same thing, except it's very short. It's just saying you can bring the claim anytime for these causes of action, and it explicitly says, regardless of whether the statute of limitations on such actions expired prior to the effective date. And the section it's repealing is the old application section for when we did away with the statute of limitations going forward. That sounds like a whole bunch of gobbledygook. to me now. But so what they're really addressing is people, there's no statute of limitations going forward. So we're trying to pull in cases whose statute of limitations has expired, and do you do it in a limited basis or you do it broadly? And those are kind of your choices between 589 and 688. And this is the real reason why Chief Deputy Taub is here, is to answer some of these revival questions.
Thank you very much, Peggy. Committee members, I know we want to do a kind of a deep dive into the revival concept, but are there any questions that involve other aspects of these proposals that you'd like to ask of Peggy before we do that deep dive? Peggy, I have one question for you, actually. One of the differences between the two bills is that LD 589, Representative Gramlich's bill, does specifically list defined crimes and sections of the criminal code, whereas 688, Representative Brennan's, does not. Is there a preferred practice based on the bill drafting protocols of the state of Maine?
So thank you. That's a fairly easy question, because Representative Brennan's bill actually amends section 752C. 752C defines sexual acts towards minors. So it does include in the statute. And then he adds a new subsection 3 that says, by the way, it doesn't matter if the statute of limitations had already expired, you can still bring your case going forward. Representative Gramlich's bill, that is all unallocated language. So it wouldn't actually show up in Title 14, Section 752C, but it's providing that window for everybody. It still is a force of law, but it's providing the window for those causes of action, if that makes sense. They're actually applicable to exactly the same things.
Great. That was going to be my follow-up question. Are the lists the same? And it sounds like they are. Yes. Thank you very much. Committee members, any questions for Peggy before we dive into revival? Not seeing any. Welcome back, Mr. Taub. We appreciate your earlier contributions and would appreciate hearing from you about the issues that are generated by both of these bills with regard to revival.
Thanks for having me back again. Do you want me just to launch right in and sort of give an overview and then try to answer any questions? Would that make sense?
I think that's a great approach. Thank you.
So as I mentioned before, there's no question that issues can be raised when the legislature tries to revive expired claims. And the two questions the court is going to look at is first of all, is it clear that that was the intent of the legislature? And second, is it going to violate due process rights of the defendant if we allow expired claims to be revived? As to the first issue, as I said before, I don't think there's any question that these two bills make perfectly clear that there's an intent to revive expired claims. In fact, we worked with Representative Brennan on the language just to make sure that there'd be no question if this went to court what the legislature's intent was. And I think the other bill is also perfectly clear. So I don't think that's going to be an issue. I think the thornier issue is going to be this due process argument. And to my knowledge, the Maine Supreme Judicial Court, we call it the law court, to my knowledge, that court has never squarely addressed whether or not the legislature has the authority to revive expired claims. But what they have done is they've said, they've made a few statements in cases that really it didn't involve the revival of expired claims, but in the course of dealing with those cases, and I think for the most part, these were workers' compensation cases, the law court has made statements that seem to indicate that they have concerns about reviving expired claims. So, and I think it's just kind of helpful to read a couple of the quotes from these cases. So one of them is Dobson versus Quinn Freight Lines, which was decided in 1980. And this was a workers' compensation case. And the court said, legislation which lengthens the limitations period on existing viable claims does not have the effect of changing the legal significance of prior events or acts. It does not revive an extinguished right or deprive anyone of vested rights. No one has a vested right in the running of a statute of limitations until the prescribed time has completely run and barred the action. So that last sentence where they're saying that you don't have a vested right until the prescribed time is run, it sort of suggests that the converse might be that once the period has run, then you do have a vested right. And then there's also another case, Morissette versus Kimberly Clark, which is a 2003 case. And again, this was a workers' compensation case where the court said amendments to the statute of limitations may be applied retroactively to extend the statute of limitations, but not to revive cases in which the statute of limitations has expired. So, you know, those two statements from those cases, you know, at least on first blush, and I'll explain why I think that they may not really mean exactly what they say, but at least at first blush, those statements are problematic because they do suggest that in the law court's view, once a statute of limitations has run, there is a vested right. And I'll also say that in 2014, the law court decided a case that actually involves a sexual abuse of a child. It was Angel versus Halley. And there the court basically cited favorably to those other two cases that I just mentioned, and had suggested in there that once a statute of limitations has run, it can't be revived. But I think that the important thing to keep in mind about all of these cases is that in none of them, at least in my view, and I've looked at them pretty carefully, in my view, that issue was not squarely before the court because in none of those cases did the statutes purport to revive expired claims. So the court was kind of contrasting what the statutes did, which was to extend the statute of limitations for claims where the statute had not yet expired, and just sort of contrast it to a hypothetical situation where the legislature was reviving an expired claim. So I don't know if I said that very, very articulately, but let me just try that again. They were looking at statutes that extended statutes of limitations that had not yet expired. And in doing that, they were sort of saying, look, it's not like the legislature was trying to revive expired claims. And then they sort of suggested that if that had been what the legislature was doing, that could be a problem. And lawyers, I know there's a lot of lawyers on the committee. Lawyers often refer to these kinds of statements as dicta, which is they certainly reflect the thinking of the court, but they don't really form a basis for the court's decision. And you can't really put too much weight on them because I suspect that no one in these cases was briefing the issue of whether or not the legislature could revive an expired claim. Because again, that's not what the statutes were purporting to do. So I suspect there was no briefing of the issue. And so I think that these statements, you know, should be read as what they are, which is they certainly reflect sort of the court's thinking at the time, but it wasn't, you know, it was probably not without any kind of briefing on the issue. And it probably really didn't reflect a really sort of careful consideration of the issue. But they are out there. So then on the other hand, if you look at other courts around the country, courts have kind of come down on two sides. Other states have tried to revive the statute of limitations for expired claims in child sexual abuse claims. And we refer to what's happened as a split among the states. There are some state Supreme Courts that have said the legislature can do that, and there are other state Supreme Courts that have said, no, the legislature cannot do that. It's a violation of due process rights. And so it's kind of hard to divine a lot when you have sort of a split like that. But I guess one thing I would mention is that the Massachusetts Supreme Judicial Court did uphold a statute that revived expired sexual abuse claims. And I think that is significant because, you know, since Maine used to be part of Massachusetts, it's our mother state. And so we sort of share, at least early on, we sort of share development of common law. It's not uncommon for Maine courts to sort of put a little bit more weight on what the Massachusetts court has done than, some other court like Ohio or Illinois or something like that. That's not to say that they defer to the Massachusetts courts, but sort of when you're looking at courts when you're looking at decisions from courts across the country, often Maine courts will sort of look a little bit more closely at what Massachusetts has done. And so in the Massachusetts case, the court, definitely acknowledged that there's an issue about whether or not the legislature could revive an expired child sexual abuse claim. But the court said there were really three factors that it was going to look at. It was going to look at what was the public interest that motivated the statute, what was the nature of the rights that were affected by reviving the claim, and then what was the scope of the impact on those rights. And so on the public interest, that was really an easy one for the Massachusetts court. The court said that we're dealing with sort of, one of the most reprehensible kinds of acts. And it's the kind of act where it can result in the victim, for all kinds of reasons, not being capable of bringing a claim within a specified period of time. Because either the victim doesn't really, wasn't aware of what happened to him or her, or just wasn't in a position for whatever reason to bring a claim. So a whole host of reasons why in this particular kind of issue or this particular kind of claim, it's a situation where we can expect that there to be maybe a bigger delay than you typically expect in bringing the claim. The court then acknowledged that yes, defendants do have sort of a right in not having to defend against stale claims, and sort of there is some unfairness in saying to a defendant, even though the defendant thought that the claim had expired, that they were home free, to sort of say to the defendant, no, we are going to revive this claim, and now you're going to have to defend against a claim that may arise out of events that happened 20 or 30 years ago. But then sort of on the third factor, the court really sort of looked at the balance between sort of the public interest and the impact on the defendant. And I think there, sort of, the two factors that the court really thought were important were, again, this issue that when it comes to child sexual abuse, like this is a kind of claim that there's often very real reasons why the victims are not bringing the claims in a more prompt fashion. And so we want to sort of do something to make sure that the passage of time alone isn't what defeats the claim. And then the other thing the court said is, it's not like we're declaring something is unlawful that was lawful when it happened. I mean, when these defendants, however long ago it was that these defendants committed their acts, it was always unlawful to do what they did. And so it's not like we are suddenly creating a claim based on acts that were completely appropriate at the time. The acts were always unlawful, and the only reason that there might be a burden or there might be an obstacle to bringing a claim is just the passage of time. So at the end of the day, the court said, yes, we are going to allow the legislature to revive expired claims. One distinction, and this might be something that the committee wants to consider, is in the Massachusetts statute. I think that they still had a 35-year statute of limitations. So there was still like an end date when the claim would expire. And so I think, well, so let me just sort of tell you what I've talked a lot, and so let me just sort of get to the short answer, which is that there are definitely issues that arise when the legislature tries to revive claims, and I can't predict how the law court is ultimately going to rule. It will almost certainly be challenged if someone does bring a claim against the defendant that had expired. There's no doubt that the defendant is going to raise as an issue that it's unconstitutional to do this because the statute had expired. And I think, on the one hand, we have some sort of unhelpful statements in dicta from the law court, which are going to, have to be contended with. But on the other hand, we do have, good cases from other jurisdictions, including Massachusetts. And frankly, if there's any claim, where the legislature should be allowed to revive it, I sort of feel like child sexual abuse claims are like the quintessential prototype, because it's a reprehensible act combined with good reasons why there's a delay in bringing the claims. So I wish I could give you sort of a more definitive answer, but all I can say is that it's definitely defensible. It's hard to predict. And I will say that I think in terms of making the statute more defensible, I think, the idea of having like a window, like one of the bills does, is probably more defensible than just saying that once the claim is revived, you're free to bring it however many years from now. again, I think they're both defensible, but just in terms of, more or less defensible, I think I'd have to say that sort of the 2-year window is something that a court would say, well, this is a restraint. We are reviving claims, but we're also making sure that the plaintiffs bring the claims within a very short time period. So I think that would be a helpful thing. But again, I think both of the bills are defensible. And so I've said a lot, and let me stop there and see if there's questions.
Thank you very much. That was a really great explanation. I know that there are going to be questions, and I see Representative Thorne has raised his hand. Go ahead, Representative Thorne.
Thank you, Madam Chair. And only as a point of clarity, I'm a non-attorney, so sometimes I need things dumbed down for me. You mentioned revival of expired claims about a dozen times in your explanation. And I'm curious as to exactly what that means as far as from a legal standpoint. Is this something that has been presented in the past only, or is it something that's new, that's never a claim that's never been brought forward, or is it only revival of a claim that never got prosecuted or never got? Maybe you could explain that to me.
Yeah, no, that's a great question. And I probably should have started with that explanation. So what I'm referring to is claims that accrued. In other words, someone was subject to sexual abuse or sexual assault, but they never brought a claim. In other words, they never actually filed something in court before whatever the applicable statute of limitations was at the time. So if someone committed the act in 1970, and I'm just making up dates because I don't know what the actual statutes are, but let's just say
Sure.
that it committed the act in 1970, and at that point the statute of limitations for sexual assault was 3 years, but the victim didn't bring a claim by 1973, then I'm referring to that as an expired claim because it expired by virtue of the running of the statute of limitations. Does that answer your question, Representative Thorne?
Yes, and if I could ask a follow-up question, Madam Chair.
Yes, go ahead.
So, and essentially, I just for point of clarity to make sure that I'm clear on what this bill proposes is that if I was sexually abused back in 1970 and I never did anything about it, I could now take that to court today. Is that what you're saying?
Yes, if either of these two bills passed, you could then bring that claim. Under one of the bills, you would have an unlimited amount of time to bring the claim. Under the other bill, you'd have to bring it, I think, within 2.5 years of the effective date of the bill.
One more follow-up.
Go ahead.
As the law stands now, I can't do anything about that back in 1970 that happened. Is that what I'm understanding?
Well, I mean, of course I'm a lawyer, so I can't say it's impossible because there are some arguments that people could make. Like, for example, the statute of limitations is told if the person's out of state, it's told if they're still a minor. But I think just to give it like a simple answer, in most cases, and again, I don't know what the statute of limitations was in 1970, but assuming it was 3 years, in most cases, that's correct. You would not be able to reach back and now file a claim for something that happened in 1970.
Thank you. That helps very much. Thank you. Thank you, Madam Chair.
Sure, thank you. I think that Senator Keim was next. Go ahead, Senator Keim.
Thank you. I wonder if you could, nice to see you again, Mr. Top. I was wondering if you could just speak about, it seems like this is unconstitutional. So can you just talk to me about how that the courts would see that and the constitutionality aspect?
Yeah, so I didn't mean to suggest it's unconstitutional. What I was trying to express was that there is definitely a constitutional challenge that could be brought. If either of these bills gets passed, a defendant could definitely argue that the legislature overreached and acted unconstitutionally in trying to revive expired claims, but it's just impossible to predict whether that challenge would prevail or not. Again, we have some statements from the law court that indicate that the challenge would prevail, but then we also have case law from other jurisdictions, and we have some compelling policy reasons. So all I'm saying is that there is a constitutional issue, but we just can't predict what a court's going to do. And I think ultimately that's what's going to have to happen, is it's ultimately up to the law court to decide whether or not the legislature can do this or not. Does that help, Senator Keim, or?
Yes, thank you.
Okay.
Representative Libby?
Thank you, Madam Chair. My question is just a clarification. Both bills only deal with civil, not criminal. Is that correct?
That's my understanding, and I'm no expert in criminal law, but I think there are some different issues that come about when you try to extend the statute of limitations for criminal filings.
Follow up if I can, Madam Chair.
Yes, go ahead, please.
So what is the burden of proof for a civil case for something that was never adjudicated criminally, if it was 30 years ago?
Yeah, so typically in civil cases, it's going to be the plaintiff's burden to prove by a preponderance of the evidence that the sexual assault occurred, that the defendant was the person who committed it, that the person was harmed as a result, but the standard will be preponderance of the evidence.
Thank you.
Representative Rackett?
Well, excuse me. It's taken me a long time to decide whether or not I wanted to speak on this bill in work session or anyplace else. I personally am a victim of child sexual abuse. I don't talk about it much. Happened when I was 10 years old. I stuffed it down and never remembered it again until I was 25. But I'm telling you, it had a lot of impacts on me. But I don't know that I would have done anything, either civilly or criminally about it, even if I could have, because that's another whole bag of worms. But it was a family member and I was a child and I could not possibly have done anything about it when it happened, or really, frankly, for 10 or 15 years after it happened. I'm not even sure I could do anything about it now, aside from the fact that the perpetrator is dead. But I mean, the reality is that for many, many years, I dealt with this. I don't talk about it much because people who are prone to think about me and my sexuality in a way that's doesn't fit me, I think that's why I'm a lesbian, is because I got sexually abused as a child. I don't believe that's the reason, but I know that some would jump to that conclusion. So I try not to give them the opportunity to do that, because then it's hurtful to me now. But I know for sure that it is almost impossible not to push this kind of experience back in your psyche and in your brain, and try not to think about it, never mind talk about it. So there was no way in God's green acres that I could have done anything at the age of 10. Maybe I could have at the age of 25, but I don't think so. But the reality is, many of the cases that I have interacted with victims about were way more horrible than mine, way more impactful than mine, although mine was pretty damn impactful on me. So I don't know how you draw those lines. And I think that it's really hard for victims not to know whether or not there ever will be any ability for them to deal. So I'm in favor of both of these bills. My preference is probably to leave it more open than 2.5 years after enactment, but I could live with that if I had to. because it's not going to impact me personally, but it is going to impact other people. And I hope that we can send the kind of message that we need to. And I know legislation's not designed to send messages, but the reality is, if we don't do something with one of these bills, I think it says something about how seriously we take this crime, because it is a crime. So I'll be quiet now, but which I do a little more successfully than Representative Babbage, but not always. Thank you.
Thank you, Representative Reckitt. Other committee members, are there other contributions to the conversation? Representative Harnett? And could you begin by introducing yourself, Representative Harnett?
I will.
Thanks for
Thank you,
joining us.
Madam Chair, and to the committee and others. It's not as if I showed up late to work today. I was in another committee all day long and just got out at 5:15. So I'm sorry that I missed most of today's discussion. And my question is for Chief Deputy Taub. When you were talking about the two different bills, one with the window and one with the unlimited period of time, and you said that the bill with the window is probably more defensible. Is there a way to quantify that, or is it just that it's a smaller period of time? So weighing that as opposed to a forever makes it more defensible in your mind?
Yeah, I can't quantify it. It's just that a limited period of time is more defensible than an unlimited period of time. If the window was 5 years, that would be more defensible than unlimited. There's no like real bright line. It's just that I think a court, because ultimately due process is about fairness. I mean, that's really what it comes down to. And so I think the idea that we are going to revive claims, but we're going to give people a limited time, whether it's 2 or 5 or 8 years, I think court would feel more comfortable with that than if it's unlimited. But again, I want to be clear that both of these bills are defensible. And when we say defensible, it just means that if they were challenged, we think that we could make credible, solid arguments that the statutes are constitutional. So I'm just really talking about which one would have maybe a slightly better chance of winning than the other one.
Thank you. May I have a quick follow-up, Senator Carney?
Yes.
And in that they both revive claims. They both revive extinguished claims. So they're going to be subject to that challenge. It's just perhaps the amount of impact because of the length of time as opposed to having no end. So,
correct.
Okay. Thank you. And nice to see you.
Representative Harnett.
Committee members, are there other questions? At this point, I'd really like to invite both of the sponsors of these two bills to speak with us. Although I also see Representative Libby, you're okay to wait? Okay. Yeah, so Representative Gramlich, did you wish to just briefly share with us your perspective, having heard this discussion? And Representative Brennan, will turn to you in just a moment.
Thank you, Senator Carney, and thank you to my colleagues on the Judiciary Committee. And Mr. Taub, thank you for your analysis in addition to what Peggy provided. I know the way 589 is crafted, it does offer that window, which Mr. Taub identified as being more defensible, although I would agree that both bills are defensible. I guess if I had my druthers, I would have an unlimited period of time for which a survivor can come forward, because as I identified in my testimony, the developmental milestones that survivors process are variable from survivor to survivor. And so there's no really set time frame when one feels that she or he may be safe in coming forward and sharing their very personal story for all the reasons that you are all well aware of. I really think it's important that we maintain the educational component that is identified in 589. I think it's really critically important that we offer the judicial branch all the education they can get about this very difficult topic.
It's a topic that, as I mentioned in my testimony, it's a very taboo topic that people don't generally talk about. And I think it's really critically important that we offer multiple opportunities to educate folks, particularly, quite frankly, people who are in positions of power, to make decisions about the implications that this issue has on, quite frankly, survivors' lives. So I think I'll stop now because this is a little bit of an emotionally charged conversation for me. And I'll pass this over to my colleague, Representative Brennan.
Thank you very much, Representative Gramlich. Representative Brennan, good afternoon.
Thank you. Thank you, Senator Carney and Representative Harnett. And I truly have to say, my breath was taken away by both Representative Rickett and Representative Gramlich. And thank you very much for your courage and your comments. They're deeply appreciated. I will add, I had the opportunity to meet with Mr. Taub after I had the bill had been drafted. And I would not pretend to have anywhere near the legal expertise that people on this committee have, but I did understand what he said. And I did understand the issue about revived cases. I understood the potential constitutional challenges because he did such a great job of explaining it as he did to this committee. But I felt an obligation to come forward with a bill and with language that didn't leave anybody out, which that's what we've done in the past. With statute of limitations and having just a look back that have a limit of time, people get left out. And I think if you listen to the testimony of people that came forward, you've listened to Representative Rickett and Representative Gramlich, we shouldn't be leaving anybody out again. And so the language that I put forward does not leave anybody out. And I think given the comments Mr. Taub had about the constitutionality of it, Massachusetts has ruled favorably. Vermont has passed similar legislation and that has not been challenged. I just feel an obligation that we as a state should not leave anybody out and move forward with this bill. And if we have to deal with constitutional issues going forward, we will. So thank you very much. And thanks for your thoughtful consideration. And that clearly was my thinking behind bringing a bill to you that just had 40 words in one sentence.
Thank you very much, Representative Brennan. Committee members, are there any? Oh, there are some questions. Go ahead, Representative Moriarty.
Thank you, Madam Chair. I had a question for Peggy. You began your remarks, Peggy, by saying that the statute of limitations is unlimited now. What was the effective date of the expiration of, or the taking away of the statute of limitations?
The effective date was August 11th, 2000. Before that, the statute of limitations was 12 years, which was enacted in 1991. In 1991, the legislature moved it from 6 years to 12 years. And that's when we first had an application section that said, this applies going forward, all actions for which the claim has not yet been barred by the previous statute of limitations. So that was 1991. And that's probably what you need to know. So it was 2000 that no statute of limitations at all applied. And the legislature very much around that time also enacted, did away with the criminal statute of limitations.
So if there was an act in 1986, a sexual assault, that would still have been viable at the time of the 1991 amendment, extending, you're shaking your head.
I'm thinking not. 1986, then yes, it would be. Why am I? Yeah, that's right.
So basically, and I'm not trying to make a big deal of this, but any offense committed from roughly, well, from 1986 forward has no statute of limitations.
I know there's a date and that might be it.
When you bootstrap all those changes onto each other in the meantime.
Right, as long as it didn't, that the extended statute of limitation, it still fell under the extended statute of limitations when we extended it again.
Right, right. Okay, that just helps me see the broader picture more clearly. Thank you.
So, Representative Moriarty, is the point you're making that opening up, reviving claims would really only apply to claims that predated 1986? Is that what you think is the impact of this?
Yes, that's one point, but then I guess we would also want to consider the window model versus the unlimited model, going back to claims that are that old, and issues in terms of perpetrators having died, evidence having been destroyed, potential challenges to credibility and memory and so forth when you go back that number of decades. But so anyway, it just helps me put the whole thing into a better perspective.
Mr. Top, could I ask you, looking at it from that perspective, that really we're talking about conduct that predated 1986, does that kind of lens, does that impact your opinion at all about constitutional defensibility for an unlimited versus a window of opportunity to bring revived claims?
So I think, are you asking that because this statute would really only sweep in claims that are older than 1986? Is that going to be a fact? Yeah. I mean, that's certainly something I think that the court would look at, that because it's going to be sweeping in claims that, I don't want to use the word stale, but just the idea that it's going to sweep in claims that are pretty old. And so defendants might have some compelling arguments that it's really difficult for them to defend against those claims. I think that's a factor the court would consider. Does that answer your question, Senator? I don't know if I did or not.
It does, although, I mean, in light of that, which is more likely to survive a constitutional challenge, a window versus unlimited?
Well, so I might be confused, because I think if you're going to retroactively revive expired claims, I think that necessarily means that you're only going to be reviving claims that are going to be older than the 1986 or whatever the cutoff date is. So I don't think there's any way to really to fix that. I suppose unless you wanted to revive claims that are only up to a certain point, like maybe you could revive claims that accrued from 1980 on or something like that. But in terms of like the window issue, the way I was thinking of the window, and maybe we're using window in two different ways, but I was thinking of the window as being like the window of time within which you would have to bring your expired claim. And so
That's
do
how
think-
I was thinking
Okay,
about
yeah.
it. Wow.
And so I do think that having a window is going to be a factor that will cut in favor of the statute being upheld, because you are putting an endpoint on the claim. So you're saying, yes, we're going to revive the claim, but you've got to move pretty quickly if you want to actually bring this revived claim. And if you don't do it within 2.5 years, then it's too late. So I think that would be a factor.
Thank you.
And I think there is another state. I think Delaware took the 2-year window approach. I could be wrong, but I think it was Delaware that used that approach, and I believe that was upheld. But I can track that down for sure if that's something that the committee would find helpful.
Yeah, that would be helpful. Thank you. Representative Thorne?
Chair, I'll leave it to the legal minds to present compelling evidence and theories on the legal aspect or implications of it, but I'm just listening to what I heard today from Representative Galgay-Reckitt and a little bit about Representative Moriarty's comments about the vagueness and going back and circumstantial evidence of the way back prosecution attempts, and I can almost see victims being victims twice by attempting to bring somebody to justice, but with nothing more than hearsay and nothing more than circumstantial evidence. And unless there was a perpetrator that wanted to clear their conscience at an old age and admitting it, I don't know what closure it brings. And in fact, most cases, I think it's just going to open up more wounds. But again, just expressing my thoughts and views. Thank you.
Committee members, are there other comments or contributions to the discussion on this legislation? Go ahead, Representative Harnett.
Thank you. I just wanted to respond, if I could, to Representative Thorne's question. There's nothing in this statute that requires a person to bring a claim. It would be the choice of the individual who had been harmed. So if that's something that survivor chooses to do, that's their call. That's all we're giving them, is that the ability to make that decision. And I'm maybe being hyper technical here, but I don't want to use terms like prosecute, because again, we're not talking about a criminal matter. We're not talking about a state prosecuting a defendant in a criminal matter. We're talking about somebody bringing private civil action.
Representative Harnett, the internet connectivity was a little bit poor. Can you just repeat your last sentence? Thank you.
Was it on the prosecution aspect?
You were just talking about that, and I think we just missed your concluding statement about that.
I was not trying to be too precise on words, but I wanted to remember that we're talking about a civil action here. We're not prosecuting a crime against somebody in criminal court. This would give the ability of a survivor to bring an action for civil damages, if that is what they choose to do. That come across better?
We could hear you. Thank you.
But it might not have been better, just we could hear me. That's okay.
Thank you for that clarification, Representative Harnett.
You're very welcome, sir.
Yeah, and I didn't mean to imply that it wasn't. It was just the concern was making sure everybody heard you. But thanks for repeating it. Representative Reckitt.
Thank you. I would like to suggest that whichever of these bills we put forward for a vote, that we amend it if necessary to include the portion from Representative Gramlich's bill that deals with judicial education. So whether or not so I guess I'm sort of proposing an amendment for both bill, for one bill, and acknowledging that I think that's a very valuable part of Representative Gramlich's bill that we ought not to forget if we choose Brennan's bill because of the time constraints that we may or may not think shore up its constitutionality. So I suppose it's
Thank
not the
you.
moment to do that, but that's my intent or wish.
Thank you, Representative Reckitt. And I just did want to note for committee members that we actually have amendments to two different types of tort claim statute of limitations. One is under the Maine Tort Claims Act, which Representative Harnett is are you waving your finger at me? And okay.
I'm counting people, I'm sorry.
Okay. The Maine Tort Claims Act, which is applies to claims against government entities and government actors. And that's Representative Gramlich's bill. And then Representative Brennan's bill is the statute of limitations that applies outside of the context of government entities. In Maine and many places, government entities have absolute immunity unless there's an exception. And so it's important, I think, for us to actually address both of those arenas, both the government related claims and the claims between non-government entities, private citizens, and in other settings. And so I'm not looking at this personally as an either or. That being said, I did want to ask Representative Brennan, we've heard some reflections on the difference in strength of constitutional argument when you apply a limited time for individuals who have revived claims to bring them, and was wondering if you could share with us your reflections on whether, given that it might be a little bit more defensible, would you request that addition to your bill, or would you be amenable to it? And then similarly, Representative Gramlich, if you can comment on how you feel about that provision in your bill, given what we've learned from Mr. Taub. Go ahead, Representative Brennan.
Yeah, well, Senator Carney, thank you for the question. And again, I understand that the choices before the committee, I understand what Mr. Taub had said. And I just have to go back and kind of reiterate what I said before, that given the choice of leaving a group of people out, or people that have legitimate claims out versus testing the constitutionality, I prefer to test the constitutionality than to leave people out at this point. And I know it may be a more cautious approach to be talking about having a window as opposed to eliminating the limitations together. But I think at this point, and I think Representative Moriarty already pointed out, there have been a number of people that have already been included in the previous efforts on statute of limitations. And I think this is the final effort. And I think this is the final step that we need to take as a legislature and as a state. So I'm always willing to compromise, and I'm always willing to look at the best way forward. But I do think the best way forward at this point is for us to ensure that if we're going to eliminate statute of limitations, that we include everybody. I also agree that with Representative Gramlich's bill, if we can do educational initiatives with judiciary, that would be helpful. I would not suggest how the committee might want to do or not do, but it also could be possible to pass two bills and preserve some of the elements of Representative Gramlich's as well as what's in 688. But at the same time, that's a committee decision. And I will certainly rely on the best judgment and wisdom of the committee.
Thank you very much. And Representative Gramlich, can you share with us your thoughts about continuing to have the window for the revived claims versus having an unlimited time to bring revived claims?
Thank you, Senator Carney. As I think I articulated earlier, and also when I presented my testimony on the 17th of March, while my bill was crafted to include that window, I do believe that we need to have an unlimited period of time for which one can come forward. And and I'm going to use some terminology. I'm not a victim. I'm a survivor. And it would be my choice as to whether or not I wanted to come forward for justice in terms of my recovery. And it has been over 45 years. And this is the first time, other than my testimony, that I've spoken publicly about what happened to me. And it's quite frankly empowering, even though it's difficult. And so I appreciate that opportunity. I know my bill identifies government entities where Representative Brennan's bill is much more universal. That's where I'm inclined to lean. I think that, and I know that survivors, as I've said earlier, have varying levels of comfort in which they might want to come forward to seek justice. And we need to provide those individuals every opportunity that they have. And I'd much rather challenge the constitutionality in court so that folks have that opportunity. And again, I think it's really critical that we maintain the educational component for the judicial branch. And I guess I'd leave it to you all on the committee to tackle the government entities piece, because I can see how that can become a little bit more of a thornier issue. Perhaps that's why 589 is crafted with that kind of a carve out. So, I mean, I think I'm just going to speak really candidly. Abuse is abuse all day long, regardless of who's perpetrating it. And that's what I believe and know to be true. But I think when we get into some of the thornier issues from the legal perspective, I could see the courts looking at it a little bit differently in terms of government entities versus individuals. So I don't know if I necessarily answered your question, Senator Carney, but I just think that we need to afford individuals every opportunity they can if they choose to want to come forward. I mean, I can't remember who asked, I think it might have been Representative Thorne, had asked a question about other states. And what prompted me to consider presenting this legislation. I was actually going to present it during the 129th as an after deadline bill, because I had learned that New York State had enacted similar legislation with a window whereby individuals over 55 years of age who had endured sexual abuse would have a window of opportunity whereby they could come forward. And having hailed originally from New York State, I can't tell you the joy that brought me, even though my perpetrator has been deceased, because it's an opportunity for justice. So we do have other states that have given windows of opportunity for folks to come forward. But again, I think that we need to really examine this through the lens of individual survivors, all of whom have varying levels of comfort and readiness to come forward with their claims.
Thank you very much. Committee members, I'm sensing that there's not a lot more discussion or questions, except that I see my wonderful colleague, Representative Harnett, raising his hand. Go ahead, Representative Harnett.
Thank you. This is a question for Peggy. In Representative Gramlich's bill, she proposed an amendment to Title 14-8107, which is a modification or an amendment to the main Tort Claims Act, whereas Representative Brennan's bill just changes the statute of limitations section and doesn't impact the Tort Claims Act as I would see it. So if we went with, and I'm going to propose something that has a little bit of both, I think, but if we went with Representative Brennan's bill and part of Representative Gramlich's bill, but did not include the amendment to 14-8107, this would not impact governmental entities. Is that correct?
I believe that's correct.
Thank you.
Representative Harnett, I just want to ask you, is it your belief that the action we take on this issue should not revive claims against government entities?
I guess that's more of a question for Representative Gramlich as she had proposed it. And I'm wondering what her comfort level would be with removing that section, because it would preclude some claims that occurred before 1986.
Is that a question for me?
Yes.
Okay. Thank you. I wasn't sure where you were going with it. You know, it's a difficult question because I know we all understand that children can be victimized. You're a government entity. We've seen it. We've heard about it over the years in the news. Certainly that wasn't my experience, but I think about the children who have fallen victim to the hands of folks within a school system, folks within their day camps or their churches. I mean, there's a whole list of organizations or entities that would fall under government entities. I mean, I guess I would suppose that would mean that a survivor could have a claim against that entity. And it's difficult for me to speak about that only because I don't have that frame of reference. Because regardless of whether an individual is with a government entity or not, it's still an individual or individuals who perpetrated the crime. So I think that if we were able to hold the individual accountable, I mean, I think that's a step in the right direction. But again, I would leave it to you all, being the committee of jurisdiction, sorry, I'm passing the hot potato back to you, Representative Harnett, in terms of kind of digging through that. I guess I would not want to do anything where we've gotten this far between my bill and Representative Brennan's bill. I wouldn't want to do anything that would inhibit individuals or marginalize any group or any population moving forward.
Thank you. Could I pose a similar question to Representative Brennan? Hello?
We can hear you. I think you're coming through.
Oh, you can. Okay, thank you. I'd like to pose a related question to Representative Brennan, if I could. Representative Brennan, one of the goals in your bill was to not leave anybody out. Are you concerned that we're leaving people out if we do not amend the main Tort Claims Act?
Well, I'm not as familiar with that aspect of what is in and out. And again, I just have to say what I've said before is I drafted the bill to try to be as inclusive as possible. I don't know if this helps at all, Representative Harnett, but I'd be perfectly happy if you felt comfortable with taking the language of 688 and putting it in 589. I think there was another part, probably the there's one other part. There's probably going to be a fiscal note with Representative Gramlich's bill because of judicial training. But I think we can work with that going forward in terms of trying to deal with the fiscal note and preserve the language if we needed to at some point. But if you're suggesting the language in Representative Gramlich's bill, I'd have to say I think what's in 688 is more preferable. But I'd be totally comfortable taking the language in 688 and putting it in 589 and keeping some of the other aspects that are in Representative Gramlich's bill.
Thank you.
Thank you very much, Representative Brennan and Representative Harnett and Representative Gramlich. Peggy, I had a question for you, which is the current status of the Maine Tort Claims Act for claims involving sexual abuse of a minor. What is the status of that? Are claims that would have to be brought under the Maine Tort Claims Act currently not subject to a statute of limitations going forward?
So, and maybe Mr. Taub is better at answering this. My understanding is the Tort Claims Act, provides immunity for governmental entities and then says, here's some exceptions. And the exceptions are really kind of building, vehicles. And then in addition to the waiver, there is that waiver for buildings and roads, and there's immunity notwithstanding the waiver for undertaking a legislative act, undertaking a judicial act, performing discretionary function, performing prosecutorial function. I mean, I don't think sexual abuse would ever come under the description of things where there is immunity. That would never be within the scope of someone's employment as a governmental employee. So I would think that, I don't know.
Yeah, that's really helpful to me to understand that framework. Let's ask if maybe Mr. Taub could weigh in as well.
Yeah, so is the question the extent to which governmental entities would be immune from sexual abuse claims?
Right now, yeah,
Right
under
now.
current law.
Yeah, so I agree with Peggy that, and just to be clear, there's sort of two separate immunities. There's the immunity of the actual entity itself, like the state or the municipality, and then there's the immunity of the individual employee. But when it comes to the entity, as Peggy said, there are only 4 or 5 very sort of specific exceptions, like operation of a motor vehicle, maintenance of a public building. And so, it's not to say that someone couldn't come up with a creative argument, but I think under current law, it would be fairly difficult to overcome the governmental entity's immunity, bringing a sexual abuse claim.
And what about the individual immunity?
Yeah, I mean, so as Peggy said, I think, and we've never, as far as I know, we've never had at least I've never been involved in the litigation of a sexual abuse claim under the Tort Claims Act, but a lot of the sort of exceptions and coverage apply to employees who are acting within the course and scope of their employment. And so, and I think Peggy said this as well, which is, I think it'd be difficult for an employee to claim immunity for something that is so far outside, the course and scope of their employment, that's actually a criminal act. So I think it would be difficult for there to be immunity in that situation. But again, it's not to say there was not some argument, but I think it would be difficult.
Thank you both. That's because I was always kind of functioning under the assumption that we had to address both. And I think with your combined explanations, yeah, it seems like I'm worrying about something that I shouldn't be concerned about. And I'm really grateful to both of you for helping me understand that. Representative Reckitt?
I have two things. One is I think that I could be convinced that we should have a window. I just think 2.5 years is a little small. So I would rather have a 5-year window, for instance, than a 2.5-year window. Frankly, I'd probably rather have 10, but I'd go with 5 if I had to. But the other piece of this is on the government entity piece. One of the other, I can't even know what they are in my things in my past, is I served for 5 years on the Baxter Compensation Authority that was set up by the legislature to bring fiscal remuneration to victims of abuse and sexual abuse on Baxter School for the deaf. It was a horrendous tale. And I'm telling you, that entity was criminally liable, although they weren't. And not to mention the victims couldn't, some of the worst victims could not come forward, literally. So I think there are, and in my head, that government entity was guilty. But, I understand what you're saying about government entities, but so I'm glad that is for Maine, but not for the rest of the deaf schools in this country. I'm certain a settled thing. So my suggestion, I guess, is that, my suggestion is that we open up the window a little broader than 2.5 years. So that's my personal feeling.
Thank you, Representative Rackett. Is there a committee member who is ready to make a motion on? Let's take these in order. Let's start with LD 589. Is there a committee member who's prepared to make a motion on LD 589? Representative Thorne?
Thank you, Madam Chair. I didn't want to make a motion, but I just wanted to express my gratitude for, it's nice to see that we can finally have a bill that we can slow down and ask all the questions that we need to ask and not be rushed through them or reminded how much work we have to do, because this was refreshing to see the open and honest discussion back and forth for an extended period of time tonight on this bill. And it would be nice if we could approach every bill like this without being reminded of how much work we have to do and how we must rush through these bills. So I just wanted to express that before somebody made a motion. Thank you.
Thank you, Representative Thorne. Committee members, does anyone have a motion? Representative Harnett?
And I'm not sure how to phrase this. I'm sure Peggy can correct me if I miss it, but what I want to move is, I want to move LD 688, if it can be amended to include the unallocated language from Representative Gramlich's bill regarding prioritization of cases and judicial training, the court training aspects. I'm concerned about the implications of amending the notice requirement under the Maine Tort Claims Act and also waiving the 2-year statute of limitations that exists under that, primarily because of a fiscal note that could occur, knowing that we could still, that a survivor could still bring a claim against the individual. It would not address the concerns of Representative Rackett when she felt the governmental entity was itself culpable in conduct, but I'm trying to figure out what is the smoothest way to get something passed, and I worry about implicating the Tort Claims Act. So am I making sense, Peggy?
Yes, you want the, you don't need a window. You don't want a window.
I'm moving that we try to be as inclusive as we can to everybody who has survived such an episode in their life. And,
so
and wants to address it.
So I think what you're talking about doing is amending 589 to strike out section 1, section 2, section 3, move whatever's in 688, section 1 and 2 there into 589 and keep section 4 and 5.
I think that's right. I was doing it the other way, but I think it's easier to.
Oh, I'm sorry. I thought we were talking about LD 680, I mean 589. Now I'm
No,
mixing the numbers up.
I
However
jumped
you
on.
want to do it, you want to combine, you want to merge.
I want to merge them, but take out the amendments to the Tort Claims Act, if both sponsors would be amenable to that. It addresses Representative Brennan's concerns regarding time, and I believe is the not having a window is more palatable to Representative Gramlich, but keeps in the training and the prioritization of cases. So that would be my motion unless I hear a strenuous objection from either of the bill sponsors.
Can I just raise one concern? When the judicial branch testified neither for nor against, they were appreciative of the suggestion regarding education. They felt like they were already able to handle the priority scheduling without it having to be incorporated into the language of the bill. So I just offer that.
I remember that testimony, and in light of that, I would delete section 4 then as well from 589.
And I think that makes sense because that is sort of tied to the window, the fact that there was only a limited amount of time for those cases. So as long as you're talking about the judicial branch's testimony, we usually don't pass legislation directing the judicial branch to do something kind of internally, but write a letter recommending. I mean, even with the like veterans treatment courts, you ended up writing a letter that says, you know, please expand these to more locations. And I just wonder if that is something you want to proceed with for the education piece as well.
Would, looking at the bill sponsors, would, in light of the judicial department's acknowledgement that they would do the education, is that procedure acceptable to you?
I presume you're directing that more pointedly at me, Senator Carney.
Fine with me.
Well, certainly, but I mean, I know this committee works more with the judicial branch. A lot of the committees I've worked in deal with other branches and other entities. Perhaps in addition to a letter, presumably the judicial branch gives some sort of report back. I'd like there to be some sort of opportunity so that we in the legislature can be assured that this is actually occurring.
Yeah, I think we can accomplish that with a letter. The distinction with the judiciary is that it's a co-equal branch of government. That's a little different. Great, thank you.
Thank you.
Representative Moriarty, you have your hand up.
Yes, I'll second the motion, but I want to ask, by virtue of the complexity of the issue and of combining the two bills, how much can we do in language review? Is it strictly limited to tweaking the language, or can we get into substance, as with, for example, mandating training, or in some more polite fashion, suggesting training? Or should we take a look at a draft before we pass a motion?
I think we can go either way. Peggy, I'm sorry, I cut you off. You were about
No. It's for you to decide how your committee works.
I think we can go either way, Representative Moriarty. That's a good suggestion to raise. I think what we're working with though is actually pretty simple. It's section 1 from LD 688. And then
I
and
think
then
you've
and
actually
then
taken everything else out of 589.
yeah, and then a letter that we would separately write with regard to training and requesting a report back. But we could, I mean, we could on language review certainly reopen a bill and have another work session on it. If
Okay.
it was the desire of the committee.
So if I may, my take on language review is to give you the final look at language to make sure I got it right. And if you decide in looking at it that I didn't do it right, you give me a chance to fix it. If you look at it and say, oh, well, now we realize that there's another issue, you can always vote to reconsider and change everything. Until the bill is out of committee, you can always vote to reconsider, change the language, change the votes. I know that slows things down, and I'm sure that the chairs are saying, oh, don't let them know that that's an opportunity. But I mean, that's how the committee can get its work done the way it wants it done, is reconsider if, especially if the drafting process identifies issues that we weren't really thinking about in the work session. And that's why Senator Keim was saying, look, if we get to the point where if you bring back the draft for this divided report and I like it and I have the information I needed, I might change my vote. So she would ask you to reconsider so she could change her vote. And I think that happens on a regular basis, which is great, which to me means you're really paying attention to language review. And I appreciate that. But if we could get back to the motion that was made on this bill, we were talking about taking out section 1 and section 2 and section 3 and adding in the contents from LD 688. But then you went on to take out section 4 because it was related to the window, and section 5, we're going to turn that into a letter. I think what you're getting to is the only real substance you need is portrayed in section 1 and section 2 of LD 688. So I realize the sponsors they don't need any, they're not looking for, their own glory in this, but you can figure out how you want to go forward with this. But I think what you're using is the text of 688.
Yeah, and I actually think that was Representative Harnet's motion, I think. Can you clarify that, Tom?
I wish that I could.
I'm not sure that it was ever second, so you can do whatever you want.
Steve had seconded, so he understood what I was moving. I was originally moving the language from 688 into 589, but then as we took everything out, I understand Peggy's point. But since we are going to follow up on the language regarding training, et cetera, in a letter to the court, is there anything wrong with using 589 as the vehicle?
No, I don't think so. I just think that the motion ought to be as clear as we can make it tonight. Which one are we dealing with and which one are we moving forward with? And just as a slight digression on the education piece, I think we can write Julie Finn and find out what is the curriculum for judicial education, and do you in fact train on these topics from time to time, if not annually? And we all in the legislature go through annual training on harassment issues, and I wonder if the judges don't do something similar. But anyway, we can find that out in the meantime.
Yeah, she did reassure us that they were ready, willing, and able to incorporate it into their annual.
I can't imagine they wouldn't.
Yeah, yeah.
So right. I guess I'm seconding a motion which is ought to pass on LD 589 which will include the language from 688 and maintain the trial scheduling priority and the judicial training components. And Peggy saying no.
No, we're going to do that in a letter. If we use 589 as the vehicle.
Well, again, I thought under language review, we might just delete it completely.
Okay.
But if that's properly done within the scope of language review.
Peggy, is that properly done within the scope of language review, or should we agree at this point to do the letter?
I guess from a drafting perspective, I would prefer that you make that decision now. I mean, you can always undo it. You can always, if you think you're going to go with a letter, and give me an opportunity to help you draft that letter, and we can bring it back for language review at the same time that you're looking at the language review, which is, I think you already know what that language is, but we can look at it. I would prefer that you, just from a drafting perspective, not from a policy perspective, that you identify what you want in the amendment now, if that makes sense.
Mm-hmm.
So should I restate where I think we are? Which is that we are going to amend 589 to strike the text of the legislation and replace it with sections 1 and 2 of 688. Is that the wish of the Tom?
That is.
Was that your motion?
That is. Thank you.
Okay. And that was seconded by Representative Moriarty. And so the pending motion is ought to pass as amended on LD 589. And I see that Ms. Panett has joined us. Is there any more discussion? Is the committee ready for the vote? All right. And I'm just going to move the bill sponsors back to attendee status while we vote. And Mr. Taub as well, thank you very much for your help today. All right, Ms. Panett, I think we're ready for the vote.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell. I'll call the absent. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Poirier. Representative Poirier is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. I have 6 members voting in the affirmative, 1 member voting in the negative, and 7 members are absent. That is the vote of the committee.
Thank you very much. And I am not going to forget at this point. Representative Thorne, can you please tell us what your report on the bill would be? Is it an ought not to pass?
Ought not to pass.
Thank you. And so the vote of the committee is 6 in favor, 1 opposed, and 7 absences. And with that, we conclude the work session on LD 589 and move on to LD 688. And is there a motion? Representative Moriarty,
Move ought not to pass.
is there a second? Representative Sheehan? Any discussion on the motion? Is the committee ready for the vote? Looks like we are. Thanks, Ms. Panett.
Thank you. Senator Carney.
Yay.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Representative Newell, I'll call the absence. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Poirier. Representative Poirier is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 7 members voting in the affirmative, 0 in the negative, and 7 are absent.
Thank you very much, Ms. Panett. And with that, that concludes the work session on LD 688, and it includes our very long day of committee work. Thank you, everyone, for all your hard work and for hanging in there today as we did work sessions on so many bills. And with that, I'll entertain a motion to adjourn.
I'll make
So
a motion.
move.
Thank you very much, Representative Thorne, and see everybody on Thursday morning. Thank you.
Okay. Good night, all.
Good night.
Night.
Thank you.
Thank you.